case. This is my personal difficulty because at 12 noon, my lord, before the DB3, your case is pending, my lord.
All right, you send somebody. You send somebody.
It is my honor. It is my honor's request, my lord, that it may be kept at 1 p.m. my lord.
12:15. Yes.
Obliged.
Any adjournment for serial number 39 or 40? Any adjournment between serial number 41 to 46? Under the heading for orders on petition serial number 1, the managing director Hindustan Antibiotic Limited versus the Union of India for the Indian Street, Amitabh.
Lord, in this case, the LPA which has been filed, my lord, is accompanied by a limitation petition, and which is numbered as, my lord, IA 1 of 19, my lord. It was filed in the year 19, my lord, against the order of the Honorable Single Judge, my lord, by which the review petition was rejected on 22/10/19. My lord, the period of limitation, my lord, is, my lord, limitation is by 14 days.
All right. Heard IA for condonation of delay in filing LPA for the reason stated in the application and affidavit, and the fact that the delay is only 14 days. Accordingly, condone. Main matter.
Now, my lord, we have also filed a stay application. Probably I have looked into.
First of all, what is the main matter? In order to consider your
The main matter is, my lord, with regard to the order of dismissal.
has not been challenged.
Against the respondent number 2, my lord. He was dismissed from service, my lord, which was challenged before this honorable court.
Where is the challenge to the original order passed in CWJC?
The original order, my lord. That is, my lord.
No, in your prayer you are not challenged that order.
That ought to have been, my lord. I have challenged the order of, my lord, the review application.
Can you?
My lord,
You have to challenge both the orders.
I quite agree, my lord. It ought to have been filed, my lord. Kindly,
What is to be done? We have to reject or what?
my lord, I'll file a supplementary affidavit.
No question of supplementary.
Lord.
We don't believe in supplementary business. We'll give liberty. You file fresh. Yes, take down.
Lordship, only one thing which I wanted to point out to your lordship, my lord, if it finds favor with your lordship, my lord.
No, when there is a defect in the LPA itself, there is a question of favorable and other.
No, I'm just telling you, lordship, the contempt, my lord, the honorable single judge, my lord, in a contempt application is moving with the contempt application. It is rightly moving, my lord.
All right,
I don't have any objection to that, my lord. We have already paid, my lord, about 22 lakhs and odd.
we are not concerned with that. We are concerned with the defect in the LPA.
Acha, theek hai.
Yes, take down.
Theek hai, ji.
The present.
Kindly give me the liberty, your lordship.
Original order passed in CWJC. On the other hand, what is challenge is order passed in civil review 69 of 2019. To stop in the absence of challenge to the order passed in CWJC 534534 of 2001. The present LPA is not maintainable. Accordingly, LPA stands dismissed, reserving liberty to file fresh LPA.
Serial number 2, Bihar State Food versus Ravi Kishore Sahai for the Clean and Street challenge to passing.
Limitation or limitation delay my lord 16 month my lord. 16 month my lord. It is a dismissal order my lord, and the disciplinary authority my lord already followed the all procedure my lord. Honorable single judge passed the order and set aside the impugned order with direction to pay entire retirement benefit and area sales to the petitioners my lord. Set aside on technical point my lord. On the ground, the witnesses is not examined. One witnesses is not examined as per submission by the petitioners, my lord.
What is the charge?
Charge dismissal of service, my lord, and dismissal of service, my lord.
Sir, what is the charge? I am asking you, not penalty.
Charge.
Charge. What is the charge?
Today, my lord, did application counterfeit not, but that is available me, my lord, due to earlier counsel, my lord, Mr.
Mr. Counsel, we want to examine whether is it a case for remand or not. What is the charge? Is it charge relating to misappropriation?
Charge is, my lord, the petitioner is a assistant godown manager and defalcation of huge quantity of food grain, my lord, and also participate in a black marketing.
Issue notice to the contesting respondent. Sole respondent Ravi Kishore Sai. Necessary requisites shall be paid within a period of 1 week.
2 weeks, my lord.
2 weeks. To notice main matter as well as IA for condemnation of delay.
Then,
Normally, single judge order. Correct, but we can't set aside and close them. Allocation of money is there. Supreme Court. At least in the light of Supreme Court decision, ND's Constitution Bench decision, thereafter whole India is there. And technical ground, the penalty order, matter is funded. These are that's fundamental. Another issue like that, then such matters question and person who has retired. Such matters, you know.
both process, my lord.
Both process.
Serial number 3, the state of Bihar versus Gaurav, for the appeal Shri Kumar.
Lordships, there is a delay of 110 days in preparing present memo of appeal. An IA to that effect has been filed on 13th of January 2023.
Why the respondent is not entitled to compassionate appointment or compensation?
That is not compassionate appointment, Your Lordships. It is appointment. It is appointment. It is appointment to the post
Compensate.
for which he is not possessing requisite qualification, Your Lordships.
Wrongly.
Not in mechanical.
Got it correct. You have no objection for
Condemnation, my lord, they have explained that it was primarily owing to the file movement, my lord, that the delay took place.
No, as usual, they are state.
Takes a lot of time, my lord, seeking this opinion, that opinion, and after that, my lord, they have done it.
How many days delay?
110 days, Your Lordships.
It's taken. Heard. Yes. 1 of 2 for compensation of delay in filing LP for the reason stated in the application. Main matter.
A date may be fixed for addressing on the main matter.
My lord, we have been running as in it's the appointments
Monday,
were way back, my lord.
Appointment order issued.
Well, we had also been recommended. They did not appoint us, my lord.
He is asking for 1 week.
Only on Monday, Your Lordships.
One next week.
I will apply.
All right.
If any records are required to be examined in that event, you have to bring the records.
I will.
On that ground, we can't adjourn the matter.
I will.
Detailed affidavits had already been filed, my lord, so most of the documents are already there on record. So that's how it is. Obliged.
Serial number 4, the state of Bihar versus Manjay Kumar, for the appeal Mohammed Shah.
This is filing counter affidavit.
Delay?
Counter affidavit. Supplementary petition, sorry.
What is the delay?
Today, my lord, 100, my lord. My lord, I have filed, my lord, petition, my lord. Hariyana.
Number of days delay is blank. We have to calculate and put. Take page number 2.
My lord.
It is blank. Why?
Sorry, my lord. Very sorry.
Why we should not reject?
Sorry, my lord.
We are also very sorry. Yes, so and so. 3 of 2022 relating to condonation of delay. In para 1, number of days is blank. Accordingly, IA stands rejected, reserving liberty to file fresh IA.
Connected case में one application have to adding the
In the connected matter also, you have blank.
In second case, my lord, 223 days delay is there, my lord. I have stated in this para 4.
Second case, please.
638. 638 में
646.
638 also give. After the state appeal, they will commit the same error.
In 638,
They don't refer.
646 I have stated.
Wait, one by one will go. 638. Delay is appearing for state.
Sir, we have already stated 204 days delay.
Where have you mentioned? In which paragraph?
Para number 4.
How many days delay?
204 days, my lord.
204.
Yes.
Who is on the other side?
My lord, I appear in LPA number 638 for the writ petition.
You have filed your counter.
My lord, I filed my counter affidavit. Although they have said that file was moving from one table to another, but my preliminary opposition to the IA is on the ground that the judgment says that the result has to be published district wise and not block wise. After the disposal of the impugned writ application, they have prepared merit list district wise citing the judgment impugned in at least 3 of the districts I have brought on record in the counter affidavit. So therefore,
No, that is on merit. Only condonation of delay. We will formally condone the delay and decide the matter on merit.
to that extent, they have said that files have been moving.
Heard IA 3 of IA 3 of 2000. Why IA 2 is showing pending? It is already disposed. Ask the concerned register why. IA heard IA 3 of 2022 for the reason stated in the application and affidavit. Delay in filing LPA stands condoned. Allowed. On merit ready. State.
My lord, Arvind Council is on leg.
Next week. What about 646?
Actually,
My lord, 223.
I humble my submission is that, my lord. The contract only come supplementary contract on all the record.
In which matter?
My lord, first, my lord, SP.
No, we are taking 646.
Actually-
Please understand.
I'm not saying, my lord.
Then don't interfere. Are you in 646? We are one by one we are taking.
In para 4 of the supplementary affidavit, my lord, by which the earlier IA file has been rectified, my lord. In that application, my lord, I have stated the delay of 223 days.
No, what is that IA number?
That IA number is 1, my lord.
No, IA is already allowed. Call the register. Why they are showing? The disposed IAs are being shown as if it is pending. Next week, 646 also. What is the
Ample submission, my lord.
no? Why this CWJC is linked?
It involves the same issue, and the Honorable Single Bench, when informed that LPAs are pending, it has been directed to be tagged with permission of Honorable the Chief Justice.
All right. What is that you want to mention?
My lord, I want to mention, my lord, I will be not here in next month, my lord. Next week, my lord, I am not here, my lord. Day after next, my lord. On 13th, my lord, it may.
No, your matter will be adjourned on the next week if you are not appearing and if you don't comply.
My lord, I will comply, my lord, by Monday, my lord, but I will be not, my lord, on that date, my lord. I request only on 13th, my lord.
All right, list this matter, all these matters on 13th.
My lord.
Although I do not oppose the time which has been taken, but in the two writ petitions which are listed, during the pendency they are taking time on all hearings, and they have made appointment in the interregnum also. Despite the reason that the case is covered by the judgment of the Honorable Single Judge.
Alright, it is made clear that no further time would be granted for the reasons that adjournment is formally opposed by the contesting respondent on the score that during pendency of the litigation, official respondents were stated to have official respondents have proceeded to appoint the subject matter of litigation. Appoint to the post, comma, which is the subject matter of litigation.
Obliged.
Connected writ application, my lord. One IA before lordship, my lord.
IA is for what?
To implement necessary petitioner as a party, my lord. Application being filed as implemented necessary party petitioner who has the same cause of action, my lord. Right, my lord.
You are an intervener.
My lord. In CWJC 9687.
Yes, IA 1 of 2023.
My.
Yes, respondents have no objection. Petitioner who is appearing for petitioner in CWJC 9687 of 2022.
First case, Mr. First case, Mr. Tangible.
Case taken heard IA 1 of 2023. None appears for the petitioner. IA 1 of 2023 is for intervener dash petitioner. Who is IA for the reasons stated in the application and affidavit. IA stands allowed with all exceptions. The petitioner is permitted to file his objections, if any, insofar as intervener petitioner to be brought on record at the time of final hearing.
My lord,
Respondent, I am the respondent.
Who is Chandrakant Indrashwari Prasad? You are. Then who is the original petitioner in 968?
968, original petitioner, we are, my lord.
Who has filed IA?
IA also filed, my lord. Another petitioner want to.
Sir, IA is filed by you only.
My lord.
Then how can there be any objection from you? What is this?
I have no. State has to party.
State to respondent.
All right, I will rectify the draft. The petitioner, original petitioner council intends to add new petitioner to the existing petitioner I will rectify the order sheet. Sir, you should properly plead, sir. What, sorry?
Serial number 5, Manju Kumari versus the State of Bihar for the appellants disclosure.
Your Lordship, this matter relates to the appointment from the post of Sika as a supervisor, Your Lordship. On the last occasion, Your Lordship has directed to bring on record a certain...
What is the delay?
That has been considered, Your Lordship. Your Lordship has on...
Court officer. So why disposed IA is being shown in the cost list? Simply dumping papers here without examining the previous order sheet. Yes, sir.
Your Lordship, the counter affidavit on behalf of the department as well as on behalf of the DPO is ready, but I could not file due to the technical glitch, Your Lordship.
But you are filing counter affidavit?
Yes, Lordship. Yes, Lordship.
Your Lordship, I have received
Supplementary
the counter
counter
in
affidavit.
courtroom only, Your Lordship.
The statement made by the appellant in para 3 is otherwise, Your Lordship.
No, and where is the provisional seniority list?
Yes, Lordship. There is no problem. Yes, Lordship.
Huh? You are prepared? What is the date? Please give the date. On what date you are prepared?
Yes, Lordship. The fact is otherwise. Your Lordship, kindly.
Your Lordship, with
Before Your Lordship may allow me to read para 3 of the memo of appeal. The statement made by the appellant, Your Lordship. May I read, Your Lordship? That the facts necessary for consideration of the issue involved in this case is that the appellant who was appointed as Anganwadi Sevika in the year 1980.
Sir, show us the combined seniority list.
Yes, Lordship.
Where is her name? Serial number so and so.
As per guidelines, Your Lordship, the applications were filed by the candidates. On that basis, Your Lordship, merit list was prepared. That merit list was shortlisted, Your Lordship. In the said common merit list, Your Lordship, the petitioner placed at serial number 152. Discuss.
Your Lordships, in this matter at the outset, I want to point out one recent development. The director ICDS has
That was not required in his case.
has already relaxed age for 11 years, Your Lordship. So that may be considered, Your Lordship, and I don't think that.
We'll consider at the time of final.
Annexure B is the
51. Seniority list is
Annexure B, page 24 of the counter affidavit.
no, this is seniority list. Annexure C.
No, Your Lordship, that is not.
Where is the seniority list? We are asking you.
Is not prepared, Your Lordship.
All right, keep your official present. Without the seniority list, you are going to fill up the promotions.
Allow me to place the certain facts, Your Lordship.
Sir, what is
As per guidelines, Your Lordship.
sir? What is the method of recruitment to the post of supervisor?
That is there. Annexure A is there.
Promotion? No. Is it by promotion?
Appointment, Your Lordship.
Appointment.
On the post of the supervisor, Your Lordship. Amongst the.
It is not a promotion.
No, Your Lordship.
Then have you advertised?
Yes, Lordship. We have advertised.
Where is the advertisement?
Advertisement is Annexure B.
Your Lordship, it's a promotion from the working Anganwadi Sevika.
Where is that method of recruitment?
That is, Your Lordship.
And that guidelines, Your Lordship, is Annexure A.
In terms of
No, sir. 25% promotion is there or not?
50%.
25% will be considered among the Sevika, Your Lordship. But the same is the.
That has been operated or not?
Applies, Lordship.
That has been operated or not? Have you filled up 25% of the?
Yes, Lordship.
Then show us. Where is that?
Yes, can you see, Your Lordship?
For that purpose, seniority is required or not?
Yes, we have prepared the merit list, Your Lordship.
Not merit list, sir.
As per guidelines, Your Lordship, it is open for the Sevikas to file application.
There is a method of recruitment to the post of Anganwadi supervisor.
Annexure A.
Your Lordship, page 15 of my writ petition, Your Lordship.
Now, Your Lordship, kindly see clause 5 Anga. Clause 5 Anga, page 20. It says, Your Lordship, हिंदी में उसको पढ़ देते हैं, आंगनबाड़ी सेविका से नियुक्ति, आंगनबाड़ी सेविका से 25% कर्णाधिकृत पदों हेतु प्राप्त आवेदन पत्रों की समीक्षा. The application will be made by the desirous candidate, Your Lordship. They will file the application. That application will be scrutinized by the authority, Your Lordship. Then a merit list will be prepared, Your Lordship.
Sir, 25% is earmarked for Anganwadi Sevika.
Yes.
Correct? Yes. Is it a direct appointment? It is a promotion.
Appointment is there amongst the Sevika, Your Lordship. 2 appointments are there, Your Lordship. Number 1, direct appointment, Your Lordship. Earlier,
appointment 5% for Anganwadi Sevika. Is it by promotion? Then he is saying appointment. Promotion means seniority is required to be followed. Show him the word promotion where it is reflected.
It says selection will be made from 25% for Anganwadi Sevikas.
Is it by promotion or what?
Using word promotion or appointment. They just say selection.
Come on to promotion. When the post of this Anganwadi supervisor was created?
2010 guidelines is there, Lordship.
2010. Between 2010 to 2022, how many recruitments have undertaken?
Yes, Lordship. In 2010 itself, we have made recruitment, Lordship.
All right. After her appointment, for the first time, when did you recruit?
Yes, 2010, Your Lordship.
She was appointed in which year?
In 1988.
88.
Yes.
She had participated in.
Yes, Lordship. She has participated. Her name was placed at serial number 152. In the state merit list, Lordship. 152. Page number 43. Page number 43, Your Lordship. With a score of 67.77%.
For appointment.
You have to say. No, otherwise 55% by competence. What is the method? Similarly, this
what they have cards.
It is the identity. What are these columns?
Columns for what? Awarded marks for.
Huh?
Awarded marks for this. Marks for the.
That is the eligibility.
And on adding some.
So they have prescribed some.
Yes. For not for supervisor. What is it? For 20,000 immediately. When you are appointing supervisors from Anganwadi Sevika, what is the preparation of their list, selection list?
We have mentioned in the guidelines itself, Your Lordship. Clause 3, Your Lordship, page 17. प्राप्त आवेदन पत्रों के आलोक में शैक्षणिक योग्यता के आधार पर इस मार्गदर्शिका की कंडिका 1 5 क ख ग घ अंग के अनुरूप अभ्यर्थियों की मेधा सूची का निर्धारण जिला स्तरीय चयन समिति द्वारा किया जाएगा। पेज 17 यूनिवर्सिटी।
Whether they have passed from matric, inter or graduation. 10 marks for 10 years continuous service, and thereafter 1 marks for service of each year. And 10 and 5 marks will be awarded to a prize from the state government or central.
After 2010, next recruitment was under.
We are going to Your Lordship.
After 12 years, you are undertaking.
11 years we have exempted the age bar, Your Lordship. We have.
No, that is all right, sir. After one decade, for a second time, you are going for supervisor. In between, the vacancies are not available.
There was certain developments, Your Lordship. The GAD has restricted in the state of Bihar, Your Lordship, keeping in view of the matter.
Now, in 2022, how many posts you are going to fill up in so far as 25%?
That is for the district level committee, Your Lordship, to find out the post, Your Lordship, and publish the.
No, because of your default, why she should suffer?
No, she must appear.
No, you are not allowing to appear now because you are saying that she is overage.
Now, after that letter, Your Lordship, the department has issued annexure, Your Lordship. 74, Your Lordship. We are exempted. We have given 11 years.
You have given exemption to
us? Yes. We have given exemption, not to this applicant, to everyone, Your Lordship. Who have crossed the 45 years, Your Lordship.
You have given exemption.
Yes.
So the petitioner is also included.
Yes, Your Lordship. As for now, for this year, Your Lordship, I am eligible for this, Your Lordship.
Then what remains in the present matter?
That's what I was submitting at the very outset, Your Lordship. In view of this letter, this may be disposed of.
What is the date of letter?
29/1/2023.
9th of January 2023.
After the observation of this Honorable Court, Your Lordship, that letter has been issued by the department. But the statement made by the appellant in the initial stage that she was not appeared.
In view of later development on 29/1/2023, state has evolved so far as relaxing age criteria for the post of Anganwadi supervisor from the cadre of Anganwadi Sevika. If the policy is implemented in that event, appellant would be benefited in participating in the process of selection and appointment to the post of Anganwadi supervisor. In the light of these facts and circumstances, the present LPA do not survive. Accordingly, present LPA stands. However, order passed in writ petition CWJC did not come in the way of considering the appellant's eligibility to participate in the process of selection and appointment to the post of Anganwadi supervisor.
Lordship, I only request that some time frame may be given so that
that is for the department.
Some time frame may be given so that the process of selection completed. Otherwise,
Before this main order, delay condoned for the reasons stated in the
Your Lordship, my counter affidavit and supplementary affidavit may be required.
counter affidavit is taken on record. Then lastly, you add, reliably learned that the last recruitment to the post of Anganwadi supervisor was in the year 2010. Therefore, the concerned authority is hereby directed to complete the process of selection and appointment to the post of Anganwadi supervisor in order to avoid hardship to such of those Anganwadi Sevika who are likely to be overage for the recruitment.
What happened?
Limited question is major license.
Land register list has come. Land register list.
Why your registry is showing on the pendency of IA despite the dispose? They don't look into. This is not the file. He will give the which are the serial number. You go and verify with the concerned worker. Is he doing only postman work? Can't he see the previous order? They don't have
The link to enter.
no. They don't. While putting the file, can't they read the order? Previous order. Previous order. They look into it or not? Then in the previous order, IA is allowed. Can't they make a note and see that should not be shown in the list? IA for limitation. What the after court hours you give the whichever the file. Yes, you can go.
Serial number 6, Rajesh Kumar versus the State of Bihar for the appellant Sriran Vijay Kumar.
4 weeks time to remove the office defects.
Serial number 7, Mohammad Adhar versus the State of Bihar for the appellants Mohammad Ataullah.
In compliance of order date, my lord, order dated 18th January 2023, my lord, on 5th January 2023, I have filed the my lord.
Have you filed IA for?
My lord, on 25th January 2023, I have filed online, my lord, for condoning the delay, my lord. And therefore, after my
file hard copy.
I have filed on 30th January 2023, my lord. But that is not on record, my lord.
Registry is hereby directed to put up the IA stated to have been filed on 30th January 2023.
Serial number 8, the State of Bihar versus Vijay Vidyarthi for the appellant Sri Gopal Mohan Rao.
Your Lordship, last orders will be kindly seen, Your Lordship. Pursuant to that order, Your Lordship.
All right, office objection not removed. LPA stand in terms of the order dated 3/1/2023.
Serial number 9, the State of Bihar versus BN Mandal University for the appellant Sri Sushil.
Same in this case, Your Lordship.
Same order.
Covered matter, lordship. It is
same order.
LP number 159 is there. LP number 59. LP number 159 order is there, lordship. On merit, it has been dismissed, lordship. That's why.
And counsel for the appellant state has not complied the order dated 3/1/2023. On the other hand, it is submitted that identical matter
was with regard to
dismissed. Accordingly, the present LPA stand dismissed in the light of order passed in LPA 159 of 2021 dated 11/7/2022.
Serial number 10, the State of Bihar versus Service Prasad Sinha for the appellant Sri Gopal.
Yeah, please.
In this case,
Service of notice to respondent.
my lord, I am appearing in this case.
You are appearing for respondent.
Appearing for respondent, my lord.
Filed wakalat.
Online it was filed and the hard copy is
For respondent, Mr. So and so counsel, he stated to have filed wakalat through online.
Akhilesh Tatwa.
Permitted to file counter affidavit if any before the next date of hearing. Is this matter after 4 weeks?
6 weeks.
No, 6 weeks.
Serial number 11, Sani Kumar versus the Union of India for the petitioner Sri Gopal Prasad.
Office objection not removed. Accordingly, order dated, the LPA stand in the light of the order dated 3/1/2000. CWJ stand dismissed. In the light of the order dated 3/1/2023.
I will remove the defect, Your Lordship.
All right, take your own time. You have already dismissed your CWJC.
Under the heading for order, serial number 12 is adjourned for next week. Serial number 13, Sanjay versus the state of Bihar for the Christmas tree Sanjay Kumar Singh.
Your Lordships, in this case, in pursuance to my Lord's order, 3rd January, the collector appeared on that day. On 4th, he informed that he has initiated an encroachment proceeding. Now, my Lord, today a counter affidavit has been filed, and what they have done, my Lord, they have issued notice upon me saying that you are the encroacher, so why not proceedings would be initiated against you?
All right, you give your reply. I am not the encroacher.
I immediately on that notice itself I submitted it.
No.
Now they are saying that the date is fixed for 3rd.
1 second. The subject matter of land, you are also a part in.
No, I am not. No way concerned.
All right.
Para 8 of the counter affidavit.
Reply to the notice. That's all.
That I have filed.
All right. They will consider.
And
where is the notice issued to you?
My Lord, since he has taken, my friend has taken the notice from me and he is fled away from the court. The counsel for the respondent number 3, state. I have shown the notice to him. Para 8 may kindly be signal of the today's counter affidavit. He has to inform this court what action he is going to take.
He has not filed counter. Today he has filed.
Filed, my Lord. And in Para 8,
lying in the office.
He has to inform about the status, what action he has taken.
Take after some.
Although, my Lord, a soft copy has already been filed yesterday, my Lord.
No, why you are issuing notice to him?
No, so far the notice is concerned, my Lord, just I have talked with the department, my Lord,
No, have you perused the notice?
My Lord, I have just told you, my Lord. I have.
What is the content of the notice?
My prayer only is, my Lord, that it may be examined for a week, my Lord. Perhaps it's a misunderstanding of the CO, my Lord. Only for few cases, only one day accommodation.
Before 1:30, ask him to withdraw that notice if it is not in accordance with law. Otherwise, we will impose exemplary cost.
My Lord, may I pray?
He being the petitioner, you are issuing notice to him. Nowhere he is concerned. Is he concerned? Is he occupying any land?
My Lord, last time DM Samastipur.
Ask the concerned authority to withdraw the notice before 1:30 and let us know.
If my Lord may feel pleasure, my Lord, only pass over for the day tomorrow may be taken up.
No. Before 1:30 you have to withdraw. We will call this matter at 1:30.
And no action has been taken against encroachers till date.
We will examine. First, let him withdraw the notice.
But sir, they are not giving me the copy of the counter supplementary, they will never give me.
That is the habit of the other side. Even if you are on the other side, you would have done the same thing. It's the lawyer's duty. Is it not? It is not our duty.
Internal dispute, it may not be highlighted before the honorable court, my Lord. Just I am serving, my Lord.
All right, come at 1:30.
My Lord. All right.
Serial number 14, Rampreet Sharma versus the state of Bihar for the petitioner Sri Anush Kumar.
In this case, my Lord has inquired that whether I will be representing the whole respondent or not. In pursuant to last order, my Lord, we are representing the whole, my Lord, the respondent. Altogether, 4 respondents are there. And we have filed our reply also on behalf of both the parties. It has been filed.
Only for the petitioner.
Perhaps. I hope, my Lord, it's on record, the counter affidavit of respondent number 1 and 2.
You have filed your counter?
My Lord.
What is the reason when they...
We have explained that...
Service provider at rupees 15 per Aadhaar. And you are accepting rupees 50 to 80?
My Lord, in pursuant to Government of India, Union of India, a tender was floated and office memoranda was circulated to all the states, including the state of Bihar. Altogether, we are making 35 lakhs and odd Aadhaar. That is free of cost to the student. But it's the internal arrangement between the department that we have to float the tender. We have explained each and everything, my Lord. That is by way of Annexure A, page 15 to our counter affidavit. that how we are utilizing that amount.
Did you file counter?
My lord, it has been approved yesterday.
Approved?
Approved. We have to file it online, then it will be approved, then we have to file the hard
Go
copy.
and file hard copy.
We have filed yesterday. Hard copy.
This is hereby directed to tag counter affidavit stated to have been filed by the to stop. A petitioner is permitted to file rejoinder if any before the next date of hearing. List it after 2 weeks.
Serial number 15, Munesh Kumar Meena versus the Union of India for the petitioner Sri Ganesh Kumar.
My lords, I kindly pray for pass over for few cases.
Today is Wednesday. No after few cases. It will be only next week. This is matter next week.
My lord, similar matter and next to serial.
15 and 17 both.
15 to 17 next week.
Under the heading for admission, serial number 18, Baliram Singh versus the state of Bihar for the appearance Sri Rajiv Kumar Singh.
Make your lordship. My lord, kindly see your lordship order number 11 dated 2/1/2023, my lord. Your lordship is free to direct the
order dated
2nd January 2023, my lord. 2nd January 2023, my lord. Order number 11.
Yes, who is for the respondent? After a few cases,
Serial number 19, Lakshmeshwar Singh and others versus the state of Bihar and others for the petitioner Sri Arvind Kumar Singh.
Compliance of my lords last order dated 22/12/2022, my lords. The Vice Chancellor has passed a regent order, my lords. It is being affidavitted, my lords, to be brought on record. It will be served to the petitioner, my lords, to appellant, my lord, today, my lords.
My lord, let it come after 2 weeks.
And respondent is stated to have passed a speaking order and the same is placed on record to release this matter after 2 weeks. In the meanwhile, appellant counsel is hereby directed to produce the speaking order.
We are
address his argument on the next date of hearing. 2 weeks.
Serial number 20, Umesh Kumar Tiwari versus the Food Corporation of India through the chairman and others for the appearance Sri Harikrishna Prasad.
Your lordship, sir.
Writ application.
Annexure 18, your lordship, the order dated 30th of August is under challenge 2018 and is under challenge passed in CWJC number 9256 of 2000. Your lordship, in the writ application, the order of dismissal dated 24/7/2012, annexure 18, and order of appeal dated 1st of May 2013.
Is what is error committed by single?
Your lordship. Your lordship, this is the single judge, your lordship has not taken into consideration. The single judge has not taken into consideration that your lordship, in this case, there are 11 employees of FCI has been put in a one department of proceeding.
without specifying the charge against each of other. And by one proceeding, all have been held guilty, and out of whom, your lordship, 3 have been dismissed and 7 have been given the punishment of certain recovery of amount. Before the Honorable, there was no separation of any charge in the memo of charge. What officer has committed what mistake? Only one dereliction of duty.
Where is the charge memo?
Here, your lordship. Your lordship will take into consideration the charge memo is. Your lordship, annexure 8 at page 77.
Page
77. Your lordships will find from the charge. The undersigned proposed to hold an inquiry against Sri so and so, so and so, so and so. There is 10 or 11 persons, your lordships. Under regulation 58 of FCIS staff regulation.
Shortage
of grains. Grains, your lord, wheat and rice.
Then are you not part and parcel of that?
Your lordship, all the 10 have been. I was there, your lordship.
Then
I am part and parcel of all the.
Yes.
All the 11 persons, your lordships, have been put in the same charges, your lordship. Same charge, same and similar charge. The audio, your lordship, Rule 58 says your lordship charges must be distinct. Rule 58, your lordship, of this FCI regulation, your lordship, must be. Talks about, your lordship, the charge. Rule 58(3).
1 second. The petitioner was dismissed from service.
Yeah.
Who is the other person who has not been who dismissed, but other than dismissal penalty?
Your lordship will find from the order of dismissal itself.
Where is the order?
Your thank you. Order of dismissal, annexure 18 at page 201. Page 201. Your lordship, this from the bottom, your lordship will find Umesh Kumar Tiwari. He was dismissed. Then another person, your lordship, dismissed, your lordship, is Sri Shaukat Ali. One person was exonerated, your lordship, Suman Patel. Third person dismissed, your lordship, is.
No, sir. Where is the order of the dismissal in respect of other person?
Your lordship, in the same order.
No, which person has been imposed minor penalty?
Your lordship, Sanka. Your lordships will find from page 207. 207. Serial 5. 207, your lordships have got it. Serial 5. 3 persons dismissed, your lordships, then minor penalty, minor fine penalty. There, Moti Lal Ram, penalty of recovery of 5 lakhs.
Where is the relevant portion of in the Moti, what is this? Moti Lal Ram.
Yeah.
In the previous page, where is his name?
In the.
It is on page 203.
Your Lordship should.
Read.
Motilal, whereas from records, it is observed that the charge officer have been working in the depot since long as detailed under. Motilal Ram, Rabindranath Pathak, Janardhan Singh, Sri Krishna B. Misra, Sri Manohar Ram, Sri Bir Bahadur Singh, Sri Hridayanand Gaur. All the 7 your lordships have been given the minor penalty. And the other 3 persons have been dismissed and 1 has been exonerated.
Correct, but role is different. You take 201.
That's why I am submitting your lordships in the memo of charge. No role has been explained. What role they have, they were in the.
Have you challenged the charge memo?
No, I have not challenged.
Then without that, how can you say that?
Your lordships, I am saying only I have formulated my submission.
Correct, sir. But when you are pointing out, defects in the article of charges, you should have challenged it.
Your lordship. Indeed. And what only this, your lordship? Like one thing or one more your very important aspect of the matter. These 11 persons have been the inquiry. There were 2 inquiry officers.
2 inquiry officers.
2 inquiry officers.
Where is that inquiry?
7 has been inquired.
Where is the discipline regulation?
Discipline regulation, your lordship is. FCI regulation, your lordship, I am supplying. Then,
under which regulation the inquiry has been ordered?
Under 58. Your lordship, rule 58. Sub-rule 2.
But we are not provided copies, regulation.
It is not in the market, your lord, that's why I have.
Then how do you expect this court will have? Pass on that.
Rule 58, your lordship. The rule 58. 2 is the inquiry officer and the rule says your lordship about the charges. And your lordship.
What are the 2 inquiring officers?
2 inquiring officers, your lordship, one was. One, your lordship, one Muhammad Mujammil Hussain, Assistant General Manager.
When he was appointed?
He was appointed as your lordships by 21st of January 2012.
Who is the other person?
And your lordships, one person was your lordship P.S. Chahal.
He was appointed on what date?
He was appointed, your lordships, on. In the meantime, your lordships, date is not there, but your lordships, in para 25, I have said.
May I say 100 things, sir? It must be supported by documents.
Your lordships, let me. 7 persons have been inquired by this Mujammil Hussain. And 3 persons, Mujammil Hussain.
Sir, you are saying that 2 inquiring officers.
Your lordship. Mujammil Hussain, your lordship, has inquired about the misconduct of 7 persons. Now he has transferred that file to this Chahal. Chahal inquired about the 3 persons. Then your lordship said, report submitted about all the 10. Before the Mujammil Asraf, 4 PWs were examined.
To understand what he is saying. Can you ask? I'm not able to understand. I asked him, he will go ahead.
And before Chahal, one witness was examined. But your lordship,
I mean,
all the four were not.
no, you were saying that 7 persons were, inquiry was conducted against 7 persons by the first inquiring officer.
By Mujammil.
Yes.
He has not submitted, he has examined all the witnesses. He has submitted transferred his file to this Chahal.
There is a joint inquiry. How could you say that it was against 7, only 7?
No. While the 7 persons were inquired, your lordship, 5 witnesses were examined. 4 witnesses were examined. While 3 persons were inquired, your lordship, only 1 witness was examined. But while report was submitted, considering all the 8, all the 5 witnesses.
Where they separately inquired upon. Where they separately inquired upon.
Separately inquired upon. The 3 persons separately inquired. 7 persons jointly एक साथ inquired हुआ. Charges remain the same against all. Vicarious liability, there is no concept of any vicarious liability in the service jurisprudence. Charges must be distinct.
What is the document you are referring to regarding these facts?
Regarding your lordships, I have submitted my defense, your lordships, stating all these facts, your lordships. My defense, your lordships will find. And not only this, your lordship, before this particular fellow, your lordship, before he gave joining...
Who is appearing for corporation?
My lordship.
Take page 78 of the writ petition.
I do not have the writ petition right now, my lordship.
Huh?
I do not have the writ petition.
All right, we will impose an exemplary cost.
My lordship, it has come for the first time, my lordship.
So only we are going to impose.
No, the writ petition is available. That I will get it.
All right, without that, how can you appear?
I have got the LPA copy.
All right, we will impose exemplary cost. Without.
My lordship, I will take help of my learned friend.
All right, take. Don't take it lightly. When you are appearing in a LPA bench, you must be prepared. Litigants are waiting for a verdict, either this way or that way.
My lordship.
Take page 78. Before that, 77. From the page 77, can you make out what is the role played by the petitioner, during which period he has committed misconduct?
Page 78.
Yes. Assuming that in the article of charge you are not given the details, at least it must be reflected in the statement of imputation on the next page. Nothing is there.
But it says the names have been given.
Sir, during which period Mr. Umesh Tiwari was working and how he has committed,
that your lordship.
he has alleged to have committed misconduct. Where is the gist of the article of charge? Dates and events are very much necessary to formulate ingredient of a charge.
My lords, my lords may come to page 79.
70?
9.
79. 79 is a list of document.
Statement of imputation of misconduct,
No,
misbehavior.
that is on 78. From this also you can point out where is the
8 is the articles of charges.
no 77 is the article of charges.
I'm sorry, my lords, in this.
All right. First page is a statement of article of charge.
Yes, and the second.
From this you can't make out what is the role played by him during which period.
My lords.
And next page is statement of imputation. In the statement of imputation also it is not reflected what is the role played by him during which period.
He was the overall in charge. He was the manager of the depot.
Maybe, but
he was the manager of the depot.
Sir, that is not disputed. Otherwise, you can't initiate inquiry.
Well,
but where are the gist of the ingredients of article of charge?
that is, my lords, there in page 78, my lords.
Not page 22. Let us know. In the statement of imputation, there is no averment that Mr. Umesh Tiwari during his period so and so, he has committed misconduct or he has not maintained the records. Therefore, there is a shortage of wheat in this quantity.
It is together with, my lords, other persons also. All there were altogether 1, 11, 2, 3, 6, 7, 8, 9, 10 and 11. 10 persons. 10 persons together have been.
Sir, we are not concerned with that. We want ingredient. Mr. Umesh Tiwari was working on so and so depot, or he is in charge of so and so. During his period, this stock register reveals that there is a shortage. Where is that charge?
That charge is there, my lords. I'll read it.
That charge is there. Find out.
Month, my lords, is given. I'll read it, my lords. Sri such and such, Mr. Umesh Tiwari and others, while functioning in their respective capacity as FSD Buxar during the said period and abnormal.
Generalization. 5 persons are here. They worked during so and so 2010 to 2011. They are all involved in this alleged allegation. That is generalization.
Shortage, my lords, of a huge amount.
Sorry, sir, we'll set aside. And are they in service?
No, sir. My lords, just.
What is the age of the petitioner?
My lords, just allow me to at least place it. While functioning in their respective capacity as FSD Buxar during the said period, an abnormal shortage of wheat rice commodity has been found during the month of February 2011, which is evident from the stock account from the month of such and such. Now, February 2011, the number of stock has been given, and the shortage is also given.
Sir, not in respect of this person.
No,
what is the quantity? You can't generalize.
They all were it is not a case of theft. It is the case where
correct. For that purpose,
shortage is there.
We have to examine what is the mode of article of charge, how article of charge should be prepared. The ingredients of formulating a charge is not forthcoming either from the article of charge or from the statement of imputation. Therefore, it is a which can be interfered and set aside in the light of apex court decision in the case of some Mondal 2002 or something.
My lords, here there is my lords, I will place the inquiry report. There is
so we are not concerned with that inquiry report and all. We are concerned whether article of charges have been framed properly or not.
My lords, the article of charges are clear.
All right,
we are not saying that, my lords, there has been shortage because of any particular person.
Sir, we are not concerned with that.
These persons
mode of framing article of charge.
My lords. Yes. Now, my lords, even if we go through the articles of charges, my lords, or imputation, if 10 persons are posted in a particular depot,
Sir, each individual role is required to be explained in the article of charge. Then only you can.
Yes, individual person.
It is not there.
Their designation is there, my lords.
Yes, we will consider. That is your argument. That their designation is there.
No, my lords. The role which they have played has been already given in the inquiry report in details.
All right, we'll consider.
In the
inquiry report, it has been considered.
My lords. So here, my lords, also individual, my lords. The shortage of the stocks have been.
Sir, don't argue on merits. We don't interfere at all.
No, on the question of charge also, my lord.
Yes, on the question of charge, you show us what is the alleged allegation against the petitioner, during which period he has committed.
Period is given, my lords.
Period is 2011, randomly 2011.
Not randomly, my lords, specific. There.
What is the date?
Date is, my lords, there is an inquiry report, there is a report, fact finder.
Sir, you are also repeating, we are also repeating.
No, the dates are there.
All right, we'll consider. Dates are there, we'll consider. We will extract the article of charge itself.
My lords, may kindly, there is a monthly physical verification done. And in every monthly physical verification of the stocks, my lords.
You have regulation. You have regulation?
Yes, I've got the regulation.
Take regulation.
Right now, I do not have.
We will not provide you.
Just if it is passed over, my lords.
No question of passover.
Tomorrow, my lords, I will.
We will record it.
My lords, it has.
No, we will record it. Say we will impose cost and adjourn the matter. You want 4 weeks?
No, my lords, I don't want it.
Then.
My lords, this was not an issue in the writ petition, my lords.
All right, it's a legal issue.
So this is an issue for the first time being.
Legal issue, sir.
This is an issue for the first time.
All right, we'll consider.
Allow me at least to give a reply to that, my
Yes,
lord.
sir, give you a reply.
Allow me to give a reply because
Give you a reply, sir.
this issue was never raised.
All right, sir, we will consider that is for the first time new plea is urged by the petitioner. We will consider that such a new plea cannot be urged by petitioner.
Allow me to be prepared on that, my lords. That is only I am saying.
No question of adjournment. Without books, without writ petition, you are appearing.
That was not served on me, my lords. Writ petition. That
They can't serve you. You have appeared in the writ petition. In the
file was returned. Usually, what happens, my lords, wherever they
all right, we will record your submission.
record, my lords. Just one accommodation I was asking.
All right, subject to payment of cost.
Then, my lords, can I get? I'll respond to that. Whatever is.
This is not fair. Read the pencil mark portion. Article of charge tallies with the rule or regulation.
my lords, it speaks of one employee, single employee. Now,
Then where is the regulation in so?
Substance.
All right, where is the, according to you, it is a single employee. Where is the for common proceedings?
no, my lords,
No, under which provision of law you are going to frame article of charges for common proceedings?
no, if there are 10 employees with respect,
All right, sir.
the same charge is to be.
Correct.
But same charge can be imputed against 10%.
Yes.
It is not necessary that each and every has.
According to you, is there any other provision insofar as issuing initiation of inquiry to more than one person?
My lords, it is under this, not a.
No, you please apprise this code.
No, there is no.
This is the only provision.
In my mind, there is no separate provision.
Therefore, there is a non-compliance to this.
That is what, my lords, I am submitting. My lords, the provision cannot be construed as if it is only with respect to a proceeding which has to be initiated with respect to one employee.
All right, we'll consider your contention.
Every employee will have a separate imputation given. If, my lords, the charges are the same, my lords, if the charges are same, and my lords, in that charges the 10 persons or 5 persons are involved, against whom the imputation is same.
Sir, we have to go by regulation.
Yes, as per the regulation.
Yes, as per regulation only we are going to deal.
My humble submission is, my lords, this even as per it is only saying employee. Now, this includes employee, not one, but even several employees. It does not mean. So, yes, of course, if the charges with respect to every employee are different. Suppose, my lords, there are 10 employees being proceeded, and again, the charges are different.
Here it is a different, for a different spell. Altogether, 10 persons have not worked on the same day.
Same. Yes, it is. That
can't be same day.
Well, it is not a particular day where the shortage has occurred. Shortage has taken place in a number of months.
Therefore, we want on what period Mr. So-and-so is liable for this misconduct. Where is this specific averment in the article of charge or statement of imputation?
Well, it's the period during which these 10 persons had been working and were in charge.
All right, sir, we will consider next point.
Well, so my humble submission is that this provision, it is everywhere. It is not just in this FCI regulation, because this is adopted from the central rules. So therefore, this rule is applicable everywhere. But such rule cannot be interpreted to mean that if the charges are same, one cannot move with respect to the same charges against 5% together. Plus, there is no such bar or ban. Therefore, in my humble submission, Lords, that reading the provision, if the charges against 10 persons are exactly the same, then it is not required, my lords, to separately deal with same charges again and again with respect to several.
All right, we'll consider that.
Now, my lords, the second question which your lordships has put to me was, my lords, as to what is the period during which each of the persons are imputed. My lords, the period is same. Period is not different. For the period during which they had been at that particular FSD, and where the shortage has been found, and that shortage has been found after physical verification of stocks, and in those physical verification of stocks, all these persons were there posted in different capacity. Well, so far as Umesh Kumar Tiwari is concerned, he was manager, and the other person, Suman Patel, he was manager QC. Mr. Shaukat Ali, manager depot. Kedarnath Tiwari, assistant grade 1 depot. Motilal Ram, assistant
Mohammad Shaukat Ali, manager.
Yes.
Mohammad Shaukat.
There
are 2 managers.
There are, my lords, 3 sheds. The FSD, the food storage depot, contains of various sheds. Now, every shed has got a manager. Like shed number 1, X-manager, shed number 2, Y manager, shed number 3, some different manager. And overall in charge, there is another manager who is in charge of all the 3 sheds.
Yes.
So, in that capacity, Mr. Umesh Kumar Tiwari was functioning. Manager and overall in charge of all the...
At least from the article of charge, can you point out Umesh Tiwari is in charge of which shed?
Of all the 3.
Sure. All the. Then how Shaukat Ali...
Shaukat
Ali was a manager. There are two managers.
My lords, there are two managers. The senior managers are usually made.
Not senior. They are in the article, reading from the material.
This is a designation.
Correct.
Designation.
That is the reason we are asking you, two managers in one depot.
FSD, yes, there can be even more than two.
All right, then show me from the statement of imputation.
They are designated as manager and they were in charge of a shed. That is not disputed, my lord.
All right, anything else?
My lords, it is something. Suppose, my lords, a person is in. Everything is not to be recorded in my humble submission.
What you say is correct. We'll deal it.
Everything he was in charge of shed number 1. That is admitted position. Now whether this was necessary to be given. Now if not given, then whole charge goes. Well, that is what I'm.
All right, sir. We will deal with your argument.
So my lords may kindly have a look to the inquiry report. The inquiry report will clarify it, and there is no dispute on that there were 3 managers in the same FSD. FSD can have, my lords, 3 managers of individual and overall in charge of the FSD.
3 managers, each individual role is required to be explained in the article of charge.
My lords, I may be allowed to place the inquiry report, if your lordship may permit. That is annexure 15.
Like B.S. Charles.
Page 177.
Which is the relevant portion of the inquiring officer
Well, it's at
report?
178. Here, my lords,
Where is the finding insofar as petitioner is appellant is concerned?
my lords, I'll just.
You have not read the papers. Now taking the library here.
And
it is on page 185.
Well,
if you don't read and come, this is the position embracing for you and the court. And we will make it clear that we are not going on merit. We are only on the legality. Even inquiring finding cannot be interfered unless it is perverse.
Malus. Malus. That is page 186.
Sir, we have made it clear that we are not going on merit. We are only on the legality.
Yes, my lords. But
even if the inquiring officer finding is against him, we are not going to interfere. We are only on the legality.
I was only placing it in order to answer your lordship's query that how there are three managers and how his case is different. For that purpose.
Yes, we'll note your argument that in terms of inquiring officers finding the article of charge need not be elaborated. Correct?
My submission is not that.
Then what is your submission?
My submission is that, my lords,
sir, rightly or wrongly, in the article of charge and statement of imputation, there are no ingredients constituting a article of charge. Now you want to apprise with reference to inquiring officers finding with reference to that.
That's with reference to that.
Therefore, we are making note.
Oh, I am only making a submission. Obviously, that is a subsequent event. That is not going to rectify the earlier error if there is. My lords,
then why you want to read that?
I am only trying to make my submission, my lords, that
you can't. Can you go beyond the article charge and statement of imputation?
I cannot. But then, my lords, I am trying to trying to make a submission on the basis of that even if designation is given and there is an understanding, very clear understanding, my lords, the charges, if it is vague, not understood, my lords, by the...
Suppose, sir, if you are in Advocate General Office, one file is missing. 10 government advocates were subjected to departmental inquiry.
No.
Randomly.
No.
Randomly.
No. Cannot be. Here it is not that case. That example your lordship is saying, but that is not.
No, assuming two, three advocates have handled a case, file is missing. Who is the custodian of the record?
No. Here it is not that they had handled and they had gone away. Because they were still working there.
Therefore,
every shed.
Therefore, we will set aside and remand the matter. You hold inquiry from the defective stage.
My lords, here, my lords, every shed there was a shortage. It is not that there was a shortage in one shed.
We are not on merits. We are not on merits. Repeatedly, we are saying that we are not on merits. Our hands are tied by the Supreme Court not to interfere on merits in a departmental inquiry. We are going only by regulations. That's all. Whether regulations have been complied or not.
Well, sir, in my humble submission, if the regulations has to be read, that regulation is only saying with regard to details of imputation has to be given.
All right. We will
now that details of imputations we have given.
All right.
That I have read. Now the question is as to individual person's details. Now individual person's details is necessary, required, my lords. If there is a separate allegation for individual employees.
All right.
Here is a case where they were all posted at a particular FSD.
How many times you want to repeat?
And therefore, my lords, since there was a shortage, therefore, my lords, a proceeding was initiated against them, all of them.
We will come back and give dictation. What is the age of the appellant?
Your lordship, he would have been in service, he will ought to have been retired on 31st of October 2013.
No, what is the age as on today?
No,
from the affidavit you can't make out.
Your lordship say with their 60 में retire करेगा ना?
60 में retire किए थे.
60 about 72. 72. 20. There are 10 days. About 70 years.
Only has 12. Yes, take down. Instant appeal is FPI filed by Umesh Kumar Gari. Feeling aggrieved and dissatisfied with the order of the learned single judge. Dated 30th August 2018, passed in seat. As on the date of framing charge, he was manager of which depot?
Food storage depot. Food storage depot. Buxar.
No, incident is Buxar. Next, for appellant and others, appellant and 10 others who are working in the Food Corporation of India stated to have committed alleged misconduct which has resulted in alleged loss of a sum of rupees 3 crore 50 lakh 5,529 rupees. Towards storage shortage to the extent of 103.74.030 quintals of wheat and 2417.728 quintals of rice. Rice common and 805.29.875 quintals of rice grade dash capital A during the month of February 2011. The article of charges, common proceedings was initiated against all the 11 persons in the light of Regulation 60 read with Regulation number 58 dash procedure for imposing major penalties. Article of charge reads as under, it is on page 77. Article of charge and statement of imputation reads as under, page 77, 78 extract. The common proceedings was concluded in imposition of penalty Where is the penalty?
Penalty, your lordship, page 201.
Page?
201.
Concluded in imposition of penalty on each of the person while invoking regulation number 54 of Food Corporation of India within bracket staff bracket close regulations 1971 within bracket as amended read with regulation 54. Extract of the penalty order reads as under page 205 only marked portion. to 207. Next paragraph. Feeling aggrieved by the imposition of penalty of dismissal on the appellant. Appellant preferred appeal before the appellate authority. Appellate authority confirm the order. Where is that order?
Order, your lordships, the annexure 20, 1/5/2013.
No, page number.
Page 47.
247. Appeal was rejected while confirming the order of the penalty of dismissal from service on 1/5/2013. Next paragraph. In this backdrop, appellant has invoked remedy under Article 226 challenging the order of disciplinary and appellate authorities order dated so and so. Dated 24/7/2012 and 1/5/2013. Next paragraph. CWJC 9256 of 2014 was decided on 30th August 2018 while affirming the action of the official respondent insofar as imposition of penalty of dismissal from service and its confirmation by the appellate authority. Hence the present LPA. Next paragraph. And counsel for the appellant submitted that article of charges are not in consonance with the regulation Regulation 58 relating to procedure for imposing major penalty. He has specifically pointed out within bracket Roman 1, again within bracket 3 of Regulation 58, which provides that disciplinary authority is required to frame article of charge within inverted comma the substance of the imputation of misconduct or misbehavior into definite and distinct article of charge. It is reading of article of charge read with statement of imputation, one cannot come to the conclusion that there is a definite and distinct article of charge have been framed. In other words, the dearth of ingredients constituting the article of charge / misconduct Next, it is further submitted that disciplinary authority has not apprised the evidence with reference to factual aspects of the matter, that at what point of time the appellant is stated to have committed misconduct / misdeed It is further submitted that appellate authority has not considered the appellant's appeal in the light of regulation number 72 and it relates to consideration of appeal. In other words, there is no consideration of within bracket A, comma B, again and C, again within bracket 2 of regulation 72. Therefore, not therefore, full stop. These are all the legal issues which have not been considered by the learned single judge, and it can be raised at appellate stage. Per contra, learned counsel for the respondent resisted the aforesaid contentions and submitted that reading of article of charge read with the statement of imputation suffice that charges have been framed in accordance with the regulation 58, again within bracket 3, read with regulation 62 dash common proceedings. He submitted that in a common proceedings, article of charges need not be specifically when the alleged misconduct or a misdeed is common. In other words, misdeed / alleged misdeed is common by all the 11 persons. Therefore, there is no infirmity in the article of charge and statement of imputation. Similarly, there is no infirmity in the order of the disciplinary and appellate authority. He supported the order of the learned single judge dated 30th August 2018 that there is no infirmity so as to interfere with the order of the learned single judge. Heard the land counsels for the respective parties. Undisputed facts are that appellant and 10 others were subjected to common proceedings under regulation 62 of regulations 1971. It was concluded in imposition of penalty, among others cited supra. Insofar as appellant is concerned, penalty of dismissal has been imposed. He has exhausted the remedy of appeal before the appellate authority and suffered an order before the appellate authority. Similarly, he has suffered an order before the learned single judge in CWJC 9256 of 2014 on 30th August 2018. Hence the present LPA. Learned counsel for the appellant, next paragraph, learned counsel for the appellant submitted that article of charge read with the statement of imputation do not constitute ingredient of article of charge Stop. Particularly in a common proceedings undertaken by the official respondent under Regulation 62, it was bounden duty of the disciplinary authority to specify what is the role played by each of the officials / employees of the food corporation and in what manner each of the employee is alleged to have committed misconduct / misdeeds as stated in the article of charge read with the statement of imputation. To stop. The aforementioned contention of the appellant that article of charge read with the statement of imputation do not constitute article of charge is supported by Apex Court decision in the case of Anant Kulkarni so and so, reported in 2013 so and so. To stop. Apex Court in so and so case has specifically laid down the principle that a statute is required to be implemented or given effect in the manner made known in the statute. To stop. In the present case, Regulation 58 is relating to procedure for imposition of a major penalty. Sub-regulation 3, again within bracket 1I, is very specific that within inverted comma the substance of imputation of misconduct or misbehavior into definite and distinct article of charge inverted comma close. In the light of the aforesaid provision, it was bounden duty of the disciplinary authority to frame article of charge and its ingredients. To stop. Assuming that the article of charge do not reveal the dates and events constituting the article of charge, at the best it should have been reflected in the statement of imputation. To stop. Perusal of the article of charge and a statement of imputation cited supra, it is crystal clear that there is no definite and distinct article of charge against each of the 11 persons, including the appellant. To stop. Here it is to be noted that if any misconduct or a misdeed is committed by more than one person or an employee, in that event, it was bounden duty of the disciplinary authority to highlight each individual roles played in the alleged misdeed or a misconduct. To stop. Perusal of article of charge and statement of imputation, it is evident that the aforesaid ingredients are not forthcoming, and so also there is a non-compliance to sub-regulation 3, again within bracket 1 of regulation 58. Next, Land Council for the Respondent Food Corporation of India could not apprise this court as to whether is there any compliance to regulation 58 and regulations 58 regulations relating to imposition of a procedure for imposing major penalties, read with regulation 72, consideration of appeal by the appellate authority. Full stop. Next paragraph. The appellate authority was required to consider various issues while considering the appeal filed by an aggrieved person who had prepared an appeal. In this regard, it is necessary to reproduce regulation number 72 relating to consideration of appeal. Regulation 72 reads as under. Reading of the aforesaid regulation, it is crystal clear that it was bond and duty of the appellate authority to take note of a regulation, a sub-regulation 2, within bracket 2, again within bracket A, B, C, all individual brackets A, B, C, of regulation 72. The reading of appellate authority's order, it is evident that there is a non-compliance to aforesaid regulation, sub-regulations. In this backdrop, the appellant has made out a prima facie case so as to interfere with the order of penalty of dismissal dated so and so, comma, appellate authority order dated so and so, and order of the learned single judge passed in CWJC 9256 of 2014 dated 30th August 2018. That is the next paragraph. Accordingly, they are set aside. Next paragraph. It is a case of a remand to the disciplinary authority to initiate a fresh inquiry for the simple reason that huge crores of rupees alleged misconduct is stated to have been committed by the appellant and others. If the penalty order is set aside on technical ground, in that event, courts/tribunals have to remand the matter to the concerned authority in the light of Apex Court decision in the case of MD ECIL versus so and so, Coal India, para 46 to 50, reads as under. Apex Court reiterated the principle laid down in the MD ECIL case in the recent decision in the case of Prabhat Kumar so and so versus State of UP. Accordingly, the matter is remanded to the disciplinary authority to initiate a fresh inquiry in accordance with Regulation 1971 and complete the inquiry proceedings within a period of 6 months from today. The concerned officials are hereby directed to cooperate in the disciplinary proceedings. The next part, the intervening period is required to be decided by the concerned official respondent depending upon the outcome of the disciplinary proceedings to be initiated afresh and its conclusion. In that regard, a separate speaking order shall be passed as to how to regulate the intervening period from the date of dismissal till passing of a fresh order. Such order shall be passed within a period of 3 months from the date of final order to be passed in the disciplinary proceedings afresh. LPA stands allowed.
my lord. This is only limited to, my lord, the appellant.
Huh?
Only limited to the appellant.
It will apply to everyone.
No.
Common proceedings.
Because that has been already there.
It is left to you. If they come, you have to initiate. Otherwise, you can't initiate individual inquiry now.
Regulation. Oh, right. Good one.
Now the case fixed for 12:15 p.m. Under the heading for hearing serial number 36, Rekha Kumari versus the State of Bihar for the appearance Sri Sunil Kumar Singh.
May I please? At the last occasion, the departmental head, the commissioner, health department was called for with records of the case. And
with all the record.
The Lordship, the punishment is of dismissal. Application is unauthorized absence. That is, straightway, Your Lordships.
No, give it to stenographer.
72 regulation.
The stenographer.
ये बताइए डिसीजनरी प्रोजेक्ट Lordship, the case is very simple in the sense. I will stick to the procedural.
Maybe simple for you, sir.
That's it's subject to my Lord's approval.
Why officer should be summoned?
Because nobody was present at that point of time. A state council was not present. And nobody was there to assist Your Lordships in the case on behalf of the estate. Therefore, the commissioner was called.
Oh, state was not represented.
Estate was no estate.
What is the problem with the office of the Advocate General?
So far as this case is concerned.
Not this case. Generally, we are asking you why there is no representation on behalf of the state, where the state is party. There is no coordination among the government advocates.
There is every coordination.
Assuming that you have some difficulty, you should request your colleague.
No difficulty, my lord. I am saying, lord, that since the age 9 was the decision of the concerned advocate, my lord, it was not possible. So that is why this case could not be marked up, my lord. That is why
this was not marked. Still worst case. Yes, Mr. Principal Secretary, why it was not marked to a government advocate? A matter is of the year 2017. For 6 long years, why it was not marked?
Case was marked. The case could not be marked up below.
What is he saying?
Since age, if only the name was published in the cause list, the age 9 was not there, so it could not be marked up below. In the cause list,
these are all your internal problem. You should resolve yourself.
Not my only by
unnecessary. The officer has been summoned.
I am submitting, Lord, that since in the cause list the publication of age 9 was not there, that is why it could not be marked up below.
Anyway, sir, in such an event, somebody should represent. You all government advocates representing state. Such a coordination is not there.
And that point of time, it was not the first hearing, it was the third hearing, full-fledged.
All right, take a seat, Mr. Officer.
So,
where are the list of dates and events?
Your Lordship, we have given the list of dates of the event. But that may not, Your Lordship, kindly note this date of an event, if Your Lordships so please. On 30th of October 2004, this appellant, who happens to be the associate professor in the PM neuroscience, neurosurgeon PMC, neurosurgeon. Under the agreement between the government of Bihar and the government of India and the Mozambique government, some doctors were to be sent on their own. It was not the government sponsor, but there was an agreement, some persons will go to Mozambique for this conduct. He gave an interview, appeared in the interview, he was selected, and
where is the document to show that?
That is why at that point of time, first Your Lordship remember, I requested Your Lordships to adjourn the case so that I could obtain that document of the agreement. But since he is dead and substituted opulent his lady, his wife, she has not been able to collect those documents.
So we can't accept your such a statement.
That's correct, Your Lordship. Your Lordship. That's I agree that. But the fact is this: he went to Mozambique, and for that he informed the department through his principal. Yes, sir. He please grant me leave, 3 years leave, so that I could go.
Granted 3 years leave.
3 years leave.
Where is that communication that 3
That's
granted?
Leave was not granted.
Leave was not granted.
Not granted.
So you have disobeyed the superior officers.
No, neither disobeyed nor obeyed.
No, whether it has been rejected.
No, no. It was not rejected. And in anticipation, as practiced in the state of Bihar, not that.
You have to go by only regular.
So, Your Lordship, kindly have a look to the Annexure 1 to the my writ application.
Annexure 1 to the?
Writ application.
Writ application.
Writ application. Page 18. This is in Hindi. My lord, this is dated 30/10/2000, 30th 10th October 2004.
What is this?
This is Your Lordship's, the appellant is the Prasad Ayub, through proper channel, विदेशी सेवा में योगदान करने हेतु अनुमति एवं अनापत्ति पर प्रमाण करने के संबंध में दिस योर लॉर्डशिप सूचनार्थ निवेदन है कि मोजाम्बिक सरकार के अधीन मेरा चयन चिकित्सक पद पर हुआ है। आदेश की छाया प्रति संलग्न है। मुझे योर लॉर्डशिप ही सेज दैट ही हैज बीन सिलेक्टेड फॉर द पोस्ट ऑफ डॉक्टर इन द मोजाम्बिक गवर्नमेंट। मोजाम्बिक सर्विसेज ऑफ मोजाम्बिक गवर्नमेंट, and therefore he informed the department.
You should resign and go.
Because there is a provision for leave. There is a provision for leave, and you will not.
So, which is the relevant rule that you are permitted to take a fresh appointment elsewhere, and you will have a continuing
lean here.
Where is the provision?
On that aspect, your lordship.
Last time also I asked you.
This was not. This question was not posed to me. This question was posed to me ki your conduct. My lords was giving much stress on the conduct. Why have you gone? And why the court?
All right, show us the relevant regulation that if X person is appointed in the state of Bihar, he can join a fresh appointment elsewhere while having a lien in the state of Bihar.
I will satisfy your lordship, but first your lordship kindly see this was a.
No, one by one we will go. You first satisfy that.
I will satisfy your lordships. If that goes against me, I don't have any your lordship grievance. But the things your lordships, suppose that I have committed certain kind of misconduct. Agreed whether I had committed the misconduct, they have granted leave. And they have approved.
Where is the grant of leave?
Leave. Your lordship, it is reflected in the inquiry report itself.
No, we want an order.
That your lordship, the order, I was not provided with the order. But their document says.
If the inquiring officer has favored you.
No.
Then where is the document?
What favor? Rather, he has recommended.
All right, where is the then document?
Yes, your lordship, kindly have a look. Have a look to the.
Sir, in the inquiring officer, if he is giving finding that you have been granted leave, support of that, there must be a document. Otherwise,
yes,
such a finding given by the inquiring officer cannot be accepted.
That's. I understand what your lordship said. Yes, your lordship kindly have a look to the inquiry report. He is not giving me that advantage without any document. Page Annexure 1, Annexure I, page 21, Annexure I to the counter.
On one hand, you say that leave has been granted.
Yes.
At the same time, read your prayer, item number 2. The writ petition, prayer number 2.
application petitioner has been rejected.
Correct. Then what is this?
Yes. It was the writ petition was filed in 2010.
We are not concerned with that. Your statement is contrary to your own.
Because my statement and my prayer may be the contrary. Because I was not here. The lady is before your lordship, the substituted petition.
No, this writ petition was filed by
the appellant, the original person, filed by the original person.
So we have to go by your prayer. It is already rejected. How can you say that leave has been granted?
I say on the basis of their document.
Oh.
They kindly have a look. Your lordship, bear with me for 5 or 6 minutes. If your lordship is not satisfied, then I may not have any case. But my endeavor is to get your lordship satisfied to this. This, your lordship, the inquiry.
Whereby leave application.
Inquiry, your lordship, the inquiry report is at page 28 of their counter affidavit and Excer I.
Counter affidavit to what? Writ petition or
writ petition?
PA?
Writ petition. Counter affidavit to the writ petition. Deputy Director Health Services. Yes, your lordships. Straightway I am taking your lordships to the place where it has been indicated on the basis of the record. Then your lordships, the item number 12 of the inquiry report at page 30. As page 30, it says, Hindi mein I read and then I तत्कालीन सचिव की संचिका, your lordship, it's the record of the case. 14T में अंकित किया गया है कि डॉक्टर अरुण कुमार प्रसाद निलंबित सहायक प्राध्यापक न्यूरो सर्जरी विभाग पटना चिकित्सक महाविद्यालय पटना का मोजाम्बिक सरकार के अधीन 3 वर्षों तक वर्तमान पद पर पद ग्रहण सुरक्षित रखते हुए उन्हें अनापत्ति पद प्रमाण पत्र निर्गत किए जाने संबंधी आदेश हुआ. It was made in absence of thereafter, yes. आदेश हुआ है कि वर्णित स्थिति में इस आवेदन पत्र को विधिवत खारिज करते हुए उन्हें संसूचित करने की आवश्यकता है. तो लॉर्ड देन योर लॉर्डशिप काइंडली सी आवश्यक खारिज करते हुए उन्हें संसूचित करने की आवश्यकता है. At that point of time, at the time of inquiry, तब तक विभागीय कार्यवाही को स्थगित रखा जा सकता है. It is the commissioner who instructed the inquiry officer or advised the inquiry officer कि unless until his leave application is rejected formally, till then you keep the inquiry proceeding in abeyance. That is what he submits. रखा गया. टिप्पणी की छाया प्रति, the record is also there, therefore it was called for. पश्चात संचिका प्रभारी दिनांक तिथि के अग्रेतर करें. This was the inquiry officer's finding in the inquiry. On the basis of this, I submit subject to my lord's approval. It's my submission. Whether the leave was to be treated as approved or not. If they say, ये आदेश प्राप्त हुआ है, लेकिन इसे विधिवत खारिज करना है, your lordship, इसे विधिवत खारिज करना है. You have to reject it in accordance with the law. And then, till then you stay the departmental procedure. That's my first. Therefore, my first submission is, leave was granted. My application was pending before them. So they cannot charge me of unauthorized absence. So forget.
What is the date of inquiring officer's report?
That is the date.
What is the date of inquiring officer's report?
Report is 25/9/2006.
25/9/2006. 2006. But your leave has been rejected on 10/2/2009.
9.
You are challenging that
That's
So whatever the finding given by the inquiring officer would not assist you.
my submission is, if it was rejected in the year 2009, then there was no occasion to hold me guilty for unauthorized absence. That's my submission, and your lords, just a minute, your lord. Just a minute. So, this is one aspect of the matter, subject to my lord's satisfaction whether. Now, your lordship, come to the last line of the inquiry. Last line. Page number 31. Whatever he has done, whatever. अतः उन्हें सेवा से बर्खास्त किया जा सकता है. This is the recommendation of the inquiry. Rule 17, any of the provisions is here, does not authorize him to recount mine.
All right, we will quash that portion. He has no authority to.
But my dear, on that way, that's your lordship's prerogative, whatever your lordship. But according on his advice.
Sir, how many years unauthorized absent?
2 years.
2 years.
2 years. Less than 2 years.
He has remained
let me complete.
From 7 to 2005 till January 2010.
You will have it. You will have it.
You will have. So, your lordship, the inquiry report holding me guilty of unauthorized leave in 2006, recommending my dismissal. They kept pending, they sat over the matter, and my dismissal order was passed in year 2010 on basis of this inquiry. My submission is just to meet the requirement of Rule 76 of the Bihar Service Code. So, absence in NUT is 2 years.
Have you reported after unauthorized absent for 2 years?
Yeah.
Requesting for giving me posting?
Your lordships kindly have it.
Show us the one document.
Yes, I am showing. When the inquiry proceeding has started,
we are not concerned with that. You say that you remained unauthorized absent for 2 years.
Yes.
They say that more than 5 years.
It is the matter of fact. Your lordship can examine.
Right. Show us the document that after completion of 2 years unauthorized absence, you are reported for duty in seeking posting.
2 years. Yes, your lordships kindly have a look to the Annexer 7 to my writ application, Annexer 8 to the my writ application, and in second so-called notice was issued in year 2007, Annexer 9, etc., etc. Reply that. And it is not that when I came to know about the initiation of my proceeding against me and placing me
in Annexer 7, have you requested for posting?
Yeah.
Not his document. His document of
page 24.
Annexer 7 is author government.
Page 26.
No, sir.
Page 20. It's that I'm
24.
page 24. Yes, your lordships. Page 24, Annexer 7. Appearance in your office by the end. Most humbly, I have to say that I have been asked to report to your office by 28 2000.
You are not able to. You are unable to attend your office at present.
That's. I informed them. It was.
You are not given. You are not asking for posting.
No. Initially, before that, I requested the principal to post me.
You the document.
That's the
document.
Just Annexer 4, your lordship. Page 21. Page 21, Annexer 4. This is with reference to above. This is letter number 1.
Stated that I am reporting for duty.
Yes.
7/2005.
Yeah.
Hey, where have you asked for posting?
Yeah, I submitted my joining to the principal of the college from where I.
Principal is not supposed to give posting. It is the government.
it is the
government has to give posting.
When I left India, I was working as an associate professor PMCH.
Sir,
he has recommended
class 1 officer. Your posting and other service condition is required to be attended by only state government, not the principal or commissioner.
That, your lordships, that may be a fault on my part.
Sir, he is a class 1 officer. He must be knowing.
He must be knowing. That he must be knowing, but he was not expecting this kind of proceeding when many of the principal professors of the PMCH and other medical college, my Lord Justice Jha, knowing it, in the state of Bihar, even today, at least if your lordship get the matter in...
Not only in state of Bihar, most of the states are suffering the medical department and health department because of this type of attitude by the government, doctors.
In spite of that...
do you know how much the health center, health has suffered because of your unauthorized absence? How many persons their health has been affected?
Exactly, your lordships, I do not...
Sir, you are a responsible doctor, you can't just...
agreeing with your lordship view. But it is the government who allows to go. It is the ministers who allows to go.
Show us the document. One single document that state government is permitting you to go and...
That document, that document, your lordship, very frankly speaking, I do not have.
Then you can't make your submission, I have been permitted, I have been permitted.
Submission on the basis of their report. On the basis of their report.
Anything else, sir?
Yes.
We have spent sufficient time on this.
Your lordship, kindly see. The inquiry was concluded.
1 second.
Submitted here. And this would inform. Here it says.
Your lordship, my first submission, it is all subject to my lord's approval, what is wrong, what is wrong. My first submission is that when inquiry was being conducted, I was proceeded against. My leave application was pending. Before the rejection, I was held guilty of unauthorized absence. That is number one. Number two, even if they have conducted and found me guilty of the unauthorized absence, that according to me it was not. The inquiry officer has surpassed his jurisdiction by recommending my dismissal. And the authority concerned, neither the BPSC nor anyone, all have acted on his recommendation. They have not applied their independent mind. It may not be a case that requires that kind of. Why they have kept 3 years or 4 years? Just to kindly have a look to the Rule 76, whether I can be dismissed under Rule 76. Dismissal order. And in the dismissal order, they have not referred the inquiry order. Dismissal order. So, the procedural lapse, I have committed mistake, I have committed. But that does not authorize them to ignore the law, ignore the procedures prescripted in the law. That's your lordship. They kindly have a look to my dismissal order.
Which rule has been violated by them?
17, Rule 17. By recommend, Rule 17, any provision, the inquiry officer is authorized to inquire into the matter, frame the charges, and submit his report.
No, they are invoking Regulation 76 of Bihar Service Code.
For dismissal.
Correct.
For dismissal. But for the departmental proceeding, they are invoking CCA Rule 2005. So 2005. And
the date of framing charges.
Yes. The charge memo they did not. Because
then on what basis you say that they have invoked Rule 17 of CCA rules?
Because your lordship, I have gone through. I have gone.
According to you, have they? Your assumption is that they should have resorted.
No, not at all. My submission is the Rule 2005, not any provisions of Rule 17 which.
Don't say Rule 17. CCA Rules 2005 have not been.
Therefore, invoked.
Then where is the document we are asking you? That they have
That's the point.
taken any action under CCA rules.
Annexus C, your lordship, page 24.
Annexure C.
बड़ी अफसर जो है उसको जो है सो चार्ज में ट्रीट कर दिया.
What is this annexure C? Where do we get?
Yes, your lordship, the annexus C, kindly see,
Page 21.
page 21 of their counter affidavit.
That is relating to what?
Relating to my departmental proceeding. And if your lordship of the point of view, this has been treated as the charge me. This बिहार राज्यपाल के विश्वास करने का कारण है कि अरुण कुमार सहायक प्रबंधक निरुक्त बिहार पटना चिकित्सा महाविद्यालय अनुबंध के अंतर्निहित आरोपों में वर्णित घोर कदाचार एवं अवज्ञा के दोषी हैं, जिसके लिए उन्हें विभागीय अधिसूचना के द्वारा निलंबित किया गया है. अगर
why rule 50 has been invoked?
But initially the letter reflects that it was the old rule 55, but that was repealed on that prior to that.
What is the date of repealing rule?
13/7/2005, that day rule was repealed. 13/7/2005.
12/7/2005.
12/7, that might. The rule was.
As on 13/7/2005, this was existing.
That was existing. But they have not initiated under this rule. They have initiated under the old rule.
Anyway, sir, you are not challenging Annexure C.
I'm not on that point. I'm challenging.
Why are you referring to this if you are not on the point?
My lord says that they have dismissed you provoking the provision of Rule 76. If that there was no requirement of any departmental provision, if my conduct.
When did he join service?
Your lordship, in 20th January 1990. 90.
What?
1990.
20th January 1990. 1990.
What is the date of your unauthorized absence comment?
It starts from 2000. Your lordship, the 13/5/2005.
13/5/2005.
7/2/2005 to January 2010. As per
2005.
Yes. Order was issued on 13/5/2005.
This Annexure C. This. It was issued in 2005.
Chapter 5 minutes.
And he was shows that he is in. You can't read the suspension period and date of dismissal as unauthorized.
So my submission.
Wait. State Council, we are giving a proposal. There is a error committed by the State Department. To the extent that you have not invoked CCA rules and complete the proceedings in 2005, when he remained unauthorized absence from 7/2/2005, you have placed him under suspension, correct? When you have placed him under suspension, where is the question of remaining unauthorized absence? If he is on duty and remained absent, that amounts to unauthorized absence. When he is placed under suspension, where is the question of unauthorized absence? In fact, suspension is for unauthorized absence. Suspension is in 2005. As on the date of suspension, he was remained unauthorized absence for few months. So you can't invoke 76.
My Lord, as per his pleading.
Therefore, we are of the view that you take a decision to modify the penalty from dismissal to that of compulsory retirement, and compulsory retirement should be with effect from 7/2/2005, the date on which he remained absent and gone abroad. Otherwise, we will set aside the order and you can't initiate inquiry because he is no more. You have to go and hold inquiry elsewhere. It's impracticable.
My Lord, as per his own pleading, he has remained absent from the year 2000. As per
We are only on legal issues. No doubt. For his conduct, the punishment is dismissal. But at the same time, look at the attitude of the government. They did not initiate inquiry under CCA rules in 2005 and complete the proceedings. And by means of a short circuit method, you have resorted to regulation 76 of Bihar Service Code, treating that he remained unauthorized absent, therefore dismissal.
Because there is a provision that he...
Provision is there, but it does not amount to unauthorized absence. From the day you place him under suspension, he is under your control. How do you expect suspending the officer?
Suspension because he remained absent, my Lord.
Correct. From the date of suspension, he is in the service only. He is before suspension, have you given him, asking him to report for duty? Instead of placing him under suspension, you should have resorted asking him to come and appear.
Literally, he took the decision to go to the abroad, my Lord. And as per his pleading itself...
All right, get instruction. We will give you a 1 week time. You take a decision and come back. You want any order?
Time.
Huh? No, we will grant you time. 10 days time we will grant you. But shall we dictate? Or your principal secretary is here, very much here. He can apprise the concerned official or ministry. Have you understood? Please get instruction insofar as modification of penalty dismissal to that of compulsory retirement with effect from 7/2/2005, the date on which he remained unauthorized absent. If your hands are tied, then we are going to pass orders on merit. And thereafter you can't have any, at least you can save some money now. Otherwise, if we pass orders on merit, you have to shell down all arrears, monetary benefits and other things. You don't have liberty to initiate inquiry since he is no more. Think all these lines and apprise the concerned ministry and come back. Yes, taken. Matter heard at length. Having regard to certain legal lacunas in the case in hand, we have suggested Principal Secretary, Health Department. Secretary, Health Department. Secretary, Health Department, Mr. So-and-so, who is present in the court, has been asked to get instruction to the extent whether a state government can modify the penalty of dismissal to that of compulsory retirement with effect from the date on which deceased employee remained unauthorized absence, in particularly with effect from 7/2/2005 or not. The proposed suggestion is not acceptable to the state government. In that event, we would pass orders on merit on the next date of hearing. List this matter after 2 weeks.
I'm very grateful to your lordships and I'm obliged to you. I was also of the, I was to take it.
No, sir, it is not a fit case. Only thing is on technicality we are allowing.
Appearance maybe.
Sir, do you know how much people suffered
Your lordship,
during your absence?
your lordship, in the,
Sir, the doctors are waiting for the appointment. You can't have two appointments, one in India and another in Mozika.
in some other case, I will let your lordships know how many professors of PMCH and Darbhanga Medical College admit.
Sir, this affair is in each and every state.
That is the.
As far as appearance is concerned,
130 matter?
yes. Once my appearance is concerned, it may be
appearance of the secretary and so stands dispensed until further orders.
My lord, on conditional apology, my lord, and now the order has been modified, my lord, and recall notice so far the petition is concerned, my lord. Good copy.
Give it a copy. Give it.
Copy has already been served to the all concerned, my lord.
This matter.
My lord, my prayer is, my lord, let
This matter next week.
My lordship, this petition is filed for order passed by Labour Court in case W456/2015. My lordship, basic issue we have challenged that the jurisdiction on the question of jurisdiction of Purnia Court, whether it can decide the work done in Simla.
Where is the order? Where is the order?
Page 13 of the writ of petition.
Page
13. 1-3.
Who is for respondent?
He has not been noticed.
Petitioner counsel? You don't know who is for respondent? You are a proprietor. You are a proprietor.
No, my lordship. They have alleged that I am.
Sir, you are an employee or employer?
Contract agent, broker, my lordship. And alleged by contract laborers.
Work was executed in which area?
Simla, my lordship.
Where have you stated in your pleading? In which paragraph of a writ petition you have pleaded that Labour Court has no jurisdiction?
For my lordship.
No, you have asked them to. You are an employer in the state of Bihar, agent.
No, labor has alleged that I am a contract.
Sir, you are residing in Bihar.
Yes, my lord.
You have hired people from this Bihar state in order to engage their services in Himachal.
No, in real, I myself is labor at that place.
You are a labor. On one side, you say that I am agent.
Labor worker has alleged that I am a broker and I have taken them to Simla.
Is there any agreement?
No, my lord, sir. No.
Then, what is the material placed before the labor court? That there is a master and servant relationship.
Simple statement of laborers. They have on a statement labor said.
Other than statement, nothing has been produced.
On the last occasion, Lordship has directed the petitioner to show that whether he has raised the
any remedy
issue of jurisdiction before the labor court, Lordship. And before that,
now he is saying that the jurisdiction lies in this Shimla, Himachal Pradesh.
From the
because the work was executed in the Himachal, and that apart, he says that he is also laborer.
Lordship. And before that order, the state was directed to show whether there is alternative remedy of
against this order.
We have procured a notification of the state government by which it has been passed by the presiding officer of the labor court, Lordship, and the appeal lies before the presiding officer of the industrial tribunal.
No, then who has passed this page number 13?
It has been passed by the labor court, Lordship.
Then is there any provision appeal against the labor court before the labor court only? How can it be, sir?
It is the notification of...
Sir, who is the authority? Appellate, who is the appellate authority?
Appellate authority is presiding officer of the industrial tribunal, Lordship.
What about this?
It is
page 13.
It is labor court, Lordship.
Labor court is one and the same, sir.
No.
It all depends on designation with reference to the dispute.
Lordship, Lordship may kindly go through this notification, Lordship. In column number 3, Lordship, it has clearly stated that the presiding officer of the labor court is the person who will hear under section 21 of the Minimum Wages Act, Lordship. And against his order, the appeal will lie before the presiding officer of the industrial tribunal.
How are you distinguishing the industrial tribunal and the labor court?
Labor court is situated in different districts, Lordship, and the tribunal is operating in Patna, Lordship.
Pass on that notification. This page 13 is passed under subsection 3 of section 20 of the Minimum Wages Act. Minimum Wages Act book.
Minimum Wages Act.
You have Minimum Wages Act book?
Lordship,
or who?
We have one.
Huh?
We have one more.
Give it to him.
Lordship.
Take page 20. Read subsection 6. Every direction of the authority. You got it? Page 20.
Lordship.
Subsection 6.
Lordship.
Every direction of the authority under this section shall be final.
Lordship, there is Bihar amendment, Lordship.
Huh?
There
Sir, this amendment is, you are referring to subsection 6.
Lordship.
This is not correct. Subsection 6. Subsection 6 says that every direction of the authority under this section shall be final.
Lordship, there
This
is
notification is issued under a wrong provision.
Lordship, state amendments may be seen, Lordship. In the next page, state amendment is Bihar, in the Bihar, Lordship.
There is no Bihar,
Lordship.
Maharashtra, Rajasthan, Madhya Pradesh,
Lordship,
Karnataka.
on page 21, Lordship, at the top, Lordship.
State amendment of Bihar.
Lordship.
Where is the amendment to subsection 6?
Lordship, I may permitted to read, Lordship. D, Lordship, of subsection C.
No, so this section 6 is arising out of which section? This is subsection 6.
Lordship, subsection 6
Of which section? Main section?
section 20, Lordship.
No, there is another section.
At the top, Lordship, in its application through a state of Bihar in section 20, Lordship. Or at the top, Lordship. And now, under section 20, Lordship, the subsection 6, Lordship.
Yes.
At D, Lordship. Any employer or worker aggrieved by any direction made under subsection 3 by an authority appointed under subsection 1 on an application made under subsection 2 may within 30 days from the date of direction prefer an appeal in such manner and to such authority as the state government may by notification specify in this behalf, and that authority may, after hearing the appeal, confirm, modify or reverse the direction appealed against, and no further appeal shall lie against the order made by such authority in any court of law.
Writ is not maintainable. You have to go and approach.
Please. Here it is said that any employer or worker. Not employer, my lordship.
That will be decided by the authority, not by this court.
Has no jurisdiction to try this case, lordship. Labor court that has already passed this order has no jurisdiction to try this case, and the order passed by labor court was illegal.
Correct. It has no jurisdiction to what extent? What is the reason? What are the documents?
I mean, because the person who against whom this order has been passed was an agent. He was not an employee.
What is the material to show that he is an agent?
I mean, we have submitted in the writ application, my lord.
Correct, sir. Which is the document to show that he is an agent?
We have stated in...
Mere statement is not sufficient. You have to produce material.
We have stated in para number 4.
Then we will reject this petition. It is not supported by material information.
I mean, there was no document supporting...
Sir, you are saying that you are an agent?
Yes.
Where is the document?
That document was already not been produced in labor court also. That
you produce here.
Okay, sir.
Counsel for the state submitted that petitioner has a statutory remedy of appeal before the appellate authority in the light of notification dated 29/2/2008 passed under subsection 6 of section 20 of the Minimum Wages Act, 1948. On the other hand, land counsel for the petitioner submitted that labor court has no jurisdiction, since a respondent's grievance is required to be agitated before the jurisdictional forum under the state of Himachal Pradesh. For the reasons that whatever the works extracted from the respondent would be under the jurisdiction of Himachal Pradesh. Therefore, Labour Court has no jurisdiction to stop. In this regard, petitioners have not placed on record that they were agent in respect of providing employment to the contesting respondents. So therefore, they are hereby directed to produce necessary material to show that they were only agent and work has been extracted in the jurisdiction of Himachal Pradesh. If such a material is placed on record before the next date of hearing, present petition would be entertained, failing which a petition would be dismissed, asking the petitioner to invoke remedy of appeal before the appellate authority. List after 2 weeks.
Serial number 6, Manish Kumar versus the Union of India for the petitioner Ashok Kumar Singh.
I am for respondent number 4 to 6, Your Lordship, and I have served the copy to the petitioner today itself.
You are appearing for whom?
Respondent number 4 to 6, Your Lordship, and I am going to file a counter affidavit in this matter. Today I have served the copy to the petitioner.
You have already served?
Yes, Your Lordship.
Counter affidavit on behalf of respondent number 4 to 6? 4 to 6?
Yes, Your Lordship.
4 to 6 accepted. Petitioner is permitted to file rejoinder if any before the next date of hearing, at least after 4 weeks.
Serial number 7, Lucky Biscuit Company versus the State of Bihar for the petitioner Sri Rajit.
May it please, my
Lord, for the convenience of my Lord, I have prepared certain important dates and events. What's the matter in the narrow compass?
What is it?
Yes, my Lords. This is for setting aside the order which is at Annexure 1, dated 19/6/2020, passed by the Additional Principal Secretary, Labour Department, by which the Additional Principal Secretary has ordered the petitioners to restart the industry and keep running it as before, despite knowing the fact that the industry stands permanently closed with effect from 27/4/2020. Now, the facts in nutshell, if your Lordship will kindly just see the important dates and events.
No, under which provision of law he is compelling you to run the industry?
I don't know. We have permanently closed the industry on 27th of April 2020.
Who is appearing for us still?
I'm appearing first.
Which is the law?
Permanently closed it, my lord. And we have
closed on what date?
On 27th of April 2020, and thereafter, out of 247 workers, 169 have already come and taken the full and final dues and have left.
Out of
247, 169 of them have come, taken their full and final dues and have gone. And the remaining, we have sent them by registered post also their legal dues, etc. That apart, in the latest affidavit that we have brought it on record, we have again stated very clearly that now we have even disposed of 95% of our machinery which we were there. Now we followed the due process of law before going for permanent closure. And now, after it has been closed in April 2020, this order is coming from the additional principal secretary that, look, at that time there was a COVID, we could not take a decision on your application, etc. Now, you continue to run the industry as before. Now, how do we continue to run the industry when we have already closed it permanently?
Just give the finance. They will run the factory.
Lordship, that
State is prepared to give funds.
Lordship, I am amply permitted to submit. Lordship, the provision under which he sought closure was 25(o) of the Industrial Disputes Act. Now, your Lordship, in the intervening period, under 25(o) sub 3, there is deemed permission to be granted from 60 days if no action is taken within 60 days of. Admittedly, he has filed it, but
what is the date of application?
Date of application is 27th of January 2020. Seeking permission to close because it was a Chapter 5B industry because having more than 100 workers. So on 27th of January, we filed the application before the government seeking permission to close. Now we simultaneously also gave a copy to the union which was there.
Simultaneously?
Gave a copy to the union which was there in the industry. We gave a copy to the management played fairly. We gave a copy to the union also, that application for closure. Now the union also filed its objection on 13/2/2020 before the government. Now thereafter the government slept over the matter.
What is the objection they have?
And the 60 days lapse, the law requires that if an application seeking permission for closure is filed, then the government has to take a decision either allowing or rejecting the application under section 25(o) subsection 2 of the ID Act. And if within 60 days no decision is taken, communicating it to the parties, then the legal fiction is then it will be deemed to have been approved. They are deemed to have been granted. Now, that is exactly what happened on 27th of March, 60 days lapsed. Now, thereafter, we were under compulsion to close the factory because after 90 days, we have to close the factory. So, on 27th of April, we permanently closed the factory. We informed all the authorities of the Labor Department, the Provident Fund Office, the ESI Office, everybody we informed that, look, we have closed the industry. We even informed the workers and we told them, we requested them, please come and collect your entire legal dues, including closure compensation, gratuity, bonus, everything. We said, come and collect it. So they turned up and collected it.
Employee raised industrial dispute?
Now, they have not raised any industrial dispute.
They have not come forward to collect the settlement?
It is just that they have not come forward because it seems the union has given them some hope that, look here, if we win the case before the Honorable High Court, then this industry will be reopened and then you will get back your employment. Therefore, the remaining people are not coming forward to collect their dues. Whereas most of them, out of 247, 169 have come and collected the entire dues. The remaining are sitting on the fence, waiting for an outcome of this writ application and probably expecting that some kind of an order will be passed because they are getting the strength from this order passed by the additional principal secretary, which says you keep running the industry as before. How do we keep running the industry when we have permanently closed it?
Your Lordship, our only ground is, Your Lordship, that the 60-day period, when did it end in the fact of the current situation? We say that the 60-day period from the date of his application would have expired on 27/3/2020.
27?
3 March.
3 2000? Two months. You said 90 days?
No, 60 days is the time granted to them to take a decision. If not, then permission is deemed to.
All right, on 27/3/2020.
Permission stood granted.
Permission stood granted. In the meantime, Your Lordship, we say that the COVID lockdown was enacted and the Honorable Supreme Court passed an order increasing the limitation of all acts therein, which is subsequently reported and it has been extended from time to time. During the first period, when the lockdown was relaxed, during that period, we have, using our powers which have been vested to us by the Act, we have issued him notice in respect of the application which he had submitted seeking permission for closure. And thereafter, he has fully participated and cooperated in those proceedings. After hearing all sides, we have taken a decision wherein we say that you continue producing and operating the factory. These are the facts. Now, Your Lordship, in the meantime, they, under the impression that nothing has been done and deemed granted, they have gone ahead and declared closure with effect from 27/4/2020. Now, Your Lordship, for your consideration, Your Lordship, I raise 2 points. Admittedly, there is a judgment of the Honorable Supreme Court which says that, yes, if it is not deemed, if it is not order is passed, it has to be given effect. We are not disputing. Subsequently, Your Lordship, there is also a judgment of Division Bench of the Honorable Karnataka High Court, which, having considered that first judgment of the Highcourt, has laid down. In the fact of the case, it has to be seen where.
What is the reason for closure of the factory?
Public interest.
No, what is the?
Let me explain the reason. We were a factory which was doing only contract manufacturing of Parle biscuits. And they used to supply us the raw materials and we used to manufacture biscuits for Parle biscuits. Now we have very clearly stated in the application that on 15th of September 2019, Parle biscuits issued a letter and discontinued production from our unit completely. So we lost all business. There was nothing for us to do. And that is Annexure 3 at page 47 of the rate application. Thereafter, we kept on negotiating with Parle that please continue with us. They did not budge. Now, despite the fact that...
Did you disposed of the machineries?
But lately we have done that and we have brought it on affidavit also. That is the third supplementary affidavit which we have filed, if my Lord will kindly see. In which we have stated very clearly the third supplementary affidavit.
No, what is the date, sir? Date of disposal of machineries.
I'll just inform you.
If I may submit, Your Lordship.
Just
if I may submit that here the issue which we...
Sir, are you willing to provide raw material and funds?
We don't have business.
May I?
First of all, they don't have machineries as on today.
As of today, yes. They don't have.
Well, prior to 1906-2020, machineries were disposed or?
They were not disposed.
On what date it was disposed?
My Lords, I'm reading that paragraph. That...
Sir, don't read. What you don't know the date of disposal of machineries.
My Lords, just my Lords. During the period May to July 2022.
You don't know the exact date. What is this?
This is the period in which, in a staggered manner, the machinery has been disposed of. May to July 2022. Now, it can't be disposed of in one go, my Lords. Therefore, in a staggered way, during the period May to July 2022, the machineries have been disposed of.
Was there any condition in 1906-2000 20 that you should not disburse the.
No, my lords. No conditions. Nothing.
It has virtually become infructuous. How can you? If you want to revive the industry of the petitioner, you provide machineries, funds.
Moreover, Your Lordship, if I may draw Lordship's attention to subsection 4, wherein this order is in operation for a period of 1 year in any case.
Which one? 1906-2020.
No, Your Lordship.
Which order?
The final order.
Final order what?
Refusing to grant him permission to close down. Now, as per Your Lordship, subsection 4 of section 25, it says that the operation of such order, either granting or refusing to, will be in operation for a period of 1 year. And moreover, Your Lordship.
So you are refused on 19/6/2020. It has lapsed on 18/6/2021.
So I am free then.
Appearing on behalf of the union, my lord. My lord, after the writ application was filed and stay was granted, and after that, my lord, the
stay was granted in this petition.
In this petition, my lord, and thereafter, my lord, the machinery was they started to dispose of the.
You should have filed contempt. You filed contempt.
There was no specific direction for not.
Therefore,
my lord, they have taken advantage of the stay order, and my lord.
Sir, you provide machineries and raw material today. We'll ask them to establish.
Time of the order passed by the Labour Department, my lord, on 19/6/2022, everything was there, my lord. Nothing was missing from the.
All right, sir. Initiate contempt proceedings against them.
Contempt proceeding, my lord, only.
Or can you put back the machineries?
My lord,
can you put back the machineries?
Kindly see the conduct of the petitioner.
Sir, you please be practical. Can you put back the machineries and restart the factory?
Their basic argument is that they are taking shelter of deeming provision. That the 60 days has been completed.
All right, sir. You have a protection of Supreme Court decision insofar as COVID-19 period, the application of closure could be decided even after lapse of 60 days. Still, can you put back the machineries and start the factory?
That means, my lord, they are taking advantage of their own land.
Correct, sir. What is required? You give the solution. All right, you give the solution.
Lord, solution, we are the workers, my lord.
All right, sir, give us the solution. How to restart the factory?
Their application was not even complete in all aspects.
Sir, we are agreeing with that. What is the solution? Can you give the solution?
But solution, we are ready to work, my lord. We are the workers, my lord.
Correct. You give the machineries.
We have lost.
You give the machinery, raw material.
And the business?
My lord, business was there.
Sir, he is the only ancillary unit to Parle-G.
My lord, they have no.
If the Parle-G did not supply raw material, how do you expect him to run the business?
They have been providing, my lord, the finished product to Parle-G, my lord. They have not annexed the order of.
Sorry, mister, can you put back the machineries?
My lord, we cannot put back because they have disposed.
So you, yes, take the.
My lord, may kindly take note of fact that they have disposed of the machinery 2 years after the passing.
Sir, you resort appropriate remedy before the industrial tribunal. That's all.
My lord, that would not be applicable in the present case, my lord.
Huh?
We are.
Sir, what is the solution? Please let us know. We are repeating.
Can only be provided by the employer himself, my lord.
Employment, you give the machineries and raw material and business.
My lord, raw material and business, that my lord, that is a later part. So first part is that they have already disposed of the machinery, my lord.
All right. Then what is required to be? Then what is required to be done by this court?
My lord, this court can take note of their.
Yes, we will take note of and close the matter. Nothing remains.
I don't know why my friend is saying this repeatedly. There is no order passed by this honorable court restricting us from disposing of the machinery. The stay order, in fact, the stay order is operating in our favor, where the impugned order was stayed by this honorable court. So why is my friend
today the interim order is operating?
Is operating against us?
Yes, take down. In the instant petition, petitioner has prayed for the following relief. The petitioner company is stated to be ancillary unit to the Parle-G Industries.
Parle Biscuits Private Limited.
Parle
Biscuits Private Limited.
Parle Biscuits Private Limited. The Parle Biscuit Factory Company refused to provide raw material in the year 2019. Therefore, compelling the petitioner Lucky Biscuit Company to close its unit. In the result, petitioner company invoke section 25(o) of the Industrial Dispute Act 1947 to the state government while completing the formalities like providing a copy of the application to the union. State government did not act on the petitioner's application for closure of their unit. On the other hand, Union is stated to have filed objections on 13/2/2020. If there is any inaction on the part of the state, either accepting or rejecting application for closure of a unit, in that event there is a deemed provision under section 25(o) within bracket 3. Accordingly, petitioner proceeded to close the unit of industrial unit on 27/4/2020. Pursuant to the closure of the unit, 169 employees have settled their payments with the petitioner out of 247. The remaining persons have not come forward to settle their score with the petitioner even to this day. When things stood thus, state respondent issued an order on 19/6/2020 asking the petitioner to commence the factory unit, commence the company situated at Banka Ghat, Patna city. The petitioner, feeling aggrieved by the state government decision, order dated 19/6/2020, presented this petition in the year 2020 on 7/7/2020 and obtained an interim order to the extent of staying the operation of government order dated 19/6/2020. During pendency of the present petition, the petitioner is stated to have disposed all machineries during the month of May-July 2022. In this backdrop, whether order dated 19/6/2020 of the government asking the petitioner to recommence or restart the company or not. Next part. Land Council for the petitioner submitted that there is a deemed provision under section 25(o). Therefore, with reference to closure application dated 27/1/2020 on 27/4/2020, petitioner company was closed and machineries were disposed in the month of May-July 2022. In this backdrop, the state government cannot compel the petitioner to restart its company. A deemed provision would assist the petitioner's grievance. Per contra, Land Council for the state resisted the aforesaid contentions and submitted that in the light of Apex Court decision in the case of cognizance so and so, COVID period is required to be excluded for the purpose of any time limit stipulated under various acts and litigations. Therefore, he supported the order dated 19/6/2020. Next paragraph. Land Council for the Union resisted the contention of the petitioner, stating that there is no proper closure of the petitioner company in the light of the fact that closure application dated 27/1/2020 would survive till 19/6/2020, since COVID-19 period was in vogue, and in the light of Apex Court decision, it is also submitted that disposal of machineries during pendency of the present petition is contrary to provisions of the Industrial Dispute Act read with the order dated 19/6/2020 to establish the land councils for the respective parties. Before adverting to the contention of the respective parties, it is necessary to reproduce the section 25(o). Section 25(o) of the Industrial Dispute Act reads as under. The petitioner submitted closure of their company on 27/1/2020 to the competent authority - state official respondents, while forwarding copy of the closure application to the union. State could not take steps either accepting or rejecting. In other words, they slept over on the petitioner's closure application dated 27/1/2020. In such an event, deemed provision of acceptance would operate in favor of the petitioner to stop. In other words, as and when 60 days is completed, and if there is a inaction on the part of the competent authority in either accepting or rejecting the closure application, it is deemed that it has been accepted by the competent authority. Accordingly, petitioner proceeded to close the petitioner's company on 27/4/2020 and further obtain an interim further on 19/6/2020 state has passed an order asking the petitioner to recommence their company. Petitioner's contention is that they have already disbursed the machineries in the month of May and July 2022 in the light of the fact that they had an interim order staying the operation of 19/6/2020 of the government order. It is therefore order dated 19/6/2020 cannot be given effect to in recommencing the petitioner's company unit in the absence of machineries, and further petitioner is only an ancillary unit to the Parle Biscuit Company. The Parle Biscuit Company stopped in supplying the raw materials the year 2019 itself. Therefore, it is beyond the control of the petitioner to commence or restart the company. Next, no doubt, order of the Supreme Court in the case of cognizant so and so would have assisted the respondent. At the same time, it is impracticable to recommence the petitioner company in the absence of machinery and Parle Biscuit Company in providing raw materials to the petitioner. Moreover, after closure of the petitioner's unit, among 247 workers, 169 workers have settled their score with the petitioner company. The petitioner company is ready to settle monetary benefits insofar as such of those workers against whom settlement has not completed. Next, the contention of the state cannot be appreciated at this belated stage. Moreover, order dated 19/6/2020 would be in operation for a period of 1 year in the light of subsection 4.
Yes.
Subsection 4 of section 25O. Therefore, the present petition has become virtually infructuous. In the light of these facts and circumstances, order dated 19/6/2020 could not be given effect beyond 1 year period, and that apart, interim order was operating as on today. Accordingly, the petitioner has made out a prima facie case so as to set aside the order dated 19/6/2020. Accordingly, it is set aside. Next, reserving liberty to the such of those workers who have not settled their monetary benefits with the petitioner are permitted to approach the petitioner company for settlement, if any, within a period of 8 weeks from today. Accordingly, the writ petition stands allowed.
Serial number 8, Ashok Kumar Garg, to the state of Bihar, for the
Lordship, serial number 8 to 21 and serial number 29 and 32. Same order similar clear below. On the last occasion below, the contesting respondent number 5 below had submitted that below 50% amount he has deposited. At 50% amount he has deposited. And remaining 50% amount will be deposited before the controlling authority.
We have complied with the order, my lord, in 10 cases, my lord. For 6 cases, we need 4 more weeks' time, my lord. I'm giving the list of the cases and the amount that has been deposited, the remaining certificate amount that has been deposited.
Where is the previous order?
Previous order.
4th of January, Lordship.
In a different way.
No, this matter is not disposed.
No, it is still pending, Lordship.
It's pending.
No, we'll dispose since fifth respondent has already invoked appeal before the appellate authority.
But he has submitted below the remaining 50% amount, he will be deposited before the controlling officer.
Now he has deposited, so we will dispose this. Yes, take on. In all these matters,
Lordship, before you commence, Lordship, may I? Has he deposited it in all the cases? Perhaps not.
Lord, in 10 cases we have deposited. In 6 cases we need 4 more weeks' time, Lord.
Which are those 6 cases? D-link, court master.
They are not linked, my lord. They are separate cases, my lord. Serial 13, 15, 16, 18.
But I have not given any receipt.
I have.
These cases may be kept pending. 4 weeks.
You could give it to stenographer.
Yes, ma'am.
Other than these matters, rest of the matters are disposed. We will learn counsel for the fifth respondent. Measures Winsome International Limited. Mr. So and so submitted that fifth respondent has deposited 50% of the determined amount of gratuity before the appellate authority.
Lord, may I clarify at this stage, Lord, the gratuity amount, principal amount was deposited with the appellate authority for maintaining the appeal. Since certificate was issued on last date, I have given an undertaking. The remaining amount of certificate is now deposited with the controlling authority, Lord.
Fifth respondent has deposited 50% of the determined gratuity amount before the appellate authority for the purpose of entertaining appeal before the appellate authority. Further, it is submitted that remaining 50% has been deposited with the jurisdiction controlling authority. In this backdrop, the present petition do not survive for consideration. Since fifth respondent has already invoked remedy of appeal before the appellate authority. Accordingly, These petitions stands disposed of.
Lord, I have not given the slip note under which cases, Lord, he has submitted, he has deposited the amount, my Lord, which cases are Lord, he are going to be deposited, my Lord.
No, appeal, he has already deposited.
I have not given the list of the, my Lord, in which cases they have.
Alright, if you find any difficulty, you can make an application for recalling my order. Then I will impose a cost also.
After 21, which case is that? 29.
29 and 32. 32.
ये दोनों में भी हो गया है डिपॉजिट।
हाँ ये पूरा लिस्ट दे दो सर।
Serial number 22, Motipur Sugar Factory Hind Mazdoor Sabha, Muzaffarpur versus the state of Bihar for the Christmas tree of Nish Kumar.
92.
22.
92.
But pursuant to my lord's last order, dated notes, 10/7/12/2022, a counter affidavit has been filed on behalf of Sponpur, wherewith he has placed on record notes. Plus, is it on record? Counter affidavit of Sponpur.
Have they passed order?
Lots, they have brought it on record with the counter affidavit.
Challenge it.
Filed interlocutory application lots.
Where is that order?
Lots annexure. Lots D page 37.
Page?
37. Lots I don't have the running page because it is a affidavit, counter affidavit on behalf of respondent number 2.
I can't understand this.
And
file translation. Copy.
Was my friend fearing for
All right, he has to file. Who is that? None appears for the response.
The only objection was, in nutshell, I may say, the only objection is that since the Honorable Supreme Court in one of the proceedings has said that the order passed by the Honorable Supreme Court would not be a precedent for the others, the petitioners, though similarly situated, are not entitled to the benefit.
What is the grievance of the petitioners?
Plus, it is they claim that whatever plus there were 19 sugar factories under the Bihar State Sugar Corporation.
Sir, what is their grievance?
Grievance is to pay for calculation of the retirement benefit, at least taking into account the retention allowance.
Retirement benefits.
My words. Taking into account the retention allowance, what has been given to other lots seasonal workers of other similarly situated lots units.
The other side is not there. You are appearing.
Sir, I am appearing for respondent number of the corporation number.
What is this annexure D?
Sure.
D.
To your counter.
Notes, I haven't. That is perhaps not my counter. That has been filed on behalf of the state government. Notes.
You are not state.
No, I am the corporation.
Who is appearing for state? And appears for state. Release this matter after 2 weeks. The meanwhile, State Council is hereby directed to furnish a translation of Annexure D on the next date of hearing.
Serial number 23 and 24 are adjourned for 4 weeks. Serial number 25, Vishal Kumar versus the state of Bihar for the petitioners Sri Dishan Kumar Sinha.
In 25, Lordship, I am.
You are responder 4 and 5?
Lordship, I am appearing.
The responder 4 and 5?
Yes, sir. Post Lordship.
सीनियर दूसरे कोर्ट में एंगेज है सर, सीनियर दूसरे कोर्ट में एंगेज है।
State Bank of
ये सब कुछ पता नहीं है सीनियर अलग कोर्ट में एंगेज है दूसरे कोर्ट में
His senior is engaged in other court. He said.
Alright. This matter after 2 weeks.
Serial number 26, the chairman Uttar Bihar Gramin Bank versus the Appellate Authority in the Payment of Gratuity Act 1972.
similar issues involved in item number 1 item number 1 similar issue is involved whether the service rules will govern or the payment of gratuity act that notices were issued by your lordship sir in this case also
issue notice to the rest.
Notices have been issued
Then
service report has come probably it appears but the private respondent has not appeared so far it appears to me.
Await service of notice. No, respondent 3 has died. You have to bring LRs on record.
I will take a step for
service of notice reflects the service of notice the respondent 3 reflects from the office note that respondent 3 is stated to have died. Therefore, learned counsel for the petitioner is hereby directed to file a substitution application. List this matter after 6 weeks.
Serial number 27 is adjourned for 3 weeks. Serial number 28 is adjourned for 4 weeks. Serial number 29 is disposed of. Serial number 30 is adjourned for 4 weeks. Serial number 31, Krishna Nandan Jha versus the State of Bihar for the petitioner Sri Amit Kumar Anand.
25.
On last occasion, a counter provision filed on behalf of the district magistrate. That is on record. Para 11, we had stated that press notices have been sent to the company, official of the companies to appear before the certificate case. Notices may be issued to the respondent number 12, 13, 14 and 15 in this case.
Notice
sorry my lord Police Minister Dilip Kumar my lord he is on leave
Notice has not been issued.
You noticed respond but 12 to 15 necessary requisites shall be paid submitted in the registry within a period of 2 weeks.
Serial number 32 is disposed of. Serial number 33 is adjourned for 3 weeks. Serial number 34 is adjourned for 1 week. Serial number 35, the chairman of the Bihar Gramin Bank versus the Appellate Authority for the petitioner Sri Kumar Anand.
I'm appealing for the respondent number 3, Lordship. At the outset, I'm taking objection of the non-meritority of petition. The deponent is not authorized, Lordship. The deponent is not authorized to swear oath. No document has been annexed with the writ petition to show any resolution or any order passed by the bank to show he is an authorized person to swear oath on behalf of bank. The petition is filed on behalf of Chairman, Lordship.
Who has filed affidavit?
He's a senior manager.
Senior manager in law department.
Senior manager law.
Where is the authorization?
Statement that I am authorized to file and swear affidavit.
Correct. Where is the authorization given by the chairman?
I was not expecting that this objection will be taken, otherwise I will be producing my lord on the next date.
And counsel for the petitioner is hereby directed to furnish a copy of the authorization given to the senior manager within bracket law Prasad Yadav to present this petition. Release this matter after 2 weeks.
Serial number 36 is adjourned for 2 weeks. Serial number 37 is adjourned for 1 week. Serial number 38 is passed over for the day. Serial number 39, Sarkar Ganesh Dutt Memorial College versus the State of Bihar for the petitioner Sri Sasi Bhushan Singh.
May I please, Your Worships. In this case, Lords, basically the college in hand is an affiliated unit of
college.
College in hand, Sir Ganesh Dutt College is an affiliated unit of the Patna University. And as per section 16 of the Act, this college will not come within the purview of the EPFO Act. Section 16, and in this case, Lords, I have filed to
16 of EPF Act.
Section 16, Lords, Employees Provident Fund and Miscellaneous Provisions Act 1952, Act not to apply to certain establishments. B. To any other establishment, one can be to any other establishment belonging to or under the control of the central government or a state government and whose employees are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rules framed by the central government or the state government governing such benefits. Basically, Lords, Bihar State University Service Act 1976, Section 56, 59, Subclause 6, Bihar State Universities Act. And moreover, in this case, notices are required to be issued to the private respondent for implement of whom an interlocutory application has been filed, Lords. Initially, it could have not been filed.
One of the workers, my lord, has participated in the 7F proceeding and he has also appeared before the tribunal, my lord. He is a necessary party in this case.
He has not been added as party.
By way of filing amendment petition, I have saved the leave of this honorable court to allow him to be implicated as a respondent, Lords. Most probably it should be IA number 1, Lords. Bihar State Universities Act.
Let him come on record. IF for including, what is the name of Sanjeev?
Sanjeev Kumar, yes, my lord.
Heard IA 1 of 2.2. Read Sanjeev Kumar as the necessary proper party. Come up full stop. The necessary and proper party for the reasons that before the which authority?
CGIT, my lord. CGIT as well as the 7A authority also.
CP?
Central Government Industrial Tribunal, Dhanbad, as well as the
and
the authority under Section 7A.
And before EPF authority. Therefore, he has the necessary and proper party to the present list. Accordingly, IA stands alone. He is hereby directed to carry out necessary amendment in incorporating Sanjeev Kumar name as the respondent 10 during the course of the day. Necessary requisite shall be paid within a period of 2 weeks for issuance of notice to ninth respondent and 10th respondent.
Stop proceeding.
My lord, I have filed interlocutory application for being added as intervener respondent.
What is your name?
My name is Avnendra Kumar Jha. I am representing Jai Avnendra Kumar Jha. I have filed.
What is your locus?
My lord, I have filed. I am the teacher in the college, and my submission is with regard to the fact that the action of the authorities of the EPF is not in the benefit of the teachers. So, if the college will be compelled to comply with the directions of the EPF, the college will have to withdraw the beneficial steps which have been taken for the benefit of the teachers concerned. And otherwise also, the EPF Act will not cover the institution which is under question, my lord.
Then you question the EPF authorities' action.
My lord, that's why I am here, my lord, since I am also...
As a respondent, you can't come here.
My lord, I have the order impugned, by order impugned, the accounts of the college has been confiscated, freezed, my lord.
All right, you file a fresh writ petition.
That I will.
You have already filed IA for intervening?
Yes, my lord.
I rejected.
I have also...
It is between the employer and, institution management and the EPF authorities. Whether the institution would come under the EPF jurisdiction or not.
And since I am the teacher in that institution and the...
You file your independent writ petition.
And I may be granted liberty to mention that writ petition if... I may be granted liberty to mention that writ petition, my lord, if it is...
what is your IA number?
IA number IA 3 of 23, my lord.
IA 3 of so and so heard. Full stop. Proposed applicant intends to come on record in support of petitioner's relief, since he is one of the teaching staff of the petitioner institute. To stop. In the present case, grievance of the petitioner is EPF authorities. Applicant has proposed applicant has no locus in the form of intervener. Accordingly, IA stands rejected, reserving liberty to file fresh petition.
Lords, one more IA has been filed, Lords, IA number 4 of 2023, wherein I have assailed the order whereby assailed the action of the EPF authorities whereby bank's operation has been restrained. 51 lakhs has been.
51 lakh is nothing.
Lords, college is
the order of assessment is appealable before the tribunal. It is the order of applicability, my lord, which is under challenge before Lords, my lord. The order holding the act to be applicable upon them is under challenge before Lords. The meanwhile, my lord, there was...
They have already invoked remedy of appeal before the appellate authority.
Appellate authority against the order of applicability, my lord. Subsequently,
there is no interim order.
There is no interim order. Lord, subsequently, there is an order of assessment because one bench of this honorable court has directed in a petition filed by one of the employees whom your lordships have just noticed that the benefit may be extended to him. Subsequently, my lord, an assessment order has also been passed, my lord, and that order of assessment is subject to challenge in appeal before the appellate authority. My friend is seeking a stay of that very order, my lord. The recovery option is pursuant to that order.
Will not be stayed. Next.
Notices both mode, Lords. Notices
both mode.
No IA4 is showing on record.
Serial number 40 is adjourned for 4 weeks. Serial number 41, Almia Cement Bharat Limited versus the recovery officer for the petitioner Sri Yadav Sundar.
In this case, my lord, I am appearing on behalf of the employee state insurance contract. There is some. I pray for 4 weeks time allowed to file counter affidavit.
Counsel for the respondent intends to file counter affidavit. Release this matter after 6 weeks.
number 42, Sun Pharmaceutical Industries Limited versus the State of Bihar for the petitioner Sri Manish Kumar.
May it please, my lord. Lord, this short question that is involved is, my lord, if an employee claims to be some low-level union functionary, then is he immune from any order of transfer that has to be issued by the management in accordance with the condition of service? What has happened in this case?
He has challenged the transfer.
He has challenged the transfer. And what
from where to where?
He was posted from at Siwan in Bihar.
To?
And Shimoga.
Where is it? Shimoga.
Shimoga is in Karnataka. Now, from 2007 July, he was posted at Siwan. And
July 2007?
He was posted at Siwan. And as per the terms and conditions of his employment, his services could have been transferred anywhere. Now, he was transferred in 2014, August. Now, he questioned the transfer order.
No, you just now he said 2007.
2007, he was appointed.
Appointed 2007, transferred in 2014.
2014. At one place, he had remained for good 7 years at Siwan. Now, the moment the transfer order was issued and he was asked to comply with it because the transfer order is in accordance with his conditions of service.
Now, in the order of appointment, have you imposed the condition it is a transferable post?
Yes. Therefore, I'm saying in the appointment letter, there is a clear stipulation. That
all right. Now, what is?
Now, what he did was he went and challenged this transfer order, and the ground on which he said that I am some joint council convener in some union, and therefore I am a union functionary, and I was agitating with regard to employees, etc. And therefore, it seems the management has transferred me with malified intent. And on this ground,
is there any bar if a member of the joint committee come?
There is no bar. There is no bar in law and even otherwise that even if some employee joins some union as some council convener or whatever.
Is there any bar by any rule or a statute? Nothing.
No bar at all. If his services are transferable, he knows it, then he has to comply with the order of transfer.
Now, was there any interim order staying the operation of transfer order?
No. There was no interim order. He did not comply with the order of transfer. Although we carried out a disciplinary proceeding against the employee for defying the lawful order of transfer, but we did not inflict any punishment. We kept it on hold. We did not dismiss him, terminate him from service. Now what he did...
There is no provision for suspension also?
Because he was not reporting at the transferred place, he was on no work, no pay, because he was absenting from the place where he was transferred. So by suspending him, we would have qualified him for the subsistence allowance, etc. So the management did not suspend him, and I personally feel right.
And why you did not complete the inquiry proceedings?
We completed the inquiry proceedings.
Impose the penalty.
But we did not inflict the punishment. We kept it on hold because in the meantime, what he had done was he raised this dispute, and the matter was referred to Labour Court Chhapra. And now Labour Court Chhapra has passed an award setting aside the order of transfer and granting him relief of reinstatement, although he was never removed from service, he is still in service, and with 50% back wages. This is the issue involved.
What is the date of Labour Court order?
The Labour Court order, Your Lordship, is... And now, Labour Court order is 27th June 2022. Passed in reference case number 1 of 2016.
Have you prayed for interim order?
Yes, my lords, I have.
Yes, take that. You are appearing for?
State, my lord. Private respondent number 2 has also made party.
Issue notice to the
made party in this case.
Respondent number 2.
Inquiry was conducted against
mode. Necessary requisite shall be paid within a period of 2 weeks. In the meanwhile,
Respondent number 2, my lord,
passed by the Labour Court
in this case.
My lord, we have also filed an application for 17B compliance.
All right, we will consider that. Stay of award dated so and so, passed by the Labour Court so and so, till next date of hearing. The petitioners are hereby directed to file their objections to 17B application before the next date of hearing, list after 4 weeks. Note 19. For respondent.
Appearance, sir, कर दीजिए.
Yeah.
Serial number 43, Mrs. Kumar Enterprises Private Limited versus the Union of India for the petitioner Sri Kumar Singh.
Yes, my lord, I am appearing on behalf of the employee state insurance company, the respondents. I appear for 4 weeks time to file counter petition.
4 weeks time.
I am from the side of
And counsel for the respondent, Mr. So and so seeks 4 weeks time to file counter affidavit if listed matter after 8 weeks.
Lordship, one small prayer, Lordship. Actually, Lordship, after filing this case, the recovery proceeding is still going on, Your Lordship.
What proceedings?
Recovery proceedings are still going on, Your Lordship. And the recovery officer, which is the crux of this case, he is pressurizing the bank to part with the money to ESIC, which will cause great inconvenience to the petitioner, Your Lordship.
Let him file counter affidavit.
Lordship, I pray for, restraining recovery officer from.
No, if you succeed, it will be refunded to you along with the interest.
Lordship, the business will be affected, Lordship. We are in business, Lordship. And already Corona had affected hotel business a lot, Your Lordship. And it will further affect, our business, Your Lordship. And
you file it within 2 weeks.
Balance of convenience lies in our favor, Your Lordship.
Within 2 weeks, file.
Lordship, my humble prayer, Lordship, he should be restrained for that 2 weeks period, Your Lordship. Till that 2 weeks period, at least, Your Lordship. Learned counsel for the department.
No. Yes, make it 2 weeks. कौन सा 44?
Yes, sir. There are 44 Financial Power Holding versus Suraj Ragai for the petitioner's fee reviewers.
One of the petitioner have challenged the award dated 28/7/2022 passed by the learned presiding officer Labour Court Begusarai in reference case number 2 of 2007, my lord, whereby the Labour Court had awarded payment of wages to the coal unloading mazdoors of petitioner company at par with grade B semi-skilled workers. And we have, my lord, we have challenged the award on the grounds that the reference itself is bad, my lord.
Then you should have challenged the reference. Without challenging reference, how can you say reference itself is bad?
My lord, the Labour Court has gone beyond the reference which was made.
All right.
Which was made to it.
Like that you can say. Reference itself bad, you can't say.
I am saying that the Labour Court has gone beyond the reference which was made to it. And moreover, my lord, the reference is at, my lord, at page 58. Page 58, the English version is at page 58, my lord, type copy. Is annexer P4. My lord, the reference made here is whether non-regularization of service and non-solvability of problems as pay and only etc. of semi-skilled B category workmen by the management Baroni Thermal Power Station Baroni is justified.
What is the post held by the respondent workman?
My lord, they were coal unloading mazdoors. They were not semi-skilled grade B semi-skilled workers. They were coal unloading. My lord, in thermal power, the power generating companies, my lord, there are workers who are engaged in loading and unloading of coal because it is run on coal, my lord. And their services were regularized.
Then you should have questioned the reference. Why you did not challenge? Reference itself is wrong according to you.
I may be allowed to make that.
No. After these many years, 2007 reference.
My lord, Labour Court has no jurisdiction to entertain this reference, my lord.
Why?
My lord, may I kindly come to section 10 of the Industrial Dispute Act, my lord. I may be allowed to place it. Section 10 prescribes the reference of disputes to board, courts or tribunals, my lord. Section 10, subsection 1 says that where appropriate government is of opinion that any industrial dispute exists or is apprehended, it may at any time by order in writing, the relevant is C and D, my lord. Clause C and D of the subsection 1. Refer the dispute or any matter appearing to be connected with or relevant to the dispute if it relates to any matter specified in the second schedule to a labor code for adjudication, or D. Refer the dispute or any matter appearing to be connected with or relevant to the dispute whether it relates to any matter specified in the second schedule or the third schedule to a tribunal for adjudication. And the next paragraph says, provided that where the dispute relates to any matter specified in the third schedule and is not likely to affect more than 100 workmen.
Now show me from the schedule
that
this issue will not fall under any of the schedule.
My lord, it falls under third schedule, my lord. And the workmen involved are in number of 269, my lord. So the reference would have been made to the tribunal instead of labor code, my lord. Schedule 3 may be.
That is the reason you are not questioned this. At this belated stage, how can you question?
I may be allowed to amend the prayer.
No.
Add a prayer in this, my lord.
No, sir.
In the meanwhile, notices may be issued and I may be allowed to make an amendment, my
You are
lord.
not supposed to, we will not permit you. 2007 reference, you can't question.
We have taken that stand in our pleadings, my lord. We have taken that stand in our pleadings.
Taken, but there is no challenge. You should have challenged into within 2010, within a reasonable period of 3 years. And you have surrendered your jurisdiction before the labor court or industrial tribunal.
There is one more ground which, my lord. In 1982, the coal unloading workers' services were regularized by the petitioner company, my lord. And they were regularized under a terms and condition which were an agreement was entered into between the union and the company. That agreement still stands. And there was
regularized under that
in that agreement, their wages were terms and condition of their wages were enumerated and which was agreed upon by the union itself. And that
you first regularize them in terms of 1982 policy. Let us then we will see.
They are regularized, my lord. Their services
are regularized.
Services were regularized in 82 itself.
Then what is the basis for claiming semi-skilled?
After regularization, they demanded that there should be paid their wages in the pay scale of semi-skilled at the par with semi-skilled B category.
What is the basis?
My lord,
they claim as semi-skilled.
They claim that because their work is more hazardous than those workers, their health risk is more than that. That's why they should be paid more, or at least at par with them. But my lord, the difference is...
No, have you compared with any other identical industry where the pay has been granted to the loader and unloaders?
No, my lord.
Then you compare with that.
I do that, my lord.
No, these are all working places are not healthy and other things. You should be very fair.
We have given other benefits also in the terms and conditions which were agreed upon in 82, my lord. I have placed that all the terms and conditions of that agreement also. The medical benefits are there and compensation are there. But they are saying that they should be paid a regular pay scale at par with the other workers. My lord,
where is the structure?
My lord, the working condition is different.
Sir, where is the staff structure?
My lord. Staff structure, my lord. I didn't get a staff structure means.
For example, skilled worker, semi-skilled worker, their pay scale or whatever the wages they are granting, and other than that, only workman. What is the wage? You have to produce that.
That is not on the record. I'll bring it on record. I'll bring it on record. The whole structure of what in what category workers are getting what payment and pay scale.
Take down. The petitioner is hereby directed to produce relevant material to show that respondents were not entitled to wages or pay scale attached to the post of a semi-skilled B category workman to stop. In order to appreciate the aforesaid contention, it is necessary to take note of cadre structures and pay scale attached to each of the posts, like skilled, semi-skilled or workman. What are the pay scale or wages is being paid? To stop. He is also hereby directed to ascertain identical industries are paying wages to similarly situated person. To stop. In order to streamline in order to understand the streamline of wages being paid to skilled, semi-skilled or workman, since the nature of work which were attended by the respondent is under the coal mining.
Coal unloading and unloading.
Coal mining only.
Not mining.
No, under the coal mining project.
Power generating project. Power generating. They unload and load from the rail wagons, train wagons, they load and unload the coals.
Instead of coal mining relating to coal industry. Matter after 2 weeks. No. First you produce that.
Publish.
Serial number 45, 46 and 47 are adjourned for 2 weeks. Serial number 48, the chairman of the Bihar Government Bank versus the Union of India for the sessional secretary Prabhakar.
Just now get order Milord. In other case also I had raised one question before your order. Whether in terms of regulations of the Milord bank, the private restaurant employee of the officer of the bank, and there is a specific regulation 72E that the officers are not entitled for payment of gratuity.
Compulsory retirement. Have you preferred LPA?
Milord, no, I had in other honorable bench, Milord, the matter has been considered. If your lordship go through the Milord, paragraph 4 of the judgment, though his lordship has taken infirmity of the other judgments, he has disposed of it, but he has dealt with everything, and with his judgment and has
No, where is the distinction in respect of compulsory retirement and in normal retirement?
Not on that point. Whether the Milord on the payment of gratuity.
Have decided only on that issue, compulsory retirement and normal retirement.
In that case, that was another case. But not only your judgments, but there are other judgments also. Whether it will bring a special law, it will prevail and authority of the Milord Payment under Gratuity Act has right to decide the claims of the officer in the case of Milord punishment. That is under consideration before your lordship. That was.
No, what is the issue here in the present case?
Here, Milord, the appellate authority, Milord, under payment of gratuity act, the authority, Milord, initially it was allowed, we preferred appeal after deposit of the amount. He has, Milord, allowed the appeal. Against that we have come. But, Milord, my specific question is that once the payment has been done under regulation of the bank, which is a special law, whether the authority of the Gratuity Act, which is a general law, has a right or not to decide the claim.
No, you have already paid gratuity under the bank law.
Bank law. And there is no provision of appeal in bank law. Then he has
accepted.
No, he has accepted. He has not finally disposed of, but he has.
Under the bank law, you have paid the gratuity amount.
Millard, it was not payable to him. It was not payable to him. And we have challenged this before the authority also, but Millard, he did not pass any order on this point.
Where is that provision of law under the bank?
72E, Millard.
72E. Where is that?
So it has been quoted in the judgment also. It had provision at page Millard.
It is here.
He also because.
In the present case, respondent, fourth respondent Vidyasagar Prasad, he has been terminated.
He has been compulsory terminated.
Compulsory retirement or what?
In departmental proceeding.
Compulsory retirement. Same order. How is it permissible?
Millard, once there is no provision of appeal under the Millard regulation against the order of Millard payment of.
Sir, all right, sir. Under section 72 of your own bank regulation, regulation 72. Retirement. That's all.
It says, Millard, that if there is employee and officer, there is difference in regulation 3. That has been considered by his lordship.
Sir, punishment only termination.
No, it is compulsory.
No, the gratuity can be withheld by the bank only in invoking 72E termination in any other way except a way of punishment and after completion of 10 years of service.
Millard, if payable, here by way of punishment, he has been awarded punishment after Millard compulsory retirement.
Sir, there is under section 72, there is no compulsory retirement.
It is not a but sir, if not in Millard, if it is not by way of punishment, termination not by way of punishment, that event only he is entitled.
No, sir, I don't agree.
Let them file.
You better go take up this matter before LPA bench. I will dispose in terms of our earlier order. Give that judgment.
Cannot be appealed, but here he also was considered in this.
No.
Those judgments, there is one judgment order passed by your lordship. There is no judgment in my case.
You take up this matter before LPA, sir. Is take down in the instant petition. Petitioner has prayed for the following relief. Fourth respondent was subjected to disciplinary proceedings and he was punished while imposing the penalty of compulsory retirement. So, question for consideration is whether fourth respondent is entitled to gratuity or not. Please stop. In identical matter, in the case of so and so, it is held that compulsory retirement punishment would not come in the way of payment of gratuity. In the light of the aforesaid decision, the present petition stand dismissed.
कल की ऑर्डर शीट तो है नहीं। Why was this case listed today?
मतलब
ये कल लग रहा था केस?
कल स्टेट का अपीयरेंस नहीं हो पाया था, जिसके चलते आज आया।
स्टेट का
कल अपीयरेंस नहीं हो पाया था मेरे तरफ से, स्टेट के तरफ से, इसलिए आज
सेटल तू।
हाँ सेटल तू। Sit aside.
What happened? You have been appointed or not?
Yes, set aside हो गया हो जो इसमें.
Huh?
बीस 18 है. बीस 20. इसको कॉपी हमको दे देते तो इंस्ट्रक्शन दे देते. देखिए ना, देख लीजिए. 10,000 करोड़ का मामला.
So what is this case? क्या डिसाइड हुआ है ये?
देखिए क्या डिसाइड करेंगे. इसको जो पास ओवर कर दिया जाएगा कल है से कर देगा. मिस्टर आर्गुइंग काउंसिल ने validity of rule was challenged, your lords. Validity of rule 6 and 8 of the teachers appointment rules 2000.
You are taking. See the prayer. Where is that validity of rule challenge?
नहीं ऑर्डर नहीं था. ऑर्डर
ये जजमेंट तो आप सुप्रीम कोर्ट का कोई जजमेंट बता रहे हैं.
अभी पिटिशनर को डायरेक्शन था अभी लाए हैं. यस
क्या है ये? What you want to see from this judgment?
मिस्टर आर्गुइंग काउंसिल नॉट अवेलेबल है. आ रहे हैं.
अच्छा, आर्गुइंग काउंसिल someone else.
यस.
You are asking for same pay. What are you asking for? पास ओवर कर दे.
यस.
आप भी नहीं बता पा रहे क्या?
जस्ट अभी अवेयर हुए हैं.
नॉट दी वे यू हैव टू असिस्ट दिस कोर्ट. सॉरी. पास ओवर करिए. आप पढ़िए केस में क्या है. व्हाट इज द केस?
Item 3, Bishop Prashant Sinha.
Lord, this case was heard by your lordships yesterday. I have challenged the decision of the state government contained in Section 15, whereby the decision of the university regarding confirmation of our services has been rejected by the state government. Section 14, page 46 is the order under challenge, my lord. And Section 13, page 44 is the decision of the university.
Yes.
Lordship, appointment of the teachers is not recommended from the commission, Lordship, without approval, Lordship.
But you have made an amendment in the rule, no? 57. That is what you were showing.
Yes. Annexure 11, page 41.
What do you say about this amendment? And the university has formed a committee. It has made selection. Where is the director? Yes, there is another case also today of same nature. Four. We had called you in that case. उसमें आया बुलाया था जी मैं बुलाया था उसको बुलाया था
41
बिहार गजट 2015
See, you have passed an order. The other case at annexure B,
yes,
which was brought to our knowledge. Please see that letter.
Yes.
It seems that you have signed it on dotted lines. Second last para. अंकनीय है कि बिहार राज्य विश्वविद्यालय संशोधन नियम
57A क की उपधारा 6 के अंतर्गत चयन समिति से संबद्ध डिग्री महाविद्यालयों के शिक्षकों के निमित्त महाविद्यालय स्तर पर अनुशंसा देनी होती एक नई संस्था यथा चयन समिति का प्रावधान किया गया। इस अधिनियम के प्रस्तावना से स्पष्ट है कि उपयुक्त चयन समिति छात्र उत्तीर्णता के आधार पर दिए जाने वाले अनुदान से संबंधित संबद्ध डिग्री महाविद्यालयों में वैसे शिक्षक जिनकी नियुक्ति कॉलेज सेवा आयोग की अनुशंसा से प्राप्त नहीं है ऐसे शिक्षकों की नियुक्ति के लिए जांचोपरांत अनुमोदन का प्रावधान
किया गया है।
जी।
So that has been done. They have recommended.
No,
after conducting through a screening committee, if they have recommended their cases to you, you have rejected it just saying that this provision is there.
My lord, before किसी भी निर्णय पे पहुंचने से पहले मैं न्यायालय के सामने कुछ बात रखना चाहूंगी और यदि आप परमिट करें तो मैं शुरू जी जी मैं आभार व्यक्त करती हूं पहले तो आपका सर कि आपने हमें बुलाया और मौका दिया है सरकार को अपनी बात रखने की। जहां तक सवाल है ये चयन समिति की सर सॉरी माय लॉर्ड तो मुझसे भूल हो सकती है सर निकल जाएगा।
Don't worry. You tell whatever you have to say on fact.
तो चयन समिति का जो यहाँ हम लोगों ने बनाया है ये वैसे वित्त रहित शिक्षा नीति जब समाप्त की गई थी 2007 में तब सरकार ने इस तरह का प्रावधान किया वैसे शिक्षकों के लिए जहाँ जो एफिलिएटेड कॉलेज में कार्यरत थे और जिनकी अनुशंसा विश्वविद्यालय कॉलेज सेवा आयोग से नहीं हो पाई। मीन टाइम चूंकि बहुत ज़्यादा हंगामा हुआ था शिक्षकों ने बहुत जोर डाला था तो सरकार ने वित्त रहित शिक्षा नीति अपनाया और तब वैसे कॉलेज में जो कार्यरत कर रहे थे शिक्षक उनके लिए ये हम लोगों ने प्रावधान 57A में 6 उपधारा के तहत किया ताकि उनका भी वो भी अपने जो हमारा जो सैंक्शन पद है उस पर उनकी अनुशंसा हो सके और उनको हम दे सके परफॉर्मेंस ग्रांट जो देते हैं माय लॉर्ड वो बजट में नहीं आता है उसके लिए अलग से प्रावधान होता है और उसके लिए हम लोगों ने विश्वविद्यालय को ही अधिकृत कर रखा है कि वही उनका जो है वो चयन करेंगे और उनके लिए एडवर्टीजमेंट निकालेंगे और उनका सेवा संपोस्ट करेंगे। तो इस नियम के आने तक सरकार ने अपना जो पावर था समांजित करने का वो विश्वविद्यालय को दे दिया था। अब सवाल जो ये टीचर जिन लोगों का 67 शिक्षकों का जो अभी केस हमारे न्यायालय में है वादी ने जो प्रेयर किया है उसमें उनकी नियुक्ति 28 फरवरी 82 के में हुई थी तो 1982 में हुई थी। तो वैसे शिक्षकों का था कि उनको उसमें हमारा जो 35 को देखा जाए माय लॉर्ड हमारा जो 35A एक मिनट पहले 35 है उसमें ये लिखा हुआ है कि 35 ऑफ विश्वविद्यालय सेवा मेरा जो एक्ट है 1976। एक मिनट पहले 35 एक्सप्लेन कर लेते हैं फिर 35(2) करेंगे। उसमें सैंक्शन पद जो सरकार के द्वारा जो पद सैंक्शन किया गया no post can be created before
let's have a look at that.
Yeah 35 देखा जाए एक्ट एक मिनट मैं बता दूंगी सब आई नो
No post for appointment shall be created without the prior sanction of the state government.
My lord. और सेकेंड 2 में 35 का 2 देखा जाए माय लॉर्ड,
Yes.
उसमें 6 मंथ के लिए दिया गया है कि नॉट एक्सीडिंग 6 मंथ के लिए रखा जा सकता है, और उसके बाद उनका जो है उनका कंकरेंस जो है सरकार को वो भेजेंगे और सरकार उसको ओके करेगी। तभी हो सकता है जब उनका एडवर्टीजमेंट, वो भी 6 महीना रखना था एडवर्टीजमेंट और अंतर्वीक्षा से टेम्परेरी टीचर, और उन टेम्परेरी टीचर को इन लोगों ने रखा यूनिवर्सिटी ने, और इतने सालों 2011 तक उसका वेतन बजट में बना के भेजते रहे और कंकरेंस के लिए नहीं गए। कंकरेंस इतने सालों तक 28 सालों तक यदि उन्होंने कंकरेंस के लिए नहीं किया जब तक हमारा विश्वविद्यालय सेवा कॉलेज सेवा आयोग था। इससे ये साफ परिलक्षित होता है कि उस वक्त जरूर उनके पास अर्हता नहीं रही होगी और इसलिए वो कॉलेज सेवा आयोग में नहीं गए। हाँ, कॉलेज सेवा आयोग में कंकरेंस
नहीं रही होगी मतलब there was no requirement.
नो सर,
अहर्ता का मतलब क्या है?
अहर्ता इन एलिजिबिलिटी, जिस समय उस समय जो
these people may not be having the eligibility.
ये मेरा
That is the presumption.
ये my presumption, but
that is the presumption of the government.
Yeah, government.
Because they did not possess the eligibility criteria, so they did not send it to
और
the
6 मंथ के लिए भी जो उन्होंने रखा वो उसको एक्सटेंड करते रहे इतने वर्षों तक, और सरकार के संज्ञान में नहीं आ पाया। सरकार के संज्ञान में आया 57A, सरकार के संज्ञान 57A में है। मैं जो बोली ना 57A में है, तो सरकार के संज्ञान में ये जो 35 है 6 मंथ के लिए है, और 57A जो इन्होंने अभी मुझे बोला है वो 57A निकाला जाए।
ये
हाँ, वो परमानेंट टीचर्स के लिए आयोग रहेगा, आयोग के द्वारा होगा। आई नो है।
Yes. 57 is appointment of teachers in universities, right?
Yes.
And 57 capital A is
57
57A में है affiliated college not maintained by the state government and made by management.
Yes.
Yeah. तो 35 जो मैंने कहा था सर,
that you have already said.
या 35 एक्ट में सर देखा जाएगा सर, 2 कॉलेजेस है, एक जो गवर्नमेंट से कंट्रोल होती है और दूसरा है लिंग्विस्टिक एंड माइनॉरिटी के बेसिस पे। तो ये जो कॉलेज हमारे हैं संस्कृत वाले, ये लिंग्विस्टिक्स के बेसिस पर हैं और इसी वजह से ये लोग एफिलिएटेड कहलाते हैं यूनिवर्सिटी से। तो 2 तरह के एफिलिएटेड कॉलेज हो गए सर, एक हो गया माय लॉर्ड, एक हो गया जो लिंग्विस्टिक ग्राउंड पे बने एफिलिएटेड टू यूनिवर्सिटी हुए, और दूसरा जो हमारा हुआ एफिलिएटेड कॉलेज जिसमें हम परफॉर्मेंस ग्रांट देते हैं विथ रही 2008 के या 7 के पूर्व जो हमारे 8 के पूर्व जो हमारे कॉलेज एफिलिएटेड थे उनको आज भी हम परफॉर्मेंस ग्रांट, यानी कि जो बच्चों का रिजल्ट निकलता है उसके आधार पर हम उनको परफॉर्मेंस ग्रांट देते हैं और यूनिवर्सिटी को भेजते हैं।
We are dealing with linguistic colleges.
ये जो ये linguistic.
So for them, what is your policy?
ये इसमें इनका वेतन एफिलिएटेड है, एफिलिएटेड कॉलेज घाटा अनुदानित है ना, इनको हम लोग घाटा अनुदानित के ये में रखते हैं, श्रेणी में रखते हैं, और इनका बजट आता है हमारे यहाँ और उस बजट के आधार पर इनका पेमेंट जाता है, यूनिवर्सिटी को अनुदान जाता है, और अनुदान जब यूनिवर्सिटी को जाता है अनुदान फिर इनकी सैलरी यूनिवर्सिटी इनकी
सैलरी। So their salary is paid from the grant which is released from the government.
और यूनिवर्सिटी पे द सैलरी ऑफ दोस टीचर्स. It's not the government who pays the salary.
So but the grant has been released for them.
No. We didn't.
That is why they are here.
Yes. इसका रीजन ये हुआ कि 2011 तक तो सरकार के संज्ञान में ये बात थी ही नहीं कि ऐसे शिक्षक जिनका कंकरेंस कॉलेज सेवा आयोग से नहीं है वो कार्यरत हैं अभी भी। जब हमने उसमें एक कॉलम जोड़ा 2011-12 के बजट में कि ऐसे जो भी शिक्षक का आप नाम भेजें, एक कॉलम बनाया कि उसमें आप लिखें कि ये अनुशंसित हैं कि नहीं, कॉलेज सेवा आयोग से इनका कंकरेंस है कि नहीं, या विश्वविद्यालय सेवा आयोग से कंकरेंस है कि नहीं। तो इन 67 टीचर्स का जो बजट हमारे पास आया उसमें नो लिख कर आया। तो फिर विभाग इस पे गहन अध्ययन किया, समीक्षा की और पाया कि इन 67 शिक्षकों का तो कंकरेंस है नहीं कॉलेज सेवा आयोग से, तो यहाँ से बजट उनका बंद कर दिया गया। हमने सैलरी हम देते नहीं है, वी गिव ग्रांट।
So you
सैलरी
have
विश्वविद्यालय देती है।
Stop their grant.
ग्रांट, हाँ, उस
Then-
नाम हमारे यहाँ से
Then
सर
what
ग्रांट-
was the next step which
सर
was
हमारे यहाँ
required?
से जो ग्रांट जाती है सर समेकित, जो
All right, we have understood.
विश्वविद्यालय पद बताता है उसके अनुसार से हम लोग मल्टीप्लाई करके उतना पैसा उनको भेज देते हैं
और-
ग्रांट के रूप में, और वो फिर उसको सैलरी को डिसबर्स करते हैं।
So against their post, you have not released the grant.
Yes.
Now, after this 57A, which has come into force from 2013.
Yeah.
They have been screened by the university.
Yes.
And after screening, the university has sent for recommendation.
By the time हमने पावर तो
Will 57A not apply to them?
Yeah.
Will it apply or not?
No, it will not apply on those teachers,
Why?
on those colleges, because
Let us read 57A.
yeah, of course.
Whether it excludes them.
Yeah. It is already written, affiliated college not maintained by the state government.
Subject to provisions of this act. Let us read this 57A. Please read it. वकील साहब आप पढ़ो.
आप पढ़िए 57. आप पढ़िए ना, आप आइए.
Whoever is to read, please. Let us understand from you. So that's why we are asking you to read it.
57.
इसमें हुजूर there are two types.
Let us know first 57A.
No, आप read करिए ना इसको.
थोड़ा सा हम बैकग्राउंड बता देते हैं।
अभी बता दिया ना इन्होंने, गलत बताया है कि
तो उसको क्लैरिफाई हम कर देते हैं हुजूर।
पहले आप 57A पढ़िए। Don't avoid the issues which are there before the court.
57A हुजूर पहले का है, subject to provision of the act statute made there under appointment of teacher of affiliated college not maintained by the state government shall be made by the management of the college.
कहाँ पढ़ रहे हैं आप 57A? तो ऐसा नहीं है।
57A हुजूर ये
कैपिटल A पढ़ना है, 57A पढ़ रहे हैं।
मिलोट ये बिफोर अमेंडमेंट ऑफ 2007।
57 कैपिटल A पढ़ रहे हैं आप, 57A पढ़ रहे हैं।
अमेंडमेंट है।
57A पढ़ रहा हूँ।
57 कैपिटल A पढ़ी।
मिलोट कैपिटल A बिफोर अमेंडमेंट ऑफ 2007 मिलोट। 2007 amendment has been made. And there
the council, when we are asking you what is the amendment made after 2013,
Milord.
Perhaps you have understood what the court is asking.
Milord.
If you try to avoid the query of the court, we will throw you out from the court.
Milord.
I am not going to allow any kind of such kind of behavior.
56, 57.
Yes, madam, you read it. You read this. हटाइए इनको.
Yes.
He is the government counsel?
No.
कौन है? You are the who is the GC here? Who is the GC? नहीं, आपके गवर्नमेंट काउंसिल कौन है? आप पढ़िए. You will not allow anyone else.
मैं लेके आई, मैं फोटोकॉपी लेके आई.
सामने किताब रखी हुई है, आप पढ़ना नहीं चाहते? You are avoiding the issue. क्या बात है आपके वकील, आपने ऐसे कलीग रख रखे?
मैं लेके आई हूँ सर.
अपॉइंटमेंट ऑफ टीचर ऑफ
किताब नहीं है
कॉलेज.
किताब नहीं तो आपको किताब दे
ये
से दिस गिव हिम अ बुक. ये दीजिए, लेटेस्ट अमेंडमेंट दीजिए.
लेटेस्ट वाला नहीं.
पेज 46 पढ़िए इसमें.
मेरा पेज कहाँ है? वो जो हमने दिया था वो दे दीजिए, जो हमने दिया था वो दे दीजिए.
प्रॉब्लम आ रही है तो ये से दिस. आफ्टर ऑल वी आर ऑल हियर टू pursue a legal question. We'll decide it together.
Yes.
We'll understand
Section
from you.
57.
57A पेज 46 पर है.
46.
B है.
हाँ.
Procedure of selection to be prescribed by the statute.
Yes.
Number one, subject to the provisions of this act and a statute made hereunder for appointment of teachers in such affiliated college which are not governed by the state government or not funded by the university
the applications from the candidates fulfilling the qualification prescribed under clause 3 of subsection 1 of section 57 of this act shall be invited by the governing body of the college concerned. The selection shall be processed by the selection committee constituted by the university under the provisions contained in section 57B of this act. 2. In making recommendations on the basis of interview of the candidates holding the above mentioned qualifications, the rules or the reservations shall be adhered by the selection committee. 3. The recommendation made by the selection committee shall remain valid for 1 year from the date of recommendation. Within 6 months from the date of recommendation of the selection committee, the college administration shall process the appointment, promotion in order
This is for those colleges which are not affiliated, which are not funded.
Which are not funded
Now
by the
come to
government.
57(6).
Yeah, not controlled and
57A का 6 सबका 6
57A is already mentioned.
ये नया ऐड हुआ है
जी जी ये नया है
ये रिलाय कर रहे हैं इस 6 पे जी पढ़िए इसको
Subject to this act, selection committee shall complete the scrutiny of the cases of the teachers appointed without the recommendations of the Bihar College Service Commission prior to 19/4/2007 in the affiliated degree colleges on the basis of the qualifications in force at the time of appointment of such teachers till 31/3/2018. Otherwise, such appointments will not be treated valid. Thereafter, the governing body of the college will accept the names recommended by the selection committee, which shall be finally approved by the concerned university. Distribution of grant amount sanctioned by the state government till 13/1/2018 shall be made against the teachers working in the concerned affiliated degree college by the governing body.
What do you understand about this? Does it not cover these teachers who were appointed prior to 2007?
Lodge.
But not recommended by the commission? ये आपने लिखा है इस ऑर्डर में लेटर में और उसके बाद नीचे लिख दिया कि साहब हम इनको नहीं देंगे.
They were appointed under clause 35(2).
They might have been appointed for 6 months, but they were continued.
They continued.
Now, for those people who were continued and who were not recommended by the commission, for them this clause has been added to scrutinize them. The university has conducted scrutiny, recommended that their names should be put in there, grant should be released for them.
But in the writ application, nowhere it has been stated, Lordship, that their names were recommended by the commission.
Yeah, the university.
Concerned
Those who are not by the commission, उन्हीं के लिए तो ये clause है.
But my lord, my lord, please allow me to say something.
Yes.
Regarding this. My lord, just look at this 57. It is already written by which are not governed by the state government.
Wait, these are for different sets.
So
57A, why I asked to read 57A and 57A6. 6 is a proviso. It is for separate
proviso of 57A. This was made for those teachers who were working in the affiliated college where the performance grant has been accepted by the government. The government will give them the performance grant on the basis of the result.
But those
and my lord, please let me explain. The last line, which shall be finally approved by the concerned university. This is the condition.
So
but why they have sent to us?
They have finally approved by the university. So you have to release their grant.
No, sir. Here they send us for सेवा संपुष्टि कि सरकार की अनुमति. सरकार ने कह दिया कि हमने तो अपना सारा पावर दे दिया है, विश्वविद्यालय को 2007 में, फिर why you are sending
All right.
these to us? आपने इसलिए इससे ये समझ में आता है सर कि ये जो नियम सरकार ने बनाई थी, सोचा भी नहीं होगा कि ऐसे टीचर्स जो इतने सालों से 30 सालों तक इलीगली वहां पर काम कर रहे हैं, सॉरी जो भी वॉट एवर, आई रिटर्न माई वर्ड, बट वो वहां पर काम कर रहे होंगे। सरकार ने टीचर्स के बेनिफिट के लिए, एफिलिएटेड कॉलेज के टीचर्स के बेनिफिट के लिए ये बनाया ताकि उन लोगों को इस, चूंकि कॉलेज सेवा आयोग नहीं है तो उनको इनसे फायदा मिल सके।
Please read your letter annexure A. That is why I say that whatever you are doing on your dotted line. You just now said that the university has sent it for approval.
Approval?
No.
They should
No,
not
they have
send
not
it.
sent it for approval. Come to annexure A. Come to annexure A. Your in your affidavit.
नहीं,
Could not have called you had that been the situation. Please see annexure A.
Annexure A.
यूनिवर्सिटी से
क्या रिक्वेस्ट है यूनिवर्सिटी की आपको? लास्ट लाइन पढ़िए। उन्होंने कहा कि हमने यूनिवर्सिटी ने अप्रूव कर दिया है। वेतनमान विमुक्त करने की कृपा की जाए। That is the letter. They have said that it is अधिकार विश्वविद्यालय को है। You put all this burden on this court because there is no, somehow the application of mind is not there. Whatever you have been told by your subordinates, you just sign it on the dotted lines. We don't expect that from senior officers. अभी आपको भी यही फीडिंग करके आप आई हैं, आपको दी गई है, यही फीडिंग कर दी गई ना कि यूनिवर्सिटी ने अप्रूवल के लिए भेज दिया। अप्रूवल के लिए नहीं भेजा था, यूनिवर्सिटी ने कहा हमने अप्रूव कर दिया है, आप उसकी ग्रांट रिलीज करिए। आपका ही डॉक्यूमेंट है, आपने पेश किया और आपने उसको वापस भेज दिया।
इसमें ये भी था कि वो लोग जो है इनकी,
चलिए, दैट्स ऑल, वी डोंट नीड एनी फर्दर फ्रॉम यू। चलिए, yes, you have to say anything further?
Lordship, one thing I will like to add.
We are going to impose cost on you, and a heavy cost on you, for unless is putting this litigation in the court.
I'm sorry.
देखिए, the petitioners by way of this writ petition have prayed for quashing of the letter dated 23/9/2018 whereby the Education Department, State of Bihar, has refused to release the grant for the teachers who were working in the Sanskrit universities, working in the various colleges of the under the Sanskrit University, and were appointed by the university. Brief facts of the case are: इससे पहले लिखते हैं in CWJC 808/2019, the prayer has been made to provide release of salary of petitioners since June 2011. which has been withheld by the authorities concerned, in spite of several proposals made by the university concerned, and reminders sent to the state authorities. Brief facts required to be noticed are as under CWJC कर दीजिएगा 250/2019. Petitioner states that he had applied under an advertisement issued on 21/6/79 for the post of lecturer and he was appointed for a period of 6 months. The appointment was approved by the university and extension was granted till further orders, wide order dated with effect from 1st July 1983, wide order dated 5th November 1983. He continued to draw service salary, and university confirmed the services in terms of decision of the syndicate by letter dated 28/8/2010. Since February 2012, the petitioner's salary was stopped. The Education Department sent a letter to the university to get the recommendation of selection committee in case of such teachers who are appointed by the governing bodies of the respective colleges. He attained superannuation on 31st January 2016, but did not receive salary for want of confirmation of service in terms of section 7A, capital A, subsection 6. By order dated 29/2/2016, the university, upon recommendations of the selection committee, regularized the services of the petitioner with effect from 1/9/77. But his retirement benefits were not released. He filed CWJC 18751/2017 before this court. The court where is that order of the court?
That has been, after passing of this order, Annexure 14, it was disposed of with a liberty to challenge the order. In fact, it was brought on record.
During the pendency of the writ petition, the impugned order dated 23/9/2018 was passed and granting liberty to the petitioner to challenge the said order. The writ petition was disposed of.
It is at Annexure.
And therefore the present writ petition has been filed.
Annexure 15, page 51 is the order.
In CWJC 808/2019, it stated that the petitioners had been appointed in several faculties against the sanctioned post of assistant professors in various affiliated colleges under the Kameshwar Singh Darbhanga Sanskrit University, Darbhanga. After following due selection process, they were being granted salary till May 2011 as per UGC pay scale, but their salary was withheld by the authorities thereafter. Since June 2011, the same has not been released. Representations were made whereafter the issue was taken up by the government directing the education department to release the salary from June 2011. A CWJC 444/2018 was preferred by 37 teachers. Whereas directions were issued to the respondent on 11/5/2018 following directions. In view of the above, page 27 पे कर दो. Despite thereto, the respondents, in spite of above directions, the respondents did not release their salary. The Additional Secretary of the Bihar Legislative Council also directed release the salary violation order dated 6/7/2018, but the same was also not complied with. They must have superannuated. Some of the petitioners have already attained superannuation. The after notices were issued in this case, and therefore fresh writ petition was given. This court passed an order on 20th August 2019 directing the state to file specific affidavit with regard to recommendation of the university in CWJC 808/2019. However, the same was not complied with. Again on 5/9/22, this court directed the respondent to file thereafter. An affidavit has been filed by the Deputy Director Higher Education, Patna, stating that the petitioners were appointed as temporary teachers in different colleges under Section 35 within bracket 2 of the Bihar State Universities Act 1976, which only provides for appointment for a period of 6 months. The same has to be continued only after further approval from the university. But the university, in collusion with the management of the colleges, allowed to continue the petitioner and continue. Same has to be approved by the state government.
That's why I was.
But the university, in collusion with the management of the colleges, allowed to continue the petitioners, and payments were made to them up to the year 2011. And it was brought to the knowledge of the state government. The payment of salaries for such teachers was stopped. It is further stated that so far as amendment made under Section 57, capital A within bracket 6 of the State Universities Act is concerned, the same is to extend the benefits to teachers of affiliated colleges which are being provided grants, taking into consideration the performance of the students appearing in the examination. And the said amendment was not meant for the teachers of deficit grant in 8 affiliated colleges. It is asserted by the state that provisions of Section 57, capital A within bracket 6 would have no application relating to the teachers working in the colleges which are receiving deficit grant in aid.
Deficit grant, yes.
And therefore, the request made by the university, even after regularizing their services, was not acceptable to the state government. And in a letter dated 6/10/22 has been placed on record to assert that the state grant is not required to be released for such teachers, and they could not have been confirmed by the university. A similar stand has been taken by the state in CWJC 250/2019. The counsel appearing for the petitioners has invited attention to 57 capital A subclause 6 of the Bihar State Universities Act 1976, which has been brought to force from 2017. This amendment is of 2017.
It was made on 27th of August 2015. The notification, my lord, I have got on record.
Yeah, I have that.
27th August 2015. To submit
27th August 15.
that a selection committee was required to be formed for scrutinizing the cases of teachers appointed without the recommendation of the Commission prior to 19/4/2007 in the affiliated degree colleges on the basis of qualifications enforced at the time of appointment of these teachers till 31st March 2018. The petitioners who were appointed in the respective colleges cannot be excluded from the said provision on the basis of the nature of grant being issued by the state government. I have considered the submission. It would be appropriate to quote the amendment made in sections 57 capital A of the Bihar Universities Act 1976, notified as on 27th August 2015. Page 41 पे ले लेना. CWJC 250/2019. ये जो अमेंडमेंट आया है सब्स्टिट्यूशन 2017 का, the language is slightly different.
Yes, the language has been slightly different. My lord. In 2015 amendment, my lord, there was a different language used. In subsequent.
It appears that by Gazette of 2017, Act of 20 of 2017,
Enforced at the time of
the section 57,
yeah, 57(6)
capital A, subclause 6 was further amended,
yeah.
and following provision was added.
The cutoff date was also shifted on 31st of March.
The word affiliated degree colleges
But it was only
has
for
been
the
added.
performance grant college.
Yes.
Yeah, and we have also given the executive instructions along with that, and this gazette. Along with that, we have also given the colleges the executive instructions, which has been highlighted.
The amendment which was made in 2017 was on the basis of a preamble which requires to be noticed. Now, this preamble says that the earlier with Rahit Shiksha Niti, that stands abolished. And therefore, now they will be all treated as equally. This is what it says, this preamble. And therefore, this requirement of adding the words has been highlighted.
I pray.
All right, or whatever you say.
Early occasion, Your Lordship, on 3rd May 2013, Your Lordship, the Department of Education has already directed to the concerned university to take
It was done by mistake. It was done because of the wrong analysis of that. It was done because of the wrong analysis.
Sorry.
In spite of above, from the perusal of the aforesaid amendments and the preamble to the amendment made in 2000 on 4th September 2017, it is apparent that the state government wanted the department to scrutinize all the cases of all those working teachers appointed without the recommendation of the Bihar College Service Commission, without making any distinction between those who were receiving different kinds of grants, namely the deficit grant or the grant
Performance.
against performance. It was also noticed that the with Rahit Shiksha Niti has been abolished by the state government. And therefore, no distinction could have been drawn by the state authorities in between the teachers who were appointed in colleges which were receiving different types of grants. This court further finds that the university has, in terms of provisions of section 57 capital A, exercised its power and scrutinized the cases of the petitioners and found them fit to be confirmed on their post. The recommendation for releasing of grant was sent to the state government by letter dated 25th March 2019, informing that the teachers have been duly recommended for release of the salary. Opinion of the Additional Advocate General had already also been received, also been taken by the university before sending the request for release of grant. However, the Director, Education Department, has rejected the request, merely mentioning the provisions of section 57 capital A subclause 6. The letter does not even mention any reasons for not releasing the grant. In these circumstances, the director, Education Department, was called by the court to be personally present in the court to explain. Whereafter, she is present in the court and states that since there are two different kinds of grants being released by the state government, the provisions of section 57 capital A subclause 6 would apply only to the affiliated colleges which are receiving grant for performance and not for those which are receiving grant in deficit. It is further stated that the work of regularizing confirming the services of the teachers is that of the university and not of the state government, and no approval is required from the state government for the said purpose. Having heard the director, this court finds that the university, in its letter dated 25th March 2019, does not request the director to approve the appointments of the concerned teachers, but on the other hand states that the university has finally approved their services in terms of section 57 capital A subclause 6, and requests the director to request the department to release their salary.
Grant, not salary. Grant.
It appears that the state government and their officials have adopted a stubborn approach, and in spite of there being a direction issued by this court earlier in CWJC उपाध्याय जी का ऑर्डर है ना कि कुछ
Yes, it is Milord
CWJC 444/2018 dated 11/5/2018 Supra. The salary of the teachers who have worked with the university for more than almost 30 years has been withheld from 2011/2012. It is an admitted position that all of them have been performing their duties till they attained superannuation. Some of them are still working. Article 23 of the Constitution of India provides as under. The effect is that no person shall be asked to perform duties without being paid their due salary. No reasons are coming forward, no plausible reasons are coming forward for not taking appropriate action at that relevant time to remove these teachers if they were not appointed in accordance with law. The state government has not passed any order directing the university to take any steps for removing them. And in an arbitrary, illegal manner, contrary to the principles and ethos of the Constitution, direction has been issued to withhold the salary. Such action is an anathema to the ethos of the Constitution as laid down under Article 21 of the Constitution of India. The action is deprecated. This court had reminded earlier in its order dated 11/5/2018 on similar footings. However, the state government and its officials have failed to perform their duties as required and have passed orders without contesting the writ order passed by this court in appeal. The action is contemptuous. However, instead of proceeding to initiate any contempt proceedings, this court deems it appropriate to pass specific directions in the present case, clarifying the entire position of law. Section 57, capital A, subclause 6, carves out an exception to Section 57, capital A. It is to take care of the situation where the concerned colleges had appointed through their governing body teachers in a situation where the same were not available by the commission. Said appointments were approved by the concerned university and they continued to perform their duties and were also being granted their due salary under the UGC pay scale. It appears that in 2011-2012, the state official arose from his slumber and objected to their appointment on the ground that they had not been recommended by the concerned commission. Their appointments had not been recommended by the commission. In 2000, the issue was taken up in Legislative Assembly and an amendment in the Act was brought into force by notification dated the page per notification.
In 2017 amendment I have not brought on record, my lord.
15.
15 it at page 41, my lord. Annexure 11, page 41.
51.
41. 41. Annexure 11, page 41.
Was brought into force by issuing of notification on 27th August 2015, which provided for scrutiny of cases of teachers of affiliated degree colleges appointed prior to 19/4/2007. The distinction on the basis of different grants was not mentioned in the amendment. However, the state authorities have proceeded to carve out a distinction between the two. Admittedly, the colleges where the petitioners were performing their duties are affiliated to the university. In view thereof, the scrutiny of their cases was required to be done in terms of the amendment made on 27th August 2015. It appears that the university has conducted that exercise and has made recommendations, but the state authorities did not accept it on a ground that the aid being released is under the deficit grant and not under the grant against performance. Although such a submission has been made before this court and in the counter affidavit, the orders passed, the orders impugned do not reflect such a reason. Be that as it may, this court is satisfied that there is no difference mentioned in the provision added to 57 capital A wide notification dated 27th August 2015, and no distinction can be drawn between the teachers who are appointed without recommendation of the Bihar College Service Commission for the purpose of scrutinizing their cases or for the purpose of releasing the grant. Such an approach adopted by the state government has resulted in unnecessary litigation before this court. The action of the state is found to be wanting, and in view of above, the impugned orders passed by the respondent dated 23/9/2018 as well as the orders passed subsequently dated 6/10/22 by the director are quashed and set aside with further direction to release the grant immediately to the concerned university for further distribution of salary and other allowances to the petitioners. Those who have retired shall also be granted their due pensionary benefits in terms of the UGC pay scales. The exercise shall be conducted positively within period of 1 month from today. Writ petitions stand allowed.
In my case, the order has been passed by the official secretary, not by the director. In my case,
yes, we have. So it has been.
Milord has.
The other order has been passed by the director.
May I get some?
I am withholding from giving from imposing cost on you, because otherwise that would be recoverable from you personally, which I don't want. You have assisted the court ably.
Item 5. Mr. Shashi Bhushan Singh.
May Premano. This case.
Yes.
Difference of areas of salary for the period of 1 month 2006 to 31st March 2010 has not been paid to the petitioner. My lord, in this case, my lord, the university has filed earlier a LPA that has been disposed of, and my lord, thereafter the state has also filed LPA that has been dismissed, my lord. So my lord, nothing is coming in the way of.
File your reply. Yes. You have not filed your house for that. File counter put up after 6 weeks.
Item 6. Mr. Vijay Kumar Singh.
My lord, similar cases, my lord, decided by my lord.
What is your case?
My lord, my lord, for promotion to the petitioner, my lord, class 4 to class 3, my lord. Already examination and already conducted, my lord, and the similarly situated person who work in university, my lord, already granted promotion. Thereafter, the sum of the petitioner.
Show him the order.
My lord, already I have given, my lord.
Is it covered?
My lord.
Do you agree?
देख लेते हैं जो इंस्ट्रक्शन ले लेते हैं.
हाँ?
अभी just
Monday को दे दीजिए. Next. Council relies on the judgment passed by this court in CWJC so and so. Number लिख लीजिए उसका. Decided on so and so. Learned counsel for the respondent wants time to go through the judgment. List this case again on next Wednesday. बुधवार तक देख लीजिए.
Item 7 case, my lord.
Same?
My lord.
दोनों केस.
Item 8. Mr. Ranjan Kumar Jha.
This is Anganwadi's matter, my lords. My lord's order is there.
Yes, with liberty.
Item 11, Mr. Amarnath Jadhav.
Your Lordship. Your Lordship, this read in the nature of certiorari, Your Lordship, in order to quash the provisional merit list as well as the final merit list, Your Lordship, dated 13/7/2019 and 24/7/2019, Your Lordship, respectively, Your Lordship. Against the two vacant posts of physiotherapist, Your Lordship, in Jawaharlal Nehru Medical College, Bhagalpur, Your Lordship, wherein, Your Lordship, one post was for general category, Your Lordship, and other one was reserved for BC1 category, Your Lordship. Your Lordship, the Superintendent of Medical College, aforesaid Medical College, was published a detailed advertisement, Your Lordship, on 17/6/2019, Your Lordship, wherein, Your Lordship, it has been mentioned that the appointment should be done on the contractual basis, Your Lordship. Your Lordship, in the said advertisement, it has also been mentioned that those aspirants would apply for that very post, Your Lordship, who had more than 18 years of age on 1/7/2019, Your Lordship. Whereas, Your Lordship, the upper age limit would be the same which had been ascertained by the government, Your Lordship. Your Lordship, it has also been mentioned that those aspirants would be given priority who had passed the government institute, Your Lordship. Your Lordship, the petitioner number 1 and 2 both have already been applied for this post, Your Lordship, and thereafter, Your Lordship, a provisional merit list was prepared, Your Lordship, wherein, Your Lordship, the petitioner number 1 was shown at the serial number 23, Your Lordship, and petitioner number 2 was shown at serial number 4, Your Lordship. Your Lordship, some objection was been given to the concerned authority, Your Lordship, and thereafter, at the last, Your Lordship, on 24/7/2019, Your Lordship, final merit list was published, Your Lordship, wherein, Your Lordship, the petition number 1 was shown at serial number 6, Your Lordship, and petition number 2 was shown at serial number 2, Your Lordship, in the said merit list, Your Lordship. Your Lordship, in the said merit list, Your Lordship, the petitioner number 2 was deducted 4 marks for failure, Your Lordship, which is against 4 marks was deducted for failure, which is against the advertisement, Your Lordship. There is no mention in advertisement, Your Lordship, that any 1 mark had been deducted in one.
आप दो अलग अलग केसेस को एक साथ कैसे आर्ग्यू कर लेते हो? एक साथ कैसे जॉइंट पिटीशन फाइल कर देते हो? You are talking about petitioner number 1, which has different facts. You are talking about petitioner number 2, which has different facts.
Your Lordship, 1 and 2 have same facts, Your Lordship. Challenge.
Just now said, na, for petitioner number 2, 4 marks were deducted.
Your Lordship,
is it correct? What
yes,
you are
4
saying?
marks were deducted for failure.
For petitioner number 2 only, na?
Yes, Your Lordship.
So it is different from petitioner number 1. His case is different. We will have to examine petitioner number 2's case differently.
Your Lordship, there is no room wherein it has been mentioned in the advertisement, Your Lordship. It has been mentioned that any 1 marks was deducted for any one failure, Your Lordship. ऐसा कहीं भी एडवर्टीजमेंट में नहीं लिखा हुआ कि कोई भी मार्क्स जो है फेलियर के लिए डिडक्ट किया जाएगा.
ठीक है.
लेकिन ऐसा इसके साथ जो है 4 नंबर काट लिया गया 4 फेलियर के लिए.
Then
petitioner number 2 के लिए हुजूर.
Then
thereafter, Your Lordship, the next one, Your Lordship, it has been mentioned in that.
Now you are at one is at number 2 in the merit, second is number 6 in the merit.
Next, Your Lordship, it has been mentioned the upper age limit of.
जब आप दो जनों के फैक्ट्स एक साथ बता रहे हो तो हम भी तो समझे ना. Petitioner number 1 is at number 2 in the merit. Select list में petitioner number 1 किस पोजीशन पर है?
Petitioner number 1 4th पोजीशन पे फाइनल में लिस्ट में.
4th पे.
Yes, Your Lordship.
और petitioner number 2
second पोजीशन पे है.
Second position.
Yes, Your Lordship.
All right. फिर क्या हुआ? Selection नहीं हुआ?
No, Your Lordship.
Then who are
Your Lordship, at the time of the.
How many persons were selected?
Petitioner number the candidate who was selected for general category, Your Lordship, was SC category, Your Lordship. At that very moment, Your Lordship. At the time of applying, Your Lordship, he was crossed the upper age limit, Your Lordship, as per the government rule, Your Lordship.
See, as per advertisement, he had crossed or not?
There is no upper age limit.
ये upper age limit कैसे Annexure 9, Your Lordship, देखा जाए.
खुद से पता समझो, वो तो वही करेंगे. Petitioner number 1 कितने जने select हुए ये बताइए. How many persons were selected?
2 persons, Your Lordship.
So you were at number 2, na?
Yes, Your Lordship.
Select list. So you were not selected.
Your Lordship, the petitioner number 1 who has already crossed the upper age limit. अगर वो सिलेक्ट होता तो मेरा सिलेक्शन होता हुजूर।
कहाँ है उसको रिस्पोंडेंट बनाया आपने?
यस बनाया है, उसको नहीं बनाया हुजूर।
उसको नहीं बनाया
फिर आप उसके लिए कह रहे हो कि वो ओवर एज हो गया,
यस
तो वो उसको एक अपॉर्चुनिटी तो दी जाएगी ना कि क्या वो ओवर एज हो गया या नहीं हो गया। आपके कहने से तो मान नहीं लेंगे। आप कोई सर्टिफिकेट, फर्जी सर्टिफिकेट ला दो कि नहीं ये उसका सर्टिफिकेट है डेट ऑफ बर्थ का, वो अपना डेट ऑफ बर्थ का सर्टिफिकेट कुछ और बताए, उसको मौका मिलना चाहिए, नहीं मिलना चाहिए?
वो मेंशन किया हुआ प्रोविजनल मेरिट लिस्ट में मेंशन है उसका एज योर से।
तभी तो कह रहे हैं कि गलत भी तो हो सकता है। उसने अपना ओरिजिनल सर्टिफिकेट दिखाया हो कि साहब मेरी डेट ऑफ बर्थ तो ये है, उसको ले लिया हो सकता है।
फाइनल
आप
मेरिट
उसको
लिस्ट में
पार्टी
भी
नहीं
उसका
लगाओगे?
एज योर लॉर्डशिप हिज एज हैज आल्सो बीन मेंशन इन फाइनल मेरिट लिस्ट योर लॉर्डशिप।
All right. Then
on what account your lordship it can be said that he has not shown his certificate of age?
yes. Anything else? इसके अलावा और कोई आर्ग्यूमेंट?
No, your lordship.
So one is with regard to petitioner number 2, that he should be given 4 marks more.
Yes, your lordship.
So he comes at number 1
Yes,
in the select list.
Yes, lordship.
Who was at number 1 in the select list? He has not been implicated as a party. कुछ कहना है? Nothing further? All right. लिखिए. The petitioner, by way of just petition, challenges the final merit list for appointment dated 24 July 2019, whereby two posts of physiotherapist in JLN Medical College Bhagalpur were filled by conducting a walk-in interview system.
Yes, your lordship.
Wherein the petitioner participated but failed to come within the merit for selection. Learned counsel for the petitioner submits that the person who has been selected and placed at number 1 in the merit list was ineligible as he had crossed the age limit.
Yes.
Further, it is stated that so far as petitioner number 2 is concerned, who has been placed at number 2 in the merit list of general category,
Yes, lordship.
was required to be given 4 marks more, as there was no provision for deducting marks on the ground of failure
Yes, your lordship.
in the advertisement. Learned counsel further submits that the age criteria as laid down under the rules has to be followed, and no different criteria could have been followed by the college for making appointments. I have reflected on the submission. This court finds that the petitioner, after having participated in the selection process and having failed to come up to the merit, has challenged the said merit list. He has not implicated anyone as a party to the merit petition. In absence of those who have been placed in the select list and who have been offered appointment, no orders can be passed directing for quashing of such a select list. Supreme Court, in the case of Uchhav Lal, State versus Union of India, has held as under. Similar view has been consistently being taken by the Supreme Court in case of Pramod Kumar Verma, 1983, as well as Arun Kumar Tiwari. So, view of above, the writ petition is dismissed.
Item 12. Mr. Shashi Bhushan Kumar.
Yes, my lord. This writ application has been filed for relief, my lord, regarding the salary of the trained scale, my lord, grant to the petitioner, completion of the training, my lord. My lord, petitioner sent for in-service training in 2013-15 session, my lord, and their training has been completed 2017 and examination conducted in 2019. So, my lord, the case of the petitioner is this issue already decided by this honorable court, my lord, Annexure 3, my lord, in case, my lord.
अरे भाई इशू तो पूरा बता दो.
इशू माय लॉर्ड कि 2013-15 माय लॉर्ड हमारा ग्रीवांस है माय लॉर्ड कि हमें ट्रेनिंग कंप्लीशन ऑफ ट्रेनिंग से ट्रेंड स्केल माय लॉर्ड.
Yes.
My I sent 2013-15 training course, my lord, session, my lord, and my training completed in year 2017, my lord, but examination has been held in 2019, my lord.
Then?
My lord, and I am passed, my lord, and my lord, trend scale has been granted for issuance of the certificate, my lord. But my lord, on due to lapses of the state government, my lord, and board, my lord, the petitioner suffered, my lord. My lord, so in this regard,
license,
my lord, sufferer, my lord, from lapses of the lapses, my lord, of the state government and board, my lord, the petitioner suffered, my lord. So then this issue, my lord, before my lord, honorable court already decided this issue, my lord, in Annexure 3, my lord. And other candidate has been granted this scale, my lord, but the petitioner, my lord, also decided this issue, my lord, in same issue.
We have followed it.
Yes.
We have followed it.
Yes.
Yes. But I think I
my lord, and other coordinate bench also, my lord.
I would like to send it to the largest.
My lord, also, my lord, coordinate bench also.
I myself.
My lord.
I am not agreeing with this view.
My lord. My lord, in this case, my lord, also, my lord, detail, my lord.
See, you know what? Why this court is not accepting this? Actually, after having, I remember that I have followed this order, but I looked into some judgments of Supreme Court which go contrary to this view.
My lord,
a person can be only granted trained pay scale from the day he gets trained, and he cannot be treated as trained till his result is declared. Now, if for any reason the delay is there, you may ask for damages. But the concept of what? You can't be asking that because they have committed a fault, so you should get a pay scale from an earlier date. If that concept is accepted, Mr. Counsel, please hear.
Sorry.
If that concept is accepted, then in all cases, where say for example a selection process starts in 2018 and you are appointed ultimately in 2022, you say that this is the fault of the appointing authority. For 4 years they did not complete it, so we should be given the pay scale from 2020 or 2018. That cannot be the way.
In this case, my
the
lord,
concept of the tort, law of tort, can it be applied in relation to granting a pay scale?
My lord, in this case, my lord, honorable court observed that, my lord.
You please answer to what I have asked.
Yes, my lord.
Yes. What the court has said, we know it.
Yes, my lord.
You tell us how to handle with this aspect. 2013-15,
my lord, session petitioner sent for the training, my lord. Thereafter, my lord, 2017, my lord.
आपका एग्जाम 2019 में हुआ. हम मानते हैं 2019 के बाद रिजल्ट भी चाहे 2021 में आता.
My lord, यहाँ है कि 2017 में हमारा ट्रेनिंग कंप्लीट
from which particular date?
इन सर्विस ट्रेनिंग था, माय लॉर्ड. हमने ट्रेनिंग कंप्लीट कर लिया. ट्रेनिंग का बेनिफिट माय लॉर्ड कोर्ट का जो
ट्रेनिंग का रिजल्ट आ गया.
ऑनरेबल यस माय लॉर्ड, रिजल्ट भी आ गया. हमें ट्रेन
कब आया? कब ट्रेनिंग?
2019 में ही आ गया माय लॉर्ड.
हाँ? 2019 में है ना?
हाँ, नो माय लॉर्ड, 2019 में ही.
अरे वही तो हम पूछ रहे हैं, 2019 को ही तो बोलते हैं।
यस माय लॉर्ड, 2019 में।
चलिए इंग्लिश में बात करें।
नो नो 19 में ही आ गया माय लॉर्ड।
नहीं, आपको जो लैंग्वेज सही तरह से समझ में आती हो।
2019 में आ गया रिजल्ट।
You want me to speak in English? I will speak in English.
माय लॉर्ड,
Which language is good with you?
हिंदी।
हिंदी, all right. तो आपको 2019 में रिजल्ट आया, आप 2015 में ट्रेनिंग में बैठने स्टार्ट करें, यही आपका केस है।
नो नो नो
2015 से 17 तक की तो ट्रेनिंग हुई।
13-15 मेरा सेशन था माय लॉर्ड।
हाँ।
हमारा इन सर्विस ट्रेनिंग 2017 में कंप्लीट हो गया।
हो गया।
यस माय
रिजल्ट कब आया?
आउट एग्जामिनेशन 2019 में हुआ माय लॉर्ड।
तो रिजल्ट भी 2019 में ही आया।
यस माय लॉर्ड, से विद इन टाइम हो गया।
कब ट्रेनिंग मानी जाएगी आपकी कंप्लीट?
यस माय लॉर्ड, यहाँ पे ऑनरेबल कोर्ट का ऑब्जर्वेशन।
छोड़िए आप हाई कोर्ट के, जब हम डिस्टिंक्शन के लिए बात कर रहे हैं,
वही आ रहे हैं माय लॉर्ड कि डिस्टिंक्शन की जब हम कोई भी क्लासेस कंप्लीट कर लेते हैं तो एग्जामिनेशन लेना फॉर्मेलिटी रह जाती है। उसी क्लास
फॉर्मेलिटी क्यों रह जाती है? फेल नहीं होते लोग?
यस, अगर
एक जना फेल नहीं होता। अच्छा, आपके साथ जितने भी बैठे, क्या आप कहीं एफिडेविट में लाए हैं कि किसी को फेल नहीं किया या करते ही नहीं?
नहीं, फेल तो होंगे, उनके लिए ये केस नहीं है माय लॉर्ड।
क्यों?
जो
वो सप्लीमेंट्री में पास हो गए,
जो सप्लीमेंट्री में पास कर गए उनके लिए भी केस नहीं है माय लॉर्ड।
क्यों नहीं?
इसलिए माय लॉर्ड क्योंकि उनका फर्स्ट इंस्टेंस ऑनरेबल चंद्रकांत के केस में भी यही बात आई था कि जो अगर
नहीं, आप कैसे सप्लीमेंट्री में पास हो गए या किसी का रिवैल्यूएशन में पास हो गए?
रिवैल्यूएशन इज द डिफरेंट थिंग।
भाई आप मुझे बताइए कि 2019 के बाद एग्जाम रिजल्ट आया, कुछ लोग तो रिवैल्यूएशन में पास हुए होंगे, कुछ लोग सप्लीमेंट्री में पास हो गए होंगे।
सप्लीमेंट्री में जो पास
भाई कोई बच्चे नहीं एग्जाम में बैठ पाए हों, वो सप्लीमेंट्री में बैठेंगे ना?
बैठेंगे, बट माय लॉर्ड
उनको क्यों आप डिस्टिंक्शन करोगे?
यस माय लॉर्ड, दिस केस ऑलरेडी डिस्टिंग्विश्ड बाय द ऑनरेबल कोर्ट माय लॉर्ड इन चंद्रकांत केस माय लॉर्ड। उसमें हुआ था कि जो लोग फर्स्ट अटेम्प्ट में पास कर गए माय लॉर्ड, वो उनको जो
चंद्रकांत का डिवीजन फुल बेंच का जजमेंट है क्या?
फुल बेंच वो फॉर्म बाय द एपेक्स कोर्ट माय लॉर्ड।
नहीं, फुल बेंच का जजमेंट है क्या? डिवीजन का जजमेंट है? अगर है तो हम फॉलो करेंगे।
डिवीजन बेंच माय लॉर्ड
बताइए, जहां उन्होंने कह दिया कि नहीं ट्रेनिंग चाहे कभी भी हुई हो अर्लियर डेट से मानी जाएगी,
उसमें भी यस माय लॉर्ड डेट ऑफ अपॉइंटमेंट से उसमें तो दे दिया गया माय लॉर्ड। उसमें तो डेट ऑफ, वो रेगुलर टीचर का केस था माय लॉर्ड, लेकिन रेगुलर टीचर का केस था माय लॉर्ड, वो रेगुलर टीचर का केस था।
ले आइए सारे जजमेंट ले आइए, एक साथ देख लेते हैं।
यस बट माय लॉर्ड माय केस इज
इसमें तो उन्होंने कोई फॉलो नहीं किया।
नहीं, इसमें फॉलो नहीं, इसमें दूसरे केस को फॉलो किया गया माय लॉर्ड एपेक्स कोर्ट।
बताइए चंद्रकांत का भी ले आइए, नेक्स्ट मंडे रख लेते हैं।
यस माय लॉर्ड, बट माय
आई थिंक आई हैव informed you about the query of the court. Please satisfy, we are ready. After all, there is a judgment in your favor. You satisfy the court.
Yes.
And विजय सिंह देवड़ा का जजमेंट है सुप्रीम कोर्ट का, वो जरा देख लीजिए। That goes against you.
My lord.
And since there is a Supreme Court judgment, if there are judgments of this court which go against the judgment law laid down by Supreme Court, then I'll have to declare the parid.
My lord, in the light
even my own judgment, if it goes against the judgment of Supreme Court, then ये देना चाहिए, ये हमने follow किया है.
My lord, in the light of this annexure 3, my lord, other candidate grant benefit of this.
We can understand there is a.
This is a.
That's why this requires to be thoroughly examined. What happens, see, you have completed your training in 2019. There might be some people who have already selected and appointed duly trained, say in 2016. What can be your possible date from which you should be declared as completed your training? Can it be in 2017?
This.
From what date should your training, you should be given the train pay scale? You tell us this. आप बताइए, 17 से होनी चाहिए, 17 की कौन सी डेट से होनी चाहिए?
जिस दिन सम रिलीव हो रहा है ट्रेनिंग से, माय लॉर्ड। ट्रेनिंग सेंटर सम रिलीव हो रहा है, कंप्लीशन ऑफ ट्रेनिंग से, माय लॉर्ड।
ये तो
यही इसमें
Let us see. You have not passed the examination. How can you?
My lord, I am passed, my lord.
Oh yes, quite rightly. You have passed it later on.
Later on, my lord, but my lord, in this case, my lord, माना गया कि 2017 में अगर इन्होंने कंप्लीट कर लिया, अगर समय से एग्जाम हो गया होता, that time अगर एग्जाम हो जाता,
ये जो होता है,
this is the view of the court, my lord. तो ये उस
अगर और if के अंदर law नहीं होता, law is not bound by ifs and buts.
Another
we don't lay down law for what will happen if so and so would have happened. इसमें तो आप अगर क्रिमिनल लॉ में अगर आपने if और buts लगा दिए,
my lord, another
तो
another court of this court, another one honorable court bench of this court, my lord.
You bring all the judgments. We are giving you time. We are keeping it on next Monday.
20 का केस Wednesday को.
हाँ, Wednesday. 2020 matters will come up on Wednesday.
Item number 13.
Yes.
Hari Bhaskar Geetesh.
Same.
Delayed matter must also, my lord.
Huh? Same.
My lord.
Same prayer. क्या प्रेयर है?
सिटी से मांग रहा है. संजय कुमार यादव.
ये तो
The matter is covered by the CWJC number. संजय कुमार यादव में.
हो गया ना, तो clarify हो गया. That has to be considered. We have also noticed in that judgment of Ataur Rahman, those who have done DLED from NIUS, they will be treated to be sufficient. कहाँ है वो judgment बताइए संजय कुमार का? The issue involved in the present writ petition. है आपके पास पड़ा है? What do you say, Mr.?
Lord, decided by Honorable Court, and in fact, Lord, I must admit that it was accepted by the NCT also. This was, Lord, the 18 months NIUS in-service training was given, and that was only for promotion, but not for selection. But that was satisfied by the Honorable Court.
So this has been allowed, no?
My Lord.
Likhi, the issue raised in the present petition. Stands finally adjudicated by this court in CWJC 19842/2019, Sanjay Kumar Yadav and others decided on 21/1/2020, wherein this court observed as under. Para 14 से ले लीजिएगा, page 38 और 39. Stop. Keeping in view thereto the decision of the state government dated 6/9/2019, holding that the qualification of NIUS, qualification of DLED training from NIUS during service to be not valid consideration for selection for post of primary teacher in government of Bihar is found to be bad in law. That this court in Ataur Rahman versus so and so has also observed that the one-time DLED course training granted by the NIUS is sufficient for the purpose of recognizing the teachers to be trained, keeping you above the present writ petition is allowed as a.
Item 14.
No one appears Kardina for petitioner.
Vijay Shankar Chaubey.
Yes.
The matter relates to appointment of 34,500 assistant teacher laws.
That we have already discussed.
Lordship.
Same judgment dismissed. Who is different?
Item 15.
Vigdana, this court has insurance case held as under. And accordingly, this petition is dismissed.
May I please, Your Lordship?
Yes.
इसमें मतलब यूनिवर्सिटी की ओर से काउंटर फाइल करना है हमको।
एक केस क्या है इनका?
मलोला में 16 में
15 कल हुआ है।
वो 1500।
Item 15.
My lord. It's a case, my lord, for grant of first and second term and promotion, my lord. Petitioner, my lord, retired in the year 1987 itself, my lord. But prior to that, my lord, while he was posted.
What happened in your vigilance case?
I have been acquitted, my lord.
You have been acquitted?
My lord.
You file your reply?
My lord, on
Then it comes for the
17/1/20, my lord, there was a direction to file counter affidavit, but till date they have not.
University is of the respondents, University Cardinal. State is is given one more chance and final opportunity to file counter affidavit list after 2 weeks.
Item 16, Mr. Rajiv Shekhar.
तो मिश्रा जी एक जजमेंट है जयपाल सिंह का, वो देखिएगा। उसमें उन्होंने कहा कि अगर आपकी गलती क्यों नहीं है तो पहले वाला बेनिफिट नहीं मिलेगा, और विजिलेंस केस था, इंटरेस्ट नहीं मिलेगा, उसका देख लीजिएगा। यस,
In this case, I will file counter affidavit, my lord.
Item
What is the
16,
case?
Mr. Rajiv Shekhar.
इसमें लिखते हैं my lord, assistant professor to accommodate the petitioner who acquired eligibility much before the treatment in question issued in consonance of the object of the resolution issued by the Department of General Administration enhancing the maximum age के लिए है my lord. Maximum age limit to overcome the unemployment by resolution number dated so and so, and also further taking from other university including Bihar Public Service Commission having fixed the upper age limit. उस लाइक का ये हजूर कहते हैं जो कि पैराग्राफ 1 में हजूर लिखे हैं। डायरेक्ट रेस्पोंडेंट टू कंडोन द एज लिमिट, एज लिमिट को कंडोन करने के लिए मालूम और प्रमोशन के लिए चाहते हैं।
इसमें क्या रिप्लाई देंगे? जो पॉलिसी डिसीजन है, पिटीशन, वो एडवर्टीजमेंट भी हो गया होगा। That must have been already acted upon. 16 का है।
इसमें वाले जो हम काउंटर फाइल किए लेकिन हमको मिल नहीं रहे हैं, जिसको हम नहीं दे पा रहे हैं। काउंटर हमारा रेडी है, तो डायरेक्ट अगर लिया जाएगा तो हजूर को हम दे देते हैं।
The petitioner by way of this writ petition asserts the advertisement issued by the Bihar Agriculture University Sabur dated 2/12/2011 whereby the age criteria was fixed as 55 years. Challenge made to the writ petition has become odious by a flux of time. Moreover, the prayer for enhancing the upper age limit to 55 years is not an issue which can be examined in writ jurisdiction, as the matter is not a subject of judicial review and is in exclusive domain of the state government and the concerned university commission to
accommodate them,
to decide as to what has to be the minimum age and upper age for recruitment of an employee, either under the state government or under the university.
Yes.
Writ petition for such purpose would not lie, is not maintainable, is just accordingly. Yes, what is the Advocate General here?
Item 41, my lord
41.
will recollect that tribunal constitution of tribunal.
Yes.
Finally, notification has been issued.
You have issued the notification?
Yes.
And then they were not required to come.
They were not required to come, however, in order to.
We said that if it is done, then they are not
I
required.
told them, but they wanted to show their respect, my lord.
What is not sitting there?
I think ultimately it has taken complete 1 year for me to pursue this thing. Because
It is not,
burden
my
on
lord,
this court.
it is not appropriate to divulge how much effort they had to put to get this notification done.
We could have been only giving some, more oil to the wheels. By passing orders.
It has been finally constituted, notification
All
has been
right.
issued. दे दीजिए.
Thank you. We'll dispose of the matter. लिखिए, the Chief Secretary as well as the Additional Chief Secretary Education are present along with the Advocate General. The Advocate General has placed on record the orders by which the concerned presiding officer for the various district appellate authorities has been notified. It is now expected that the concerned district appellate authorities shall become functional with the complete infrastructure being provided to them.
Physically
That
not
is also-
sitting there, my lord.
That is
Have we
already.
come to know from the reliable?
If not so,
Yes, if not so कर.
If not so.
इसलिए पहले से तो
जो
डिस्ट्रिक्ट
जहाँ पे है वहाँ है, जहाँ नहीं है कई जगह तो थी।
नहीं इंफ्रास्ट्रक्चर पहले
कह रहे
से
नहीं।
इंफ्रास्ट्रक्चर है सर सब जगह, आई मीन प्रिसाइडिंग ऑफिसर्स कहीं नहीं।
हाँ, पर
वो नहीं है
सारी
इंफ्रास्ट्रक्चर
डिस्ट्रिक्ट
है.
में कोई नई डिस्ट्रिक्ट तो नहीं बनी 2000
इधर नहीं
डिस्ट्रिक्ट
नहीं डिस्ट्रिक्ट
नॉट सो लिख दिए लिखा
डिस्ट्रिक्ट एपेलेट अथॉरिटी फंक्शनल नहीं था.
which includes the other staff. क्या लिखा था? If not so, and the state appellate authority who has been entertaining the petitions directly relating to issues which can be examined by the respective district appellate authorities, may at its discretion and judicious discretion remand those cases to the concerned district appellate authorities for adjudication.
Light of Suresh.
In view of the judgment passed by this court in Suresh.
Lord, my submission, Lord, one.
My lord,
This will lower down the burden of the state appellate authorities. We had taken a view that because that rule provides that even directly persons can approach the state appellate authority. So many cases went to the state appellate authority because of this non-functioning of the district. Now we are directed that they will also go there.
the rule in contempt may be discharged, my lord.
Yes.
Lord,
Yes.
ये डिस्ट्रिक्ट अपडेट अथॉरिटी के यहाँ पे रिमांड हो रहा है मैटर में, लॉर्ड.
नहीं. आपका केस?
जी.
आपका केस कहाँ था पहले?
I am in this case.
हाँ, आपके केस में क्या पोजीशन है?
I am ready to argue in this case.
नहीं, but in your case,
Court is not sitting there. That is my matter.
that was the only thing.
लेकिन
लिखिए आगे. Those in it has also been brought to the knowledge of this court. Like in the present petition,
Amresh Kumar.
that there are appeals which were filed
Yes.
in the concerned district appellate authorities but could not be taken up on account of the lack of the presiding officer. In view of the facts which have been brought to the knowledge of this court and noticed herein above, the concerned district appellate authorities shall take up on priority basis all the appeals which are pending with them and which have remained pending with them.
According to
And
Nimawali, my lord.
it is expected that the same shall be disposed of expeditiously.
Dispose of, my lord, according to teachers Nimawali. इन्होंने एक टीचर्स रूल बनाया है जो
वो आप अकॉर्डिंग टू तो वो उनको डिस्क्रिप्शन होगा. You will not direct how
एक सेकंड
by names में kindly
only for 1 second, my lord.
order did
इन्होंने एक
31st
लेटर निकाला है, वो
31st January
उससे मेरा
23.
डिसाइड नहीं होगा ना.
31st January 23.
बस according to merit indices as well as नियमावली और टीचर्स रूल बनाया 2012 में टीचर्स रूल बना है, उसके अनुसार डिसाइड कर देंगे. डिस्ट्रिक्ट ऑपरेट अथॉरिटी.
अगर वो 2006 के रूल से गवर्न होता होगा तो
नहीं है, 2006 से गवर्न नहीं हो रहा अभी तक, कोई रूल नहीं बना है. बस मेरी सबमिशन को नोट कर दिया जाए.
क्या
मेरी सबमिशन को
क्या कहना चाहते हैं?
मैं कहना चाह रहा हूँ
फंक्शन आपका था कि ट्रिब्यूनल फंक्शन करे
हजूर, और अकॉर्डिंग टू मेरिट ऑफ दिस केस टीचर्स नियमावली से आउट ही जाके मेरा ये एक लेटर इन्होंने एक्जीक्यूटिव लेटर निकाल दिया है.
हमने उनको पावर दे दी कि आप सारी चीजें एग्जामिन कर सकते हैं.
हजूर एक
नॉट ओनली अंडर द रूल्स ऑफ 2012 बट ऑल द डिस्प्यूट्स
my lord, is my name is my
the personal presence of the chief secretary, the additional chief secretary is exempted for further is exempted
contempt,
and the proceedings हमने contempt तो लगाई नहीं है इनिशियल. कहा ये है कि अगर करेंगे the and no further proceedings are required to be taken up.
एक लाइन और मालूम
is
करना है मालूम.
disposed of in
अर्लियर स्टेट अपॉलिटी को डायरेक्शन दे के पहले कंसिडर करना है. अब नाउ मान लो डिस्ट्रिक्ट अपडेट अथॉरिटी अकॉर्डिंग मान लो तो कोई कंडोनेशन या डिले हो जो
वो सब किया हुआ है. My name may kindly be indicated, my lord.
Yes.
If any, my lord,
assistance of Mr. Jharkhand in the matter is appreciated.
And my lord,
annexer.
So far the cases appeal filed, my lord, before the state appellate authority, my lord, as per the direction.
जो आपकी पहले अभी स्टेट अपीलेट अथॉरिटी में अपीलें लग गई डायरेक्टली, उनको हमने ये आदेश कर दिया कि वो चाहे जुडिशियल डिस्क्रिप्शन है उनका, वो चाहे तो उसको डिस्ट्रिक्ट अपीलेट अथॉरिटी में ट्रांसफर कर दे, नहीं चाहे खुद ही डिसाइड करना तो कर दे. पावर उनके पास ऑलरेडी है, पहले से भी थी
पावर है हुजूर, लेकिन अब ये
करने से भेज देंगे. पावर उनके ऊपर बर्डन बहुत ज्यादा होगा, वो भी डिस्पोजल नहीं हो पा रहा था.
कंट्राडिक्टरी हो जाएगा हुजूर, कि चाहे तो भेज देंगे, फिर डिमांड कर देंगे.
जुडिशियल डिस्क्रिप्शन है, आप आर्ग्यू करिएगा कि नहीं भेजे, इसलिए हमने वर्ड जुडिशियल डिस्क्रिप्शन कराया, उन्हीं के ऊपर छोड़ा है.
If any, my lord, delay, my lord,
हुआ कि रिप्लाई फाइल हो गया.
Each word has its own meaning. I have deliberately used the word judicial discretion. Suppose they are already with there is some appeal before them on the same issue, और कुछ directly आ गई है before, so they can always decide them. There is no question of sending it. But in some circumstances जो factual aspects है भेजी जा सकती है, जवाब नहीं आया तो भी भेजी जा सकती है, डिपेंड करता है, इनके ऊपर डिपेंड करता है.
Only for 1 second, my lord, may I kindly see the accept 2 of my writ application. Head of the writ, that is my case. इसमें जो नियमावली इन्होंने बनाया है बिहार.
एक बात तो है, आपको बहस करने नहीं दी गई इस केस में, आप
इतना ही हजूर कर दिया जाए हजूर, बराबर कि टीचर्स नियमावली जो रूल है उसके अनुसार ही डिसाइड कर दें.
नहीं, हम नहीं कहेंगे.
तो मेरिट
अगर वो करते नहीं है आप बहस के लिए, फिर आपके पास रहेगा
मेरिट ऑफ दिस केस लॉर्ड, दैट इज annexure 2. annexure 3 का सब्जेक्ट लिया जाए, स्कूटी
वकील साहब अगर ऐसा कर देंगे
तो फिर वहीं कर देंगे साहब,
आप वहाँ बहस करिएगा. अगर नहीं करते हैं वो
तब यहाँ करेंगे,
तो फिर आपके पास मौका मिलेगा ना एक केस.
जो अभी जो आप बोले ही नोट कर दिया जाए ऑर्डर शीट में. अगर बोलेंगे अगर नहीं सुने तो फिर यहाँ आपको डिवर्टिंग नहीं जाएगा, ये हजूर दे दिया जाए.
ये भी हम नहीं देते, क्या पता उस समय जो जज साहब बैठे हो वो आपके एंटरटेन उनको कैसे बाउंड कर देंगे हम आपके. अभी
जो annexure 3 का फेक लेटर है,
आप ये annexure 3 वहां लगाइए, बहस करिएगा.
वो एडमिनिस्ट्रेटिव लेटर है, एक्जीक्यूटिव लेटर नेवर कैन सुपरसीड दी.
एक लाइन में डिले कंडीशन के लिखवा दिया जाएगा.
टीचर्स नियमावली में लॉर्ड माय सबमिशन. अब विदिन स्टैट्यूटरी पीरियड अभी कोर्ट बैठ नहीं रहा हजूर, कोर्ट इज नॉट फंक्शनिंग देयर. Having come to know from today, it is not.
आज ही तो ऑर्डर हुआ है
जी
31 तारीख को, आज ही कल ही तो हुआ है।
मतलब अभी हम लेटेस्ट पोजीशन बता रहे हैं, डिस्पोज ऑफ ना हो गया जो, फिर जो है बैठक वहां जाएंगे ही नहीं।
आ जाइएगा, एनजेसी लगा दीजिएगा अगर ऐसी बात होती।
हाँ तो हजूर इसमें कितना दिन के अंदर वहां बैठेंगे, ये हजूर ऑर्डर शीट में कम से कम मेंशन तो कर दिया जाए। जैसे ही बोल दिए बैठ गया, कब तक? विदिन 1 वीक, विदिन 1 2 मंथ 3 मंथ हजूर कुछ भी रिपोर्टेड जजमेंट हजूर का पहले से भी है PLDR में, बस तब ना एमजेसी लगाएंगे हजूर।
ठीक है,
हाँ
देख लेंगे जब ऑर्डर है
इसको हजूर,
इसको सही तरह से देख,
इसको जोड़ दिया जाए।
ठीक है,
जो भी मैंने जस्ट आई हैव मेड सबमिशन माय लॉर्ड, मे काइंडली मेंशन इन द ऑर्डर शीट माय लॉर्ड, देखा जाए।
बिफोर साइनिंग वी विल चेक द ऑर्डर।
Permitted to withdraw, my lord.
Council prays to withdraw the petition, dismissed as withdrawn.
Item number 20, Mr. Shailesh Kumar Singh.
Lord, payment of salary of Rasoiya, my lord, and payment of salary of Rasoiya, my lord, and now my lord is filed for counter in which my lord is stated that they have been removed from service, my lord. So I will liberty to challenge, my lord, the removal order, my lord. Copy of the Lord dismissal order has not been given to me, Lord, till date. Now, Lord, in the counter, Lord, they were stated. This was engaged, Lord, as Soya, Lord, in the school of.
कोई पोस्ट है क्या रसोईया?
Yes, Lord.
Under the rules.
Under the rules, Lord.
Is it a class 4 service post, or is it on contract?
It is contract, my lord.
Then how can you come to the court for claiming that?
They were next, my lord, rule, my lord, also in counter, my lord.
अगर ऐसी बात है कि आपकी सैलरी नहीं दे रहे, आपको हटा दिया, तो आप वहां जाइए लेबर कोर्ट में। लेबर कोर्ट रसोईया है ना, ही इज अ वर्कमैन। अगर उसको 10 साल या 8 साल काम कर रखा है तो उसको मिलेगा। रीइंस्टेटमेंट भी मिलेगा, बैक वेजेस भी मिलेगी, सब कुछ मिलेगा, और कंटिन्यूटी ऑफ सर्विस भी मिल जाएगी। The petitioner admittedly was working as a rasoiya who has been orally disallowed to work. He also claims salary for the period during which he has worked. Para. Admittedly, the work performed by the petitioner brings him within the ambit of workmen in terms of section 2 within bracket S of the Industrial Disputes Act 1947, and therefore has a statutory remedy under section 10 of the Act of 1947 to raise a dispute regarding his wrongful retrenchment before the concerned labor court, keeping in view the law, the aforesaid provisions. The writ petition is dismissed with liberty to the petitioner to raise a dispute directly before the concerned labor court.
For a prepared authority, my lord. Because, my lord, he has countermanded necessary, my lord. He has said that there is a provision of appeal, my lord. Department, my lord. Assisting, my lord. His counter, my lord.
आप अपील में जाना चाहते हो?
Yes, my lord.
मिलेगा ही नहीं कुछ भी।
इनका नियम तो अपील में
हम तो ये कह रहे
उससे बेहतर कुछ नहीं होगा।
If an appeal is preferred, if a dispute is filed before the concerned labor court, the same shall be entertained directly and decided expeditiously, preferably within period of 1 year.
इतना बढ़िया ऑर्डर नहीं होगा।
Item number 21.
Application file only for the second time bound promotion and benefit of SCP medal.
Second time bound program promotion.
Yes, ma'am.
What is the post?
Retire on 2019.
What was the post, teacher?
2009. Teacher, private teacher.
आप तो चले जाओ, डिस्प्यूट तो वहां पे रेस किया ही जा सकता है। मिल जाएगा, अभी तो हम यहाँ नोटिस करेंगे, जवाब आएगा, फिर चला जाएगा ये। इट विल नॉट बी टेकन अप. Go there, we will direct in 6 months. It is informed that the district appellate authorities have become functional, keeping in view thereto the petitioner is allowed to raise his dispute before the concerned district appellate authority, who may decide the same expeditiously, preferably within a period of 6 months.
Item 23, Mr. Lal Bahadur Singh.
4/3/20 का आदेश हुआ था CWS ने 13572 के साथ रखने का 16 सेवक है ये रखने के लिए आदेश हुआ था, ऑर्डर नहीं। 4/3/2020 का आदेश हुआ था जी।
4/3/2020 का आदेश है, कहाँ पर है?
ऑर्डर शीट में है।
अनेक्शर
नहीं, हजूर का कोर्ट का आदेश है, कोऑर्डिनेट कोर्ट का आदेश
ऑर्डर शीट में।
और डिस्पोजल हजूर के यहाँ पेंडिंग है, अभी डिस्पोजल नहीं हुआ है।
13572 of 2015
जी
2015 के केस नहीं लग रहा है,
लगते हैं,
देखिए
एक मिनट
टैग अलॉन्ग विथ 13572 of 2015.
Item 25. Item 25.
Yes, madam.
Mrs. Mahachitra.
Yes, madam. This is an application for quashing of annexure 15, 16 and 17, madam. By annexure. Ji?
Punishment of censure.
Punishment of censure, I am not on that, my lord. I have come before your lordship for payment of full salary for the period of suspension. It is settled principle of law, my lord. There are several.
If it is a minor punishment, then you have this occasion.
Yes, I am not on that, my lord.
Yes, what do you say? Why have you stopped at the other part of the salary? If you have ultimately found that only censure is required to be given, for minor penalty he was not required to be suspended also.
Censure and both punishment has been given.
I am for.
You show that it is a disciplinary authority has a right of punishing. जो list of punishments है, उसमें withholding of salary during subsistence allowance.
Withholding of salary.
Suspension के कारण.
Withholding of salary नहीं है, my lord. My submission is that.
What is the punishment?
During the period of suspension, he was paid 50% of salary. And
so salary apart from subsistence allowance has been withheld?
No. Only 50% of salary as subsistence allowance he has been paid.
The other part has been withheld?
My lord?
The other part has been withheld?
Other part has been held, only 50%. And I have come for rest 50% of salary. Since no charge was framed. It is a settled principle of law.
What is that settled principle of law? Please tell us.
Yes, sir. Settled principle of law. I start from a single bench decision that is reported in 2013, volume 3, PLGR, my lord.
सेंसर तो आप चले सेंसर थोड़ी
हुजूर आप कुछ नहीं कहेंगे तो पीरियड बीत गया हमारा खाली इतना ही प्रेयर आई कन्फाइन माय प्रेयर फॉर पेमेंट ऑफ रेस्ट ऑफ 50% सैलरी for the period when the petitioner was under suspension.
Yes, show the
जी
ये ना
और भी है दिखा दे
हाँ दिखा दीजिए
क्या जजमेंट, क्या जजमेंट, जजमेंट का क्या है?
दिया है 13 वॉल्यूम 1 PLJR एज 1
एज
ये दूसरा
बिहार सर्विस कोड देखते हैं बिहार सर्विस कोड. Can you show us 97.3?
Yes, my lord. Another judgment.
No, show us 97. He is relied. Another judgment is not required because he is already taking care of two other judgments he has quoted. We want to know 97.3.
Yes.
Of the Bihar Service Code.
Yes.
You have that copy of Bihar Service Code with you?
Yes, Bihar Service Code.
These proceedings taken against you are under the CCA rules?
CCA rule.
Yes, CCA.
CCA rules provide separately. I have held in under the rules. The
CCA rule, I have got it, my lord.
Under the rule 17, my lord.
Rule 17 is the relevant portion.
Rule 17 is for CCA. For subsistence
CCA.
allowance, it is, I think, Rule 19.
Rule 19. Rule 19 is suspension. ये 97 पर है जो डिसीजन सब है. The principle settled by their lordship is that if the charge is not framed, I have annexed the charge in page 63, my lord.
We come to Rule 11.
11.
Treatment of service on reinstatement and admissibility of pay and allowances after suspension.
CCA rule, Hujur.
Yes. अभी अब तो जजमेंट दिया है ना डिस्ट्रिक्ट अथॉरिटी रूल 11 पे नहीं रूल 11 पे जजमेंट दिया है सस्पेंशन के लिए क्या हुई टेस्ट I have already given a judgment on this aspect.
Subsistence allowance during the period of suspension. Government servants deemed to have been placed in suspension shall be entitled to receive a subsistence allowance, an amount equal to half average pay, and in addition dearness allowance and admissible, provided that where the period of sentence has exceeded 12 months, the authority who has paid such order of suspension shall be competent to vary the amount of subsistence allowance.
Please don't look at rule. You are reading 10.
10. This is rule 10.
11.
11. Treatment of service on reinstatement and admission. 11 तो नहीं है.
यही है आप पढ़िए.
11 तो मेरे लिए लागू नहीं है.
पढ़िए.
जी. Treatment of service on reinstatement and admissibility of pay and allowance after suspension.
So you have been, your suspension has been revoked, na?
By the impugned order.
So that is reinstatement of suspension. After suspension, you have been reinstated back. Then what is to be done? This is what rule says.
When a government servant under suspension is reinstated or would have been so reinstated, but for his superannuation while order of suspension, the disciplinary authority shall consider and make specific order regarding the following: the pay and allowance to be paid to the government servant for the period of suspension ending with reinstatement or the date of his retirement or superannuation, as the case may be, whether or not the said period shall be treated as a period spent on duty. But in all the ruling, as I have referred before your lordship, their lordship has stated that, come to the conclusion that the period under suspension
Subclause 3 पढ़िए इसका. Subclause 3.
Subclause 3 of 11.
हाँ.
नहीं, हम दूसरा सबमिट कर रहे थे.
तो आप 97.3 दिखाइए.
97. हाँ, 97 में रूलिंग हुजूर हमारा सबमिशन इतना ही था कि जो एज पर 90
आपने जो जजमेंट दिखाया है इसमें 97(3) कोटेड नहीं है,
हाँ।
कोट नहीं है।
कोर्ट नहीं हम 97 पढ़ देते हैं हुजूर को, हमारे पास
पढ़
है।
दीजिए।
हम पढ़ते हैं हुजूर। Yes, 97.
Can you find your reply to this?
Counter affidavit has been filed, my lord. Reply has
उसमें
not been
कुछ
filed by
reply
the
नहीं
petitioner,
दिया।
my lord.
Counter affidavit दिया आपने?
Has been filed, but there is no reply.
What do you say?
I have made a definite submission, my lord.
What do you say in your
My lord,
count?
in counter affidavit, my lord, I have stated in para, my lord, 11, my lord, all opportunity has been given to the petitioner, my lord, and after giving so cause, reply has been filed, and after consideration of the reply, my lord, the order of punishment has been passed, my lord, on Exer C, my lord.
But he was required to independently pass an order with regard to the period of suspension, whether he should be paid the salary apart from subsistence allowance or not. He can't be saying that because I have punished, so we will not pay. The provision under section 11, subclause 3, requires rule 11, subclause 3 of CCA rules requires that disciplinary authority to take a separate decision.
Order has been passed.
We have already held so.
Order has been passed in twofold, my lord. First, my lord, the censor given, my lord, for the punishment of censor. Other, my lord, Shri Paswan ko nilamban avdhi mein
Have you given a hearing to this person before passing order regarding his subsistence allowance? You are withholding that subsistence allowance. Yeah? I think 97 also speak the same language as 11.
Yes, yes.
So a decision has to be taken separately.
This is, my lord, not done by the authority concerned.
Yes. So we have remanded it.
My lord,
we'll give you opportunity.
After giving opportunity, then I will pass the.
Yes. You are in service or you have retired?
Service.
You are in service, no? All right. So we are remanding it with direction to take a
One
decision.
thing I want to draw your lordship's attention. What my learned friend has argued, he is defending the order. I have made several submissions in the writ petition.
But you are not pressing that.
No, I'm not on that. Since he is justifying the order, and by remanding, your lordship will give the opportunity to the state government to pass a fresh order. Therefore,
only with regard to that part.
Only with regard to that part.
Yes.
Yes, madam. Take.
Likhi, we will pass an order in your.
Only with regard to confirm to that part. Yes.
I was thinking of passing.
Yes.
You so be satisfied.
Full salary for the period of suspension.
आपको दिखा रहे हैं आपके सामने.
जी.
The petitioner, by way of this writ petition, assailed the order dated 16/3/2018, passed by the respondent, whereby he was punished with penalty of censure, and also an order was passed withholding the salary other than the subsistence allowance already paid to the petitioner. The petitioner also challenged the order passed in appeal dated 29/8/2018 and the
order passed by
further
the
order passed on 12/9/2019. But learned counsel at bar states that she does not press her submissions relating to the punishment awarded of censure and the arguments raised with regard to the same. However, learned counsel submits that since the petitioner has only been punished with a minor penalty of censure, there was no occasion to withhold the salary of the petitioner apart from subsistence allowance during the period of suspension.
May I, 1 minute, may I? Your Lordship, allow me. That since no charge was framed, that the petitioner will not be allowed anything excepting the subsistence allowance during the period of suspension. Therefore, it is violation of Rule 97. That is the principle. That is, no charge has been framed.
The petitioner, learned counsel for the petitioner submits that there was no charge sheet issued to the petitioner, and without a charge sheet,
without providing any opportunity to defend myself on that point.
इसलिए हम नहीं लिखाते हैं कोर्ट के अंदर।
Sorry.
जी हाँ। ये तो इतने कंफ्यूज हो जाते हैं कि हम एक हफ्ता लग जाता है हमें आपके एक ऑर्डर को इसको फेयर करने में।
That there was no charge sheet issued to the petitioner, and without a charge sheet.
Without a charge sheet, the order of punishment was passed of censure, and
charge sheet matter is already issued.
Not charge was not framed on this point.
Anyway, let her say whatever she has to say, please.
Sorry.
I have seen the order.
Sorry.
If you, I can't be stopping any lawyer to say anything.
No, sorry.
Okay. And the punishment order has been passed, and therefore the salary for the period of suspension cannot be withheld. Learned counsel appearing for the respondent has invited attention to the orders passed by this court or by the government, wherein allegations were levelled against the petitioner and proceedings were initiated under Rule 17 of the CCA rules for major penalty. The petitioner had been suspended during the inquiry proceedings. However, on the basis of the inquiry report, the petitioner was found guilty of not following the instructions issued from time to time by the superior authorities, and therefore a minor penalty of censure has been awarded. Learned counsel submits that the order of, since the petitioner had been under suspension, the subsistence, the salary apart from subsistence allowance has also been withheld. I have considered the submission. Rule 11 indicates this court in Nipendra Kumar versus State of Bihar considered the similar position and found, and after having examined the provisions of Rule 11 of the CCA Rules 2005, held as under. ये पैरा 6 से पेज 6 से कर दीजिएगा फ्रॉम पेरिजल ऑफ अबव इट इज अपेरेंट से लेकर लास्ट तक जिनको दिखा दीजिए जज सेम पैरा Learned counsel for the petitioner has also invited attention of a judgment passed by a coordinate bench of this court, reported in 2013, volume 3 PLJR, page 1. Indu Prakash Sao versus State of Bihar, wherein Rule 97, Section 97 of the Bihar Service Code was taken note of. It would be opposite to court section 97 rule कर दो section नहीं rule 97 of the Bihar Service Code from perusal of above. This court notices that the same is in consonance with the provision contained under Rule 11 of the CC Rules 2005. Keeping in view above both provisions, it is found that the petitioner ought to be given an opportunity of hearing before passing of the order of withholding of salary during the suspension period. And in view of the judgment passed by this court, Supra, the writ petition is partly allowed to the aforesaid extent with similar direction as 2 months, same time, same order.
Item number 27. Mr. Mukesh Kumar.
Yes.
Item number 27, Mr. Mukesh Kumar and Mr. Ram Nivas Prasad.
ये रिजल्ट डिक्लेयर हुआ है नहीं हुआ?
In this case, I have received the statement of fact. Kindly.
What is it? Result declare हो गया नहीं हो गया?
No, Milords. Result cannot be Milords.
Earlier on,
that is the violation of the rule, Milords.
Okay, he has appeared for more than one time.
More than one time, Milords, and after leaving one paper, एक paper,
all right,
एक बार में.
File your reply.
Milords.
Counsel for the respondent wants 2 weeks time to file reply. List after 3 weeks.
Okay. Item 28, Srinivas Jha.
ये हमने रेफर कर दिया लार्जर बेंच को. हमने रेफर कर दिया. ये इशू हमने रेफर कर दिया लार्जर हो गया क्या? Then constitute.
I had mentioned it twice before the Honorable the Chief Justice, but till date it has not. My Lord, Arguing Counsel Srinivas Jha, ऑपरेशन हुआ है जो अनवेल है अभी 4 सप्ताह का समय इसमें हो गया.
Counsel wants time. Counsel is not is indisposed कर दो. In view thereof, the writ petition is adjourned for this afternoon.
Item number 29, Mr. Ranjan Kumar.
जवाब दे दिया क्या आपने इसमें? In the meanwhile, reply may be filed.
Item number 29. Item number 29, Mr. Ranjan Kumar Jha and Mr. Satya Prakash.
ये रिटायरमेंट के बाद आप फॉरफिट कर लिया आपने पेंशन? पनिशमेंट ऑर्डर आपने रिटायरमेंट के बाद दिया है? Have you taken have you passed order under 43B?
On the spot, Milords, taking bribe, Milords.
Huh? You want time to file reply?
Yes, please.
You have not filed reply. As the last opportunity, 3 weeks time is granted. 4 weeks. List again.
Item number 30. Mr. Ganesh Kumar.
43. So, 43.
Who appears in this case on behalf of the government?
Mrs. Shilpa Singh. Item number 30. Mrs. Gudiya Nisha and Mr. Ganesh Kumar and Mrs. Shilpa Singh, GA12 of behalf of the state.
Payment of salaries from 2006. Who appears? गवर्नमेंट की तरफ से किसी का नाम ही नहीं आ रहा है.
GA12 names appear.
Guria Nisha.
I will inform them, Your Worship.
पेमेंट ऑफ सैलरी का है ये केस
जी
2006 से नहीं दिया आपने
I will inform the
2006 से
office.
तो अपॉइंटेड ही नहीं होगा
The brief is not with my office, Your Worship. I will inform them.
Someone appears for the petitioner, keeping in view the law laid down by this court in Suresh Ram. The petitioner is granted liberty to file an appeal.
Item number 31, Mr. Santosh Kumar Mishra.
Lordship, I pray for password for cases 1 or 2 cases. My senior is on legs, Lordship. So I pray for 1 or 2 cases only, Lordship.
My lords, I have been informed by the clerk to the Mr. R.K. Giri, my lords, who appeared for the Raj Bhavan, my lords, that he is out of station. He will be coming on Monday, my lords. University has filed its counter affidavit.
What is the prayer?
My lords, for extending the date of joining, my lords, as an assistant professor.
So what do you say?
It was extended, my lords, but beyond the extended period, he could not join. And now, my lords.
Why he could not join?
Lordship, in COVID period, I could not join, Lordship. I am.
After the COVID period, then?
हजूर बैन कर दिए उसके बाद ज्वाइनिंग ये नहीं
as per the बैन का ऑर्डर है
My lords, as per the guidelines of the Raj Bhavan, my lords, it was to be extended for a certain period, my lords.
24/8/2020. That you cannot.
We are bound by the directions of the Honorable Chancellor, my lords. If Honorable Chancellor, that's why
want him to be here.
My lords, he is out of station, my lord. He will be coming on Monday.
Chancellor is not present. Let's discuss next Wednesday.
Item number 32.
May please do not.
लिस्ट बनी ना जो 2000 के ये जो मेंबर्स की लिस्ट
जी मैम जी
दिखाना
May please do not. My humble prayer before your lordship against the impugned order 4, annexure 4, my lord, by which in consequence of the order passed by the SDO, my lord, under the Public Grievance Redressal Act, my lord, that subject was even not included, not hearing me. That is the case of Talimi Markaz, and I have been removed from service, my lord, without asking any show cause, without hearing, no opportunity of hearing, my lord.
So what is the judgment which you have placed for?
Yeah, Hazur, Honorable Mr. Justice Anil
You
Kumar
don't have to
Sinha
say
ka-
about the name of the judge. You tell us whether you are the petitioner in that case or some other cases.
I was
for
not-
the purpose of citation.
Citation, my lord, only. And even your lordship has been pleased to decide batch of cases of Talimi Markaz.
Talimi Markaz wale cases se.
वही case है Hazur.
Huh? Both the counsels are addendum that the issue involved in the present case stands finally adjudicated by this court in judgment so and so, wherein this court has held as under the petitioner who has, by way of this writ petition, prayed for quashing of the order dated 20/12/2016. क्या ग्राउंड है? वही है ग्राउंड
जी सेम है हजूर ना
कि
तो
भाई आप दूसरी कम्युनिटी के हैं
जी हाँ हजूर बस भाई भाई बस वही और कुछ नहीं
in view of the aforesaid adjudication, the writ petition is allowed on the same terms, mutatis mutandis. ये तो उसके अंदर रखा जाएगा रिकॉर्ड पे जो चाहिए
एक फोटो
उसको रखा दिए बाकी
जी
Yes.
Item number 33, Mr. Manoj Kumar Manoj.
My lord, yes. My lord, yesterday Joseph has asked whether we have gone into the appeal or not, on which the petitioner is relying on, my lord.
Yes, Mohammed Asim versus State of Bihar.
My lord, in the case of Mohammed Azaz Kashar, my lord, in which these cases were disposed of, in that the state has preferred appeal, my lord.
Appeal हुई है pending है?
Yes, my lord. Appeal number LPA number 805 of 2022, my lord.
What happened to that? Is pending?
My lord.
Learned counsel for the petitioner by the respondent states that the order passed by coordinated bench of this court is in similar case is a subject matter of appeal in LPA number
805 of 2022.
805/22, which is pending. Keeping in view thereto, adjourned for 8 weeks.
Item number 34, Mr. Ashok Kumar Garg.
My container has been rejected only on the basis that the petitioner father is non-resident of the Bihar, my lord. Though the petitioner has got married 2002 in the year in Bihar, my lord, and several times the respondent authority has issued the domicile certificate, my lord, which is an Annexure 2 series, my lord. 2010, 2014 and 2020, my lord, they already issued the...
You are claiming reservation on some post? Claiming reservation?
Assistant professor, my lord.
No, you are assistant professor to post.
Yes, my lord.
Are you claiming reservation?
Reservation BC category, my lord.
Huh?
BC category, my lord.
हाँ रिजर्वेशन क्लेम कर रहे हैं.
Under the reservation you will not get it. Supreme Court का judgment आ गया.
My lord, they pointed out thereafter I already deposited the required court fee and requested to treat him to the general note. That's why.
As per general, are you in merit?
And my lord, maybe, my lord.
Huh?
Maybe.
Now maybe का तो बहुत बड़ी बात. Are you praying? Have you prayed in this petition?
My lord, para 10, my lord.
Have you prayed? Para 10 is not your prayer.
Yeah. Para 11 already stated, my lord, the prisoner filed objection indicted so and she also deposited extra application fee of 225 to the respondent authority and requested to consider for her condition for the said post treating him as a general candidate in the situation if the respondent may not consider.
general में आते हैं तो कर लीजिए. Learned counsel for the petitioner.
Permitted me to file identical issue is pending, my lord.
Fairly admits that so far as the claim of the petitioner as a reserved category candidate on account of getting married in state of Bihar is concerned, stands denied in view of the judgment passed by the Supreme Court in the case of 2020-21 का जो keeping in view the law laid down by the Apex Court as above, learned counsel prays that she should be treated as an open category candidate, and if she finds her name comes within merit, she may be called for interview in the open category.
Yes. The process is completed, my lord.
The learned counsel for the respondent submits that during the pendency of the writ petition, the interviews are over. However, taking into consideration the facts of the present case, this court is of firm view that a candidate's candidature cannot be denied in open category merely because she claimed reservation under on the basis of being married in the state of Bihar. The respondents are directed to examine her case, whether she falls within the merit of those who have been called for interview, and if she comes within the same, her interview may also be taken before declaring the final result of the post of assistant professor of psychology. The writ petition is partly allowed to the aforesaid extent. एक्सरसाइज करो, लड़की लेडी है, अपने मेरिटोरियस कैंडिडेट अगर डिनाइड हो जाता है the most single and foremost criteria which this court feels is a meritorious candidate should not be denied. If he is meritorious and because of some technicality you are throwing around, then wrong. Lesser money, what is your purpose? The commission has to purpose is to get the best.
Yes, my lord.
And if a person on account of
But under the defined parameters, my lord, what
defined parameter?
defined parameter, which is our clauses of
ये
the
जो है ना ये है where the courts have started intervening, because this is the law where these strictures, this is called red.
Let it be this aspect. Let it be this aspect, my lord, let it be this aspect also.
We will say some other day.
In this order, so that it will be open eyes for the everyone.
We will say some.
Last two order, your lordship may kindly say.
Item number
And day
35.
before yesterday, counter affidavit copy is served to me. So this may be taken up on Monday. Day before yesterday, a long counter affidavit is served.
तो rejoinder भी आ गया counter affidavit का. उसके बाद कौन सा counter affidavit file कर दिया?
No, it is reply to the rejoinder, your lordship. It is reply to the rejoinder, your lordship. And
there is a rejoinder.
Last order, your lordship.
So now you have filed a reply to the rejoinder.
Your lordship.
That is called surjoinder. And now he wants reply, wants to file a reply to the surjoinder.
On Monday only.
इसमें कुछ दम भी रह गया नहीं रह गया?
दम है, तभी तो आपने
Your lordship,
उतना बड़ा.
The Supreme Court
क्या है?
काउंटर देने के लिए आदेश.
नहीं ये सिलेक्शन, ये तो 2003 का कुछ चल रहा है मामला.
कौन वाला?
पता क्या
वो
विजय कुमार सिंह बोला
है क्या केस
ये टर्मिनेशन का मैटर है.
कब का?
टर्मिनेशन तो 2003 में सबका हुआ, बहुत लोगों का हुआ था, हजारों का हुआ था, बहुत का अलाव हुआ, बहुत का डिसमिस हुआ, इसी तरह से होते जा रहा है. जो सच है सो है.
The service is void ab initio, your lordship.
हम इसमें हमसे ज्यादा इसके जो वकील हैं वो तैयार हैं, इसलिए सोमवार को जरूर कर देंगे.
चलिए.
उन्होंने कहा कि हम एक करेंगे.
Put up after.
खाली सोमवार मंडे को.
Your lordship.
या जैसा अच्छा लगे.
नेक्स्ट वेडनेसडे को जाएगा.
ठीक.
Your lordship.
दोनों एक ही है.
दोनों एक ही.
36. Your lord.
Item number 37, Mr. Anil Kumar Tiwari.
The grievance for which the petition is looking for, my lord, that matter has been set at rest by the Honorable Supreme Court. That relevant judgment would be lordship at page number 219, my lord, of the brief. Page number 219 of the brief, my lord. 37.
ये तो यहाँ का है 290.
In that case,
Supreme Court का कहाँ है?
in that case, the judgment of the Honorable Supreme Court has been dealt, your lordship.
No, how can this court deal with the court judgment?
नहीं, हम बोले भाई still
We can quote the judgment, but we can't deal with it. Dealing is their job.
जी. आप ही का है, कीजिए ना. हम यूनिवर्सिटी कर रहे थे मैटर, आप कीजिए ना सर.
इसकी बात तो जो यूनिवर्सिटीज के उसके लिए यहाँ पे कमीशन बन गया था to look into what the services of the teachers.
That is Honorable Justice S.N. Jha Commission.
Justice Agarwal. Commission was formed for that purpose, and then yes, and then Justice S.B. Sinha's judgment.
Later on.
So that was only for these professors and lecturers of the universities who were alleged to have been appointed wrongfully or.
ये ad hoc है. ये ad hoc है. This case may not be covered, Your Lordship.
कब से ad hoc है?
85.
He is seeking
1985.
1985.
जी, July.
So you were not considered by the commission. उनका भी तो consideration हुआ है.
No, we were not considered. We were not considered.
In fact, my lord, he is seeking
Consideration हुआ है भाई. All
फोर्थ फेज का था.
फोर्थ फेज का मिस्टर जस्टिस अग्रवाला कमीशन कर दिया.
हाँ.
उसमें कैटेगरी बना था वो.
उस कैटेगरी में एडॉक वाले भी तो थे.
R1
जो एडॉक काम कर रहे थे 85 से 73 से.
R1 R2 करके कैटेगरी था.
यस माय लॉर्ड, R1 R2 एंड R3 करके था.
हमने एक बार देखी थी उस रिपोर्ट को.
Not considered.
देखकर देखिए फिर आप क्या क्लेम कर रहे हैं बिफोर दिस.
हम क्लेम कर रहे हैं कि पेमेंट्स so far I have worked since 1985 that salary should be given to me. I have been terminated in January 2022. 2022. 21/1/2022.
तो ये तो 2013 की पिटीशन है, आपने 2022 में कैसे
terminate? Kindly see the prayer portion, your lord. He is seeking salary from the initial date of appointment till the year 1991 only.
No. Subsequently, I have been. Previously, I filed this petition for the salary when I was working. Now I have been terminated in 2022. So salary should be paid from beginning to the last. That is my prayer, my lord.
Yes.
My lord, in this case, my lord, in fact, my lord, petitioner was appointed as a convenience allowance, my lord.
No.
If you have paid conveyance allowance, that means you have treat him as working with you.
My lord,
that is if you pay conveyance allowance, for what purpose will he come to your university and be paid conveyance allowance? Chalo, we will examine this case. There is any other case of this? There is only one case.
In fact, earlier this matter was being heard with another writ application. The initial order suggests, but later it was bifurcated.
I have given the order, my lord. That was, my lord, considered by petition court and that the petition was dismissed.
In fact, what he is saying, my lord, the writ application which was being heard together, your lordship, that one of the writ application has to dismiss, your lordship.
I have already dismissed because there was no appointment letter to her. They are quoting.
This is the appointment letter.
Triparthi judgment. The order was passed by this honorable court to pay as per Jagjeet Singh decision of the Supreme Court.
On exactly on similar footing, my lord, one DC Kant Upadhyay has also, my lord, filed writ petition by dismissed.
फिर उसके बाद क्या है ये वाला?
ये ऐसे कैसे कराएंगे?
Similarly, of the same college.
Second order. The same college.
कौन सा दी?
Yes. Pass the same order.
Will examine, your lordship. Just now I have.
Contempt has been filed against them. Against this order.
Will examine that, my lord. Let it be posted after a week, my lord.
आपको पिछली बार भी टाइम दिया था.
नहीं.
We had given you time.
In fact,
for the university wants further time to examine the case of the petition, to submit to this court with reference to the judgment passed by a court bench of this court in CWJC 625/2019, as well as 16130/2013. Next Wednesday?
Let it be pushed after 2 weeks for a safer side, my lord, because I am not having the file. I will take from my London senior friend, my lord. Just now I went through the
दे दो आपके पास भी फाइल नहीं मिल रही थी पहले
जी
सब फाइल हमारा अटेंडेंस भी गायब कर दिए लोग फाइल भी गायब कर दिए and the court they are saying your lordship that he has not worked after 90
आपके ये पेटिशनर तो है ना वो तो गायब नहीं हुए ना बाकी सब चीजें ठीक है
दे दीजिएगा सर कॉपी
वो मिलते रहने चाहिए आपको
Item 38.
My lord, as per the order dated 19/1/2023, my lord, a specific affidavit was to be filed regarding claim of the petitioner, my lord. We have filed supplementary counter affidavit on behalf of respondent number 4, my lord, on 30/1/2023, my lord. And
Annexure B, my lord.
My lord, regarding
Payment.
the difference of salary, my lord,
What do you
that has
say?
been paid, my lord.
That has been done.
That has been done, but
हो गया सब कुछ मिल गया benefits.
ACP has been granted, 1 ACP and 2 MACP, but the payment has not been made. Only my grievance before your lordship.
Actual benefit has not been
granted. Actual benefit has not been.
File your affidavit.
Reply.
हाँ इसका affidavit file करिए. इनको कॉपी दीजिए ये पता करवाएंगे क्यों नहीं दे रहे
नहीं बोल
या
my
grant हो
lord,
गया?
I am seeking further 2 weeks time regarding will
Actual payments.
actual payment whether it has been
for the respondent wants further 2 weeks time. Just after 2 weeks.
Please, your
Item 39.
Date दे देना इसमें.
Jim.
Yes.
Mr. Rajiv Ranjan.
तबीयत बहुत खराब है मेरी तबीयत खराब है जो 2 सप्ताह का समय कम से कम
आप अपने हुए बोल रहे हैं ये तो हमें बताइए कि क्या कहना चाहते हैं ये माइक है ना माइक
तबीयत मेरी खराब है
तो आए क्यों हैं यहाँ नहीं आते यहाँ और भी तो लोगों को बीमार हो जाएंगे घर रहिए
2 सप्ताह का समय दे दिया जाए
ये बाकी हम देख लेंगे
ऐसे हुजूर
दम भी है नहीं है देख लेंगे
एक जजमेंट हम हुजूर और
ये तो देखिए हम यही कहते हैं वकील की कभी तबीयत खराब नहीं होती कोर्ट में रहता है तो ये तो घर में तबीयत खराब होती है बहस करो you will be all right when you argue ये जजमेंट तो आपने दे दी पिछली बार
एक और हुजूर हम
चौधरी विमल कुमार रॉय
एक और दे रहे हैं
कौन सा दे रहे हैं
LPA की जजमेंट.
हाँ क्या दे रहे हैं
हुजूर हमने 2 डिसीजन उस दिन
he will be required he is not required to pass this examination.
My lord, that is what just now he has given.
It's a division bench judgment.
Division earlier.
And earlier division bench judgment is also there.
I had also submitted on the earlier date 2 division bench judgment, your lordship, which says that it was required, your lordship, and that is why the matter was adjourned. That today it will be heard extensively. And that is why...
तबीयत खराब हो रही है बहस करिए बहस करिए माइक है आपका ज्यादा जोर से बोलने की नहीं ये माइक अच्छा है इसमें बोलिए ना इधर आ जाओ थोड़े से इधर है यू आर ऑन लाइव The entire India is looking at you. Please understand this.
ये जो दवा चला है मतलब 5 दिन का, फिर आज रात में निकाला।
आपने सोचा था कभी कि आपको पूरा इंडिया देख रहा होगा माइक पे? ये लाइव हो रहा है आपका। आप जो बहस कर रहे हैं वो सब पूरा दुनिया देख रही है।
नहीं
देख रही है।
उसी में शुरू में वो जजमेंट निकाल करके हम रखे थे, वही साथ में लेते आए हैं।
कब रख दे?
2 सप्ताह का। 2 सप्ताह का समय दीजिए।
2 सप्ताह
ठंडा लगता है।
Counsel for the petitioner states that he is unwell and is unable to assist the court. List this case after 2 weeks. Date दे दे?
दे दिए।
लगा दे कोर्ट में? कोर्ट में लगा दे, आ जाएंगे 2 हफ्ते बाद तो।
हाँ लगा दिया।
चलिए।
I beg pardon, Your Lordship. Item number 42 relates to item number 42. It relates to grant the certificate of the handicapped certificate of the disabled degree B.Ed. Lords, and in spite of the Lordship order on 3/1/2023, a specific direction was given to serve the copy of the counter affidavit on behalf of Honorable Chancellor, but today it has not been served.
Copy has been served on the other council, my lord, and he could not be traced, so we are serving.
Give him.
My lord, we have.
He's giving you. दीजिए। अच्छा हुआ ना इन्होंने बोल दिया, फिर आपको ट्रेस भी कर लिया इन्होंने।
One prayer, Milords, let Milords any date may be fixed.
ठीक है, डेट तो आ जाएगी इसमें। चलिए, डेट तो आ ही जाएंगी। नेक्स्ट वीक लगेंगे केसेस जो बाकी बचे हैं, वो केसेस नेक्स्ट वीक लगेंगे।
जी।
Serial number 40, Milord. GPSC has filed affidavit, served on 31st, Milord. Let it be after 2 weeks.
Milord, in this case, Milord, my Lord has directed on the last occasion to.
तो नेक्स्ट वीक नहीं रखें?
Yes, Milord,
नेक्स्ट वीक रख रहे हैं ना भाई। आप कोई मेंशन कर रहे हो इंफ्रक्चर्स हो गया हो तो बता। 2013-14 के केसेस हैं। Any of the cases from 47 to 74 which have become infructuous.
Order हो गया है, उसी में मेरा counter.
Any other matter?
In item number 42, my lord's direction was to tag one other case along with this case, but that has not been tagged, my lord.
देखिएगा भाई, चेक करिएगा, compliance होनी चाहिए।
My lord.
Yes, any other mentioning?
Your Lordship, 47. Your Lordship, item number 30, I beg your pardon, Your Lordship. Item number 30.
30 is already over.
Actually, sir, the council is injured.
Already over.
Kindly provide us.
See the order. If you have to file review, you may file a review. Nobody stops you.
Item number 47, Lord, I pray for time.
47 तो टाइम ही है जो नहीं आया। ऑप्शन वालों के यूनिवर्सिटी ऑप्शन में जो कंपनी मैटर्स में जो ऑप्शन वाला हुआ कैसे करेंगे? कल डीबी बैठी
कल थर्सडे को जी मतलब कल
on petition item 1.
In this case, I have been asked to make a prayer for Passover, as there is some beverage in the family of Mr. Umesh Kumar Advocate. He has gone to his village home.
On account of bereavement in the family, seeks adjournment, counsel for the petitioner. Put up after 2 weeks.
Item number 2, with analogous case, Mr. Nikhilesh Kumar.
Make plea. Lord, so far, appellant in first case is concerned, my Lord. He has been convicted under section 20 and 22 of the NDPS Act
for recovery of 27 kg gaja from his joint house, and he has been sentenced for 14 years in both the sections, and fine of rupees 1.5 lakhs. My lord, he is in custody for more than 8 years, 9 months.
This first case, Baran Mato.
Barhan Mato. Barhan Mato. First case. It is more than 9 years, 9 months. 8 years, 9 months. Custody since 26/4/2014.
Hmm. 27 kg of ganja?
Ganja.
Yes.
In this case, my lord, I have filed on 28th of January 2023, I have filed, my lord, the written objection. It was disapproved on 21/1/2023. Again, I filed, my lord, on 23/1/2023. But the status is showing that it is pending for approval. And so for
what is approval?
Earlier, I was directed to file written objection.
No, but that written objection, where is it pending for approval?
I don't know, my lord. I have filed on 23/1/2023.
ये बताइए क्या अप्रूवल के लिए कहा जाता है? ये काउंटर एफिडेविट फाइल कर रहे हैं इसका
ऑनलाइन फाइल का सिस्टम कर दिया गया, उसमें परेशानी हो रही है।
इसका अप्रूवल नहीं है।
ऑनलाइन की अप्रूवल?
जी मैडम।
अप्रूवल फॉर व्हाट?
अप्रूवल वो सही है कि नहीं my lord का लेक्चर शिफ्टिंग में अप्रूवल रजिस्ट्रार लिस्ट देते हैं।
तो आप ये भी तो फाइल कर दीजिए ना।
My lord, until unless the approval is not being given, we can't file the hard copy.
Hard copy वहीं फाइल किए हुए।
After getting approval, online filing there.
We are facing day-to-day problem in filing counter.
My hard copy is there. My hard copy is there, my lord. I have filed my hard copy.
You have filed your hard copy?
Yes, on 23/1/2023.
What are your objections?
Objection is, my lord, it is true, my lord, that 23 kg ganja of
27
kg of ganja was recovered. My lord, this case is covered, fully covered with, I have given the list of judgment, my lord. One judgment I have.
But can't we deciding it? We are only asking about your objection relating to sentence suspension.
So for Section 37 itself bars lordship that during the pendency of appeal lordship, after conviction, until unless the judgment is not being declared perverse lordship, the sentence can't be suspended lordship. And when the moment the judgment will be
judgment of this lord?
Yes, ma'am. Lokesh Chadda, my lord, 2021, SCC, volume 5, page 7 to 4. Last 3 paras, my lord. 7 to 4, my lord. Last 3 paras is relevant, my lord. 3 paras.
And that judgment also says that section 37 or whatsoever do not preclude the court to consider the case for grant a suspension of sentence. सेकंड पेज के सबसे पहला पैराग्राफ का नीचे का 4 लाइन में हुजूर दिया हुआ है।
NDPS application. You have been convicted for offence under section
20 and 22. That case is relating to section 24.
24, yes.
Of the NDPS Act.
And
My Lord,
26.
I may be permitted to submit that in that very judgment also, and in another judgment of Supreme Court has been referred, the earlier paragraph, last 4 lines, my Lord will find that the court has observed. In that case, what was before the Supreme Court, the Honorable Delhi High Court has allowed the bail application and no reason was assigned. And that was challenged before the Supreme Court. That my Lord will get from the fact of that case mentioned in that judgment.
In fact, in that case also he was convicted for 23A. He was not convicted for 19, 24 or 27A.
Which section is different?
So if
But the section 37, my lord, of the NDPS Act
bars no person accused of an offence punishable for offences under section 19, section 24 or section 27A. Only there the bar is there.
And for offences.
And for offences. And also for offences involving commercial quantity. Now 27 ganja is...
Yes, commercial quantity. It is commercial quantity.
More than 20 kgs.
Commercial quantity.
And judgment also says that this do not bar the High Court. That judgment which he had referred, I am...
मुझे suspension बिहार का मुझे था ना वो separate suspension का direction. Supreme Court. With collection था. दे दीजिए.
And appellant is now, my Lord, 68 years old. In the judgment, his age has been shown as 62 years. And judgment is in April 2017, and it is now 23. And that judgment which my Lord, my friend has referred, that
Yes.
also says that for...
What have you said about the recovery part?
it had been recovered from the joint house of the appellant as it alleged. And my lord, in ground
recovery has been proved?
Yes, madam.
my lord, no other witnesses except the police personnel and sipahi were examined. No other independent witness. And section 41 of the 42 of the NDPS Act has not been followed. That is the main ground and contention in this appeal. That judgment also says that the High Court is not precluded to consider the suspension of sentence for any other reason. In that case, the Delhi High Court has given no reason, and therefore that matter went to the Supreme Court and it is held.
Shivnandan Mahato is not supported. He is the independent witness. PW4, page 6.
Both the CLS witnesses. Both CLS witnesses are not.
Shivnandan Mahato says that Gaja has not been recovered in his presence, PW4, page 6 of the judgment. PW5 is also independent, Dinesh Prasad. On the same page 6 of the judgment, he also said that his statement was not recorded.
But they were all arrested in the same place. Any person?
After 10 days.
You wait for some time. You withdraw. Or we pass an order. Whatever.
My lord.
Keeping in view this judgment.
वही वो जो हम कह रहे थे उसमें भी जजमेंट में रेफरेंस है दिया हुआ है
नहीं, that discretion is there. We have no doubt in our mind.
So
but considering that you were arrested at that same place at the time of seizure.
घर में ही से अरेस्ट हुआ रात में घर में रेड किए तो सारे लोग घर में
in front of you that the ganja was
इंटायर
recovered.
पूरे गांव में 10-15 लोगों को गिरफ्तार किया गया सबको
सबके पास से मिला है
सबके पास से मिला किसी के पास से 10 किलो
गांव पूरा इसी काम में लगा हुआ है तो थोड़ा तो रोके
एंड सेकंड केस में हुजूर 15 kg रिकवर्ड है लेस देन कमर्शियल क्वांटिटी सो द प्ली टेकन बाय द लर्नड फ्रेंड will not apply in that case.
Yes, what do you say? ये भी 8 साल से अंदर है
नहीं इसका जो हुआ 7 साल लगभग 7 साल हम मोर देन 7 years 10 साल का
अभी रुक जाइए दोनों में रुक जाइए लेट देम डिस्ट्रिक्ट लिखाएं लिखिए
जब भी हुजूर कह दिया जाए तब भी रुक जाए
हम कहेंगे कुछ नहीं सुप्रीम कोर्ट ने बिहार के लिए there are certain directions which have been issued for pendency of the cases of sentence suspension.
I am not saying my lord is adjourning or not pressing it. I am, as my lord said so. I will wait for some time. Maybe adjourn.
No, not adjourn. We will pass an order. Either you say that I do not press and we will dismiss it saying that is not pressed. Or you say we will pass a next detailed order.
Then, my lord, some time should have been there so that I might make press.
You need instructions. From whom?
नहीं, instruction नहीं.
नहीं, हम ये नहीं कह सकते. We can't force another judge to give it after 6 months he should grant bail. We may be there, we may not be there.
I am not saying that.
So,
I may renew such prayer.
That you may do, that whatever you may say. लिखिए जी लिखाई देते हैं मैरिज को लर्नड काउंसिल फॉर द लर्नड पीपी
आफ्टर दिस रिजेक्शन
रिलाइज ऑन द जजमेंट पास्ड
ठीक है
बाय द एपेक्स कोर्ट इन 2021 5 SCC 724
ठीक है हुजूर विथड्रॉ कर लेते हैं
काउंसिल प्रेज आफ्टर सम आर्गुमेंट काउंसिल प्रेज टू विथड्रॉ द
हियरिंग
विल एप्लीकेशन एट दिस स्टेज ग्रांटिंग लिबर्टी to file fresh after appropriate time.
Submission indication is there.
This list is not pressed.
Lekin his plea was not applicable in quantity less than commercial quantity. 37
Item 3
not come in the way.
For few cases, Major, pass for a few cases, arguing constantly on name.
आ रहे हैं बहस करेंगे
जी
श्योर
हाँ सर
Item 4
In this case, by order dated 2/8/2019, the prayer for bail of the appellant has been refused for present, Your Lordship. Now the appellant remain in jail for more than 6 years and 8 months, and conviction is of 10 years, Your Lordship.
What is the amount of recovery?
The recovery is from a vehicle when the appellants along with others were on way, and the informant being the police officials got information, intercepted the vehicle and recovered the 2 bags and containing 14 kg and 16 kg in each of the bags, beneath the seat of the vehicle, the appellant is neither the owner of the vehicle and he was only found seated inside the vehicle without having knowledge with regard to keeping liquor by the driver or the owner of the vehicle.
How have you explained yours being sitting in that car?
I was inside the vehicle.
But how have you explained? As a passenger?
As
a traveler? What have you explained yourself, your presence there?
I was unaware with regard to
was it
the consignment kept inside the vehicle.
So you were traveling
and my prayer for bill was rejected by order dated 2/8/2019 for the present.
Or the present means?
Abhi, Tatkal. That too was in the year 2019. Have a glance to the order dated 2/8/2019.
क्या करेंगे वो? आपका खरीद कराया हुआ है आप बोल
तो 3 साल हो गए 2 साल के
चल दे रही
लिखिए
yes
Yes, followed. The appellants were apprehended while in a Scorpio vehicle lottery, which was not commercial vehicle, rather private vehicle lottery, and commercial quantity of contraband ganja lottery was seized from that very vehicle, in which this appellant was sitting lottery. 30 kg ganja was recovered lottery.
All right.
And his partners who were apprehended along with these appellants are there. They were apprehended for this consecutive second time for the same offence.
For that they were convicted.
So it appears that they were dealing with in the business of illegal contraband ganja lot.
And in this case, Lordship, out of 5 accused persons, the 2 were convicted and has been sentenced to undergo for 20 years. They are Pappu Kumar and Gulabi Singh alias Gulab Chand Mandal. And so far the 3 are concerned, Chamru Singh, Suresh Chaudhary, Isapilant and Praveen Kumar Mandal. They have been sentenced to undergo RA for 10 years. And taking into the entirety of the case, Your Lordship, the earlier prayer for bail of the appellant was rejected with an observation for the present. And he remained in jail for 6 years and 8 months. If out of 10 years, Your Lordship, if a remission period would be concluded, then he remained in jail for about 9 years.
Anything else?
earlier rejected, my lord, by order in which for the present, your lordship. Now after about 4 years, present interlocutory application is being made.
The petitioner is in jail since
6/5/2016.
6/5/2016 and has been sentenced
9/5
to undergo 10 years RI along with fine. Letter comes for the petitioner subject that he has already served more than 6 years in jail.
6 years and 8 months.
And 8 months in jail, and the appeal is likely to not come up for hearing in near future. He further submits that he has been convicted on the ground that he was found sitting in the vehicle from where 2 bags of ganja were recovered. The vehicle, he is neither the owner of the vehicle nor he has any previous conviction to his disability. There were other 2 persons traveling in the vehicle who were found to be having earlier antecedent of drug peddling. It is also submitted that the recovery has been supported only by the police witnesses who were members of the raid party, while the other independent witnesses mentioned in the charge sheet have not supported the case of the prosecution. The involvement of the petitioner in commercial activity has not been proved. Per contra, learned counsel appearing for the state opposes the bail application and submits that the ganja recovered, total ganja recovered is 30 kg and above the commercial quantity. We have considered the submission and perused the record as well as the judgment passed by the court below. The appeal is likely to take time for hearing. It is also noticed that the report, FSL report, has not been proved in the court. And the recovery is also not proved by any independent witness. The role of petitioner is being sought to be made on the basis of statement of co-accused who have been found to be involved in the previous drug peddling. Considering overall circumstances and without further commenting on merits of the case, taking into consideration the long incarceration of the petitioner, we are inclined to allow this bail application subject 50,000 surety of like amount.
Exhibit 3 was the FSL report.
FSL report? Who PW3?
Exhibit 3.
Who has proved it?
Lord, of course, it was not the officer of the FSL.
That is what we are saying. Not proved.
Mal.
Item 5, Sunil Kumar.
Lords. Lordship, this is a case of triple murder and punishment under section 147 for 2 years, 148 for 2 years, 302 reduced section 149 RI for life and fine of rupees 5,000 under section 307 reduced section 149 5 years plus fine 342 reduced section 149 1 year 458 reduced section 149 5 years and 506 reduced section 149 2 years, Lordship. Lordship, in the FIR, 25% has been named and 20 to 25 persons were unknown and they have been involved in the Lordship, may I read the FIR that will clear the bone of contention, how he identify the move of the person and whether the dispute was with the appellant or not. After investigation, Lordship, charges submitted and 7 persons were faced trial and one Sita Yadav is before your Lordship his first time on the point of suspension of sentence and grant of bail is being argued, Lordship. That is Sita Yadav. I am representing Sita Yadav, Lordship. Out of 7 persons, 3 persons has been acquitted and 4 persons have been convicted under the aforesaid section, as I have already explained, Lordship. Lordship, first of all, I want to draw your attention, Lordship, on the FIR. May I read, Lordship? मैं 100 आज दिनांक 12/12/17 को 10:30 बजे दिन में PMCH इमरजेंसी वार्ड में पुलिस पदाधिकारी के समक्ष बयान देता हूं कि हम लोग का पूर्व से ही जमीनी विवाद एवं दरवाज़ा खोलने को लेकर लाली यादव, लॉर्डशिप, दैट इज इम्पोर्टेंट, लाली यादव से चल रहा था। मेरा 3 फीट जमीन लाली यादव के घर की तरफ निकलता था, जिसका नापी भी हुआ था। नापी में मेरा 3 फीट जमीन लाली यादव के तरफ निकला, फिर भी हम लोग 3 फीट जमीन लाली यादव को दे दिए। हम लोग को हम लोग लाली यादव से घर के पश्चिम तरफ दरवाज़ा खोलने के लिए अनुरोध किए, किंतु वे लोग ज़बरदस्ती हम लोगों को दरवाज़ा खोलना नहीं दे रहे थे। इस बात को लेकर लॉर्ड, दैट इज़ वेरी इंपॉर्टेंट, बोन ऑफ कंटेंशन, झगड़ा का जड़ क्या है। इस बात को लेकर दिनांक 11/12/2017 को रात्रि करीब 12:10 बजे करीब 50 से 60 लोग का जिक्र कर रहे हैं जो हमारे घर को चारों तरफ से घेर लिए। उस समय हम सभी लोग सोए हुए थे। अचानक कुत्ते के भौंकने की आवाज सुनाई दिया तो हम घर के दरवाजा से बाहर झांक कर देख रहे थे, जो FIR में करे झांक कर देख रहे थे। इज इट पॉसिबल लॉर्ड से कि दरवाजा अगर झांक कर 60 आदमी को आइडेंटिफाई कर पाएंगे रात में? देयर इज ऑल्सो नो सोर्स ऑफ आइडेंटिफिकेशन। हुजूर और आगे हम बता दें। दरवाजा खोल बाहर झांक रहे थे, देखे तो पाए कि करीब 50 से 60 आदमी हमारे घर को हथियार लैस होकर घेरे हुए हैं। इससे वे हमारे लाली यादव 25 लोगों का नाम आ रहा है, इसमें मेरा भी नाम है। और डिफरेंट पर्सन का नाम दे रहे हैं हुजूर कि कौन कौन किसको मारा है। 3 आदमी हुजूर डेड पर्सन हैं, दे आर राजू, ललित एंड वीरेंद्र लॉर्ड। हमारे बारे में हुजूर लास्ट में आया हुआ है कि लालती देवी एवं सीता यादव, डेट इज एक्विजिशन अगेंस्ट मी लॉर्ड जी। भाई सुरेश उर्फ राजू को पकड़कर जान मारने की नियत से बुरी तरह मारने लगे। डेट इज एलिगेशन इन द FIR लॉर्ड। आफ्टर इन्वेस्टिगेशन चार्जशीट was submitted lordship and charges were framed lordship। हुजूर चार्ज देखा जाएगा, 7 आदमी के खिलाफ चार्ज फ्रेम हो रहे हैं। 147 में हो रहा है हुजूर, 148 में हो रहा है, 302 रेड सेक्शन 149 में हो रहा है, 307 149, बट there is no framing of charge under section 149।
149 सेपरेटली करने की जरूरत का है?
कहीं नहीं हुआ।
फिर 302 149 करा है ना
लॉर्ड,
और 307 149 करा है
लॉर्ड। बट देयर इज फॉर 149 देयर आर 2 main ingredients, the unlawful assembly, there should be unlawful assembly, and there is a common object। But in the entire evidence, Lord, there is no evidence on the common object। हम उसको हुजूर के सामने हम दिखा देंगे। तो there is no framing of charge under section 149, but 302 149 and 307 149 has been framed, Lord।
When you say 307/149, what is the meaning?
Lordship,
common object,
Lordship,
to cause injury which is dangerous to life,
Lordship। But in the entire evidence from the prosecution witnesses, Lordship, none material be produced by the prosecution witness to suggest that there was common object।
all right।
हुजूर अब देखा जाएगा FIR में जो हुजूर हम दिखा दिए, बोन ऑफ कंटेंशन क्या है। दरवाजा को खोलने के लिए झगड़ा हो रहा है। विथ whom? With लाली यादव। I am from the different village and different PS। And next, Lordship, इनका सोर्स ऑफ आइडेंटिफिकेशन क्या है? दरवाजा से झांक रहे थे। Lordship, हम अपने आप से क्वेश्चन कर रहे हैं, क्या दरवाजा से झांकने के रात के समय, इवन देयर इज नो मून लाइट,
Have you suggested that there is no light?
Lordship.
In your cross-examination, have you
Lordship,
suggested?
that has come. That is come.
In your cross-examination, have you suggested?
Lordship, in the evidence of IO.
Are you?
I'm one by one I consider the witnesses, Lordship. बस थोड़ा सा हमको समय दिया जाए, since I, Lordship. अब विटनेस देखा जाए, 12 witnesses has been examined. Out of them, 6 are material witness, and rest are the formal witnesses, including IO PW10. Hujur, PW1, who is eyewitness and injured person of the ऑफेंस लॉट, PW1, इनके बारे में कहा जा रहा है कि हमने इनको मारा, और एक वन ललिता देवी, ही डज नॉट नेम मी लॉर्डशिप.
PW1
लॉर्डशिप,
क्या नाम है उनका?
सुरिष्ट कुमार, PW1 लॉर्डशिप. नाइदर इन चीफ नॉर इन क्रॉस लॉर्डशिप. He specifically stated that who has assaulted him. पेज 2 पे देखा जाएगा, पैरा चीफ में हजूर, मुझे भी सतीश कुमार रणधीर कुमार मारा. His evidence value is much higher than other witnesses, Lordship. अगर इन्होंने मेरा नाम ले लिया रहता, there is no need of other witnesses, Lordship. That is quality of evidence, not quantity of evidence. That is sufficient for me for the conviction, Lordship. But he does not name me, Lord. PW1, Lord. He is injured witness and eyewitness also, Lord. इनके साथ घटना घटती है. He specifically named the Satish Kumar and Ardhir Kumar. इन्हीं के एविडेंस में लॉर्डशिप, one paragraph is very important, that is paragraph 5 regarding the deposition of PW2. इन्होंने कहा है पैराग्राफ 5 पे, हुजूर, ग्रामीण मिथिलेश कुमार से बातचीत घटना के बारे में हुई. हम कह रहे हैं हुजूर, हमारा सबमिशन है कि घटना को किसी ने देखा नहीं, नाइदर आई वाज प्रेजेंट. हमारा प्रेजेंस एट द प्लेस ऑफ अकरेंस इज वेरी वेरी डाउटफुल. इवन अब PW2 का देखा जाएगा हजूर, इनको तो PW1 से हम दिखा रहे हैं हजूर, इनको घटना के बारे में कैसे जानकारी है. ये कह रहे हैं कि 50 से 60, 30 से 40 व्यक्ति जुटकर 50 राउंड फायरिंग हुई. डेट वाज डिनाई बाय द PW10 IO लॉर्डशिप. इन्होंने इस तरह की बात हमारे सामने नहीं कहा. नाउ लॉर्डशिप, अब इनका पैरा 2 देखा जाएगा, जजमेंट में भी आया है जो PW2 का. सुमित कुमार, PW2 के बारे में जो
PW1 है, गवाही दिया है, लल्लन वीरेंद्र और वो है राजू.
इवन PW5 वो इज द वाइफ ऑफ द डिसीज, हमको पहचान नहीं कर पा रहे हैं. जो कोई हमारा TIP परेड नहीं हो रहा, सीधे कोर्ट में लोग पहचान कर रहे हैं हमारा. अब PW2 का देखा जाएगा जो इनका लोकेशन क्या है फ्रॉम द प्लेस ऑफ अक्रेंस से पैरा 2 में आया है। सुमित कुमार सूचक मेरे चचेरे चाचा हैं। इनके घर से मेरा घर 20 से 25 डेक पश्चिम तरफ है। मेरा दलान से जनानी की मकान लगभग 20 से 25 डेक दूरी पे है। दैट मीन्स ही वॉज अवे फ्रॉम द प्लेस ऑफ अक्रेंस 50 डेक की दूरी पे है। कोई सोर्स ऑफ आइडेंटिफिकेशन का कहीं भी जिक्र नहीं, कैसे हाउ ही आइडेंटिफाई रात में 50 लोगों के गैदरिंग में। फिर वो जो PW3 देखा जाएगा, ये भी मेरा नाम नहीं ले रहे हैं। PW3 भी मेरा नाम नहीं ले रहे हैं जो। PW4 के बारे में कह रहे हैं, ये घटना के बारे में नहीं जानते हैं, लेकिन लोग को वहां से जाते हुए देखे, सबका नाम ले रहे हैं जो। PW4 हुजूर घटना नहीं देखा था, बस जाते हुए देखा था। उतने बड़े मोब को जहाँ पे 60 आदमी गैदर हुए हैं रात में, ही आइडेंटिफाई द प्लान। जबकि हमारा घर दूसरे गांव में पड़ता है, दूसरा पुलिस स्टेशन है। हमारे फादर के बारे में नाम नहीं जान रहे हैं, लेकिन जाते हुए इतने मोमेंट स्टेज में आइडेंटिफाई कर रहे हैं कि हाँ। नाउ लॉर्डशिप PW5 गीता देवी, वाइफ ऑफ वन डिसीज वीरेंद्र यादव। ये हमको आइडेंटिफाई भी नहीं कर पा रही है हुजूर। तो in such circumstances where my presence is doubtful, I am convicted under section 149. You are member of unlawful assembly. Now PW6 is lordship informant. Informant के बारे में PW10 का देखा जाएगा।
इनमें से किसी की सेंटेंस सस्पेंशन हुआ है क्या?
अभी तक नहीं हुआ हुजूर, फर्स्ट टाइम हम आ रहे हैं हुजूर के सामने। एक बार थोड़ा सा PW
It has been rejected on behalf of Basmati Devi and Lalu Yadav.
Lordship, my case is of different footing. Of PW6 who is the informant of this case. इनका जो आयोग के द्वारा एग्जामिनेशन हुआ है वो क्या कह रहे हैं? पैरा 3 में हुजूर आया हुआ सुमित कुमार एम अनिल या तो भागने में सफल रहे,
भागने की कोशिश करी तो मार दिया।
PW10 कह रहे हैं हुजूर आयोग ये लोग भागने में सफल है, देयरफॉर डिड नॉट गेट एनी इंजरी। नेक्स्ट हुजूर जो फायरिंग की बात कह रहे थे PW2 कि 50 राउंड फायरिंग हुई, PW10 कह रहे कि नहीं ऐसी कोई बात हमारे सामने इन्होंने नहीं कहा था। और हुजूर दैट इज पैरा 12 में हुजूर के द्वारा पूछा गया था, बल्ब या रोशनी के बारे में जिक्र नहीं किया है। और हुजूर हमारा स्पेसिफिक केस है अंडर सेक्शन 313 में कि हम लाली यादव के, हालांकि इनको रिलेशन भी नहीं पता है जो कि हम क्या लगते हैं लाली यादव के, वो कह रहे हैं कि भगीना, लेकिन नॉट आई एम मौसेरा भाई। अंडर सेक्शन 313 में हमने कहा है कि उनके मौसेरा भाई होने के चलते आई हैव बीन इम्प्लिकेटेड इन दिस। that has also come in the evidence of PW4 Lordship, PW10. इस कांड में अन्य गांव के निवासी जो अभियुक्तों के रिश्तेदार हैं को भी अभियुक्त बनाया गया है PW10 Lordship. मेरा स्पेसिफिक एवरमेंट है अंडर सेक्शन 330. Since I was relative of the Lali Yadav, with whom informal side has dispute on the account of opening of darwaza and land of 3 feet. और इसमें एक और चीज़ है हुजूर, सुमित कुमार के बारे में जो PW6 है, पैरा 16 में आया हुआ है, उसने ये नहीं कहा था कि सुदिष्ट को लालती और सीता यादव घसीट कर लालू के खेत में ले जाकर मारने लगे। जो जितना भी इनका एविडेंस है PW6 का, डेट इज इम्प्लेसमेंट बढ़ा चढ़ा कर कोर्ट के सामने कह रहे हैं, that was not supported by the PW10. और जो घटना का जो कारण है 3 फीट जमीन, ओपनिंग ऑफ द दरवाजा, हम अपने आप से क्वेश्चन कर रहे हैं क्या इतना बड़ा वो बोन ऑफ कंटेंशन की इतने लोगों की जरूरत पड़ जाएगी? और दरवाजा खोलकर झांकर जो रात में विदाउट एनी सोर्स ऑफ लाइट टू आइडेंटिफाई 25%, अगर हम उसी गांव के रहते तब तो भाई चलो कोई बात नहीं, उस गांव के हैं, आपको पहचानने में कोई परेशानी नहीं हो रही है, लेकिन आई एम ऑफ अनदर विलेज, अनदर PS, क्यों हमको एक्यूज बनाया जा रहा है भाई ऑन अकाउंट ऑफ रिलेटिव ऑफ द लाली यादव? हजूर एक 149 पे ऑनरेबल सीपी साहब का एक जजमेंट है हजूर, 149 कब अप्लीकेबल होगा उसे लॉर्डशिप को तो पूरी जानकारी है, बताने की जरूरत
नहीं, बताइए ना आप पूरा।
हम फैक्ट हजूर के सामने रख दे रहे हैं, बाकी डेट इज पैरा 15 हम उस गांव के रहते हुजूर तो बात कुछ अलग होती। अगर PW1 मेरा नाम ले लेता तब किसी और विटनेस की जरूरत थी ही नहीं हुजूर।
That's all?
वही कह रहा हूँ जो कि अगर PW1 भी अगर मेरा नाम ले लिया जाता, that there was no need of any corroborative evidence of the, but he did not name my कॉमन ऑब्जेक्ट के ऊपर हुजूर देखा जाए पूरा इंटायर एविडेंस PW1 to लेकर 6 तक किसी का नहीं आया कि हाँ ये कॉमन ऑब्जेक्ट क्या था, फॉर विच पर्पज कोई TIP परेड नहीं हुआ है हुजूर, कोई कंस्पिरेसी की भी बात नहीं आ रही है। हम हुजूर कस्टडी में हैं 25/12/2017 से, ओनली एट बेसिस ऑफ द, अगर मान भी लिया जाए जो 149, वो कोई ओवरटेक नहीं, कोई हमारे हाथ में कोई आर्म्स नहीं है। इन सच सर्कमस्टांसेस कन्विक्शन अंडर सेक्शन 149 रिड्यूस्ड सेक्शन दैट जो भी जजमेंट फैक्ट एविडेंस हुजूर के सामने हमने इलाबोरेट किया, दैट वाज नॉट कंसिडर्ड बाय द लर्नेड ट्रायल कोर्ट, देयरफॉर माय सबमिशन इज जजमेंट इज परवर्स, not supported with the evidence, और जो 3 आदमी का जो एक्विटल किया गया है, 2 आदमी का, वो दूसरे गांव के हैं। उनका इसलिए कि हाँ FIR में उनका नाम नहीं है। 1 आदमी का जो एक्विटल किया गया है FIR में नाम है, लेकिन उन पर कोई ओवरटेक नहीं है। That should be priority with that person. I was entitled to benefit of the doubt, Lord. Bibha Kumari, Lord.
Yes. Okay. Please. Do you have to say anything?
Lord, I am appearing on behalf of the informant. If permitted, my Lord, I will assist the court.
Yes, yes.
My Lord, at the foremost, 2 co-convicts had made an application for suspension of sentence, and their application has been dismissed by this honorable court. I may be permitted to share a copy of.
Yes.
Vishkar sir. 2 seconds.
All these are the same village, Lordship.
Now,
all
Lordship.
these persons are of same village.
Now, Lordship, it would be important to appreciate the situation in which the FIR has been lodged. At dead hours of the night, multiple persons enter the house of the informant. It is a joint house in which PW 4 and 5 has specifically named this appellant as one of the assailants, one of the persons who entered the house and dragged few people, in which 3 of them were murdered outside the house, one on the road, another one in the agricultural fields, and my Lord, 2 others were injured. My Lord would also be pleased to appreciate the kind of injuries sustained by the deceased. Multiple injuries, my Lord. It has come in para 13 onwards.
Any of the witness alleging any overt act on his part?
Lord, petitioner, witness number 4 and 5.
Yes, come to that. Where do they say and what do they say?
I shall, my Lord, refer directly to the statement or in the judgment. Should I?
Come from the judgment.
Judgment,
From
my
the
Lord.
statement. Sorry.
My Lord.
What does PW4 say?
घटना से लगभग 7 महीना पहले
Come to that part where he says about the overt act of this person.
He says that मैं भी हल्ला करते हुए सहदेव यादव के घर के पास पहुंचा, देखा गेहूं लल्ली यादव, गेहूंवन यादव, लाल यादव, लाली यादव का 2 बेटा जिसका नाम छापित है तथा दूसरे का नाम नहीं जानता हूं, बुघारू यादव जो गेहूंवन का बेटा, 3 लाल यादव का बेटा, दयानंद यादव, रट्टू यादव, सीता यादव, द एप्लेंट मिलॉर्ड, गेहूंवन यादव का 2 साला, लाली यादव का 3 भगिना, केनवा देवी, बसमतिया देवी घटनास्थल से घर जा रहे थे। मारपीट की घटना मैंने नहीं देखा था। So while returning from the place of occurrence, the appellant was seen by PW4 Miller. PW5 Miller. He states, पैरा 1 of PW5.
Yes, yes.
घटना 8 महीने पहले आधी रात की है. मैं अपने पति के साथ सोई हुई थी. कुत्ता भौंकने की आवाज़ पर मेरी नींद टूट गई. मैंने लाली यादव, गांधी यादव and my lord, in fifth line towards the end she says Hulas Yadav, Dayanand Yadav and Sita Yadav, the appellant, गाली देते हुए मेरे घर में घुस गए तथा मेरे पति को मारने पीटने लगे. So his presence at the place of occurrence at dead hours of the night has been identified by PW4 and 5. Now, my lord,
Birendra Yadav is a
para 2,
husband of this witness.
Para 2 in the cross examination, PW5 states अभियुक्त सीता यादव, हुलास यादव तथा दयानंद यादव मेरे गांव के रहने वाले हैं, इसलिए पहचानती हूँ. She answers a specific question about this appellant in para 2 of her cross examination. Now, my lord, in the given circumstances, multiple injuries more than 10 and 15 and brutally assaulted, my lord, having multiple fractures of more than 7 or 8 in number as to one accused, my lord. There may be a possibility that under such circumstances, having so many numbers of accused persons, there would be a minor variation with respect to the eyewitnesses. But the fact remains is that 3 people have been assaulted, right from dragging them from their house and then taking them to the roadside and to the agricultural fields, where one dead body was recovered from the agricultural field, another from the roadside. And the kind of injuries that they have received, my lord, whereby the appellant's presence by entering into the house has been identified by PW5. At times, my lord, I may to some extent say that the persons who are getting assaulted might not know that who all assaulted him, the kind of injuries that has been received, my lord. It is referred in, my lord, para 14 of the impugned judgment. A lacerated wound over right leg 7 centimeter, my lord. Multiple fractures, lacerated wound over left 4 centimeter, fractures, my lord, altogether. And 3 of them have died because of these multiple injuries. And the reason for death has been described as, my lord, head injury and limb injury, my lord. The kind of fractures on limbs and body, elbows, all broken, my lord.
The statement then, you have the statement.
Lordship.
घर में कुछ और मारा, गले में मारा, घर में घुसने के बाद तो तीनों कहता है, वो फॉर्मेट पे कह रहा है, घर में घुसा.
Lordship, PW2 in para 2, he did not identify me, Lord. The person who failed to identify 25 लोगों का नाम, मेरा नाम नहीं, कहीं भी ओवरटेक हुजूर के द्वारा जो कार्य किया गया, कोई ओवरटेक है कि नहीं? That has never came in any deposition of the any witness, Lord. पैरा 2 में खुद नहीं आइडेंटिफाई कर पा रही है.
What have you handed over?
My
ये statements तो कोर्ट के statements हैं.
What statements have been PW statement? PW 4 and 5. 4, 3 and 4.
Witness
4 and 5 चाहिए. 4 and 5 गीता देवी का statement. Mal. They are in the different.
Yes.
यादव छोटू यादव गाली देते हुए घुस गए और यहाँ पे दयानंद प्लस रघु एक कुली मेरे जिम्मेदारी देते हुए मैं खुश गया और तथा मेरे पति को मारे तब मेरे पति को गांधी याद है यही याद है याद है कुछ कर लेगा ठीक है याद है छत्तीसगढ़ कर लिया मेरे पति को गांधी कर लिया तो ये भी लोग मार्केट मेरे पति को गांधी आ जाए गांधी देखा गाली दिया नहीं overtake me.
In para 2, he failed to identify lots.
General
Yes, what do you have to say?
Yes, Lord.
One more aspect, my lord, may I add that in 2022 last year, few of the accused persons have again murdered one of the family members of this informant, my lord. Last year. I have received a copy, but it is not legible, my lord. But I have requested for obtaining a certified copy.
Those who were
one of them co-accused, not
from them, they have not been released on bail. Anyone?
This trial is only with respect to 7 accused persons, my lord. There are other co-accused persons: Satish Kumar, Randhir Kumar, Madhir Kumar.
They were absconding,
my lord. And this FIR of the last year, it states that one of the family members, relatives of this informant, has been done to death in relation to the session trial which was happening. And one bodyguard has also been given to the family because of this last year's incident. I'll share a certified copy of this FIR. I have requested. It is a
that is
copy.
All right. Your statement is there. Yes.
Yes, but considering the gravity of the offence, Lordship, and the statement given by the informant in his first information report as well as before the court during trial, Lordship, not a single accused, Lordship, convict has been granted bail by the Supreme Court, Lordship. Even the ladies inmates who participated in the offence, they have also not been granted bail, privilege of bail, or suspension of sentence and grant of bail, Lordship. But 3 persons have lost their life. Some of them got serious injuries in this incident, Lordship. How they brutally dragged the victims from their house, Lordship, and done to death at the hands of the accused. Of course, the specific role has not been assigned to this very appellant that what overt act he has done. But simply forming the member of that very assembly, Lordship, that is enough. And one of the accused is admitting in 313, Lordship, that yes, my so-and-so has got enmity, that is why this occurrence took place, Lordship. The genesis of occurrence is land dispute. Admitted position is, Lordship.
दिखाएं और कुछ बोलना है?
Lordship, as for evidence of PW5, Lordship, in paragraph 2 of our evidence, he failed to identify me, Lordship. And of course, Lordship, there is 3 murder. But what is my role, Lordship? What evidence came against me? Except I am Bhagna of a even relationship, we did know the informant. In taking to totality of the evidence, Lordship, it totally creates doubt regarding my presence at the place of occurrence. No verdict has been assigned any role. No source of light.
All. This is a sentence suspension application moved by the accused petitioner Sita Yadav, seeking bail in case where he has been convicted under section 302 149, 307 149 and other offences. Life
with 5,000 rupees.
Imprisonment and fine of 5,000 rupees. Legal counsel appearing for the petitioner submits that there is no overt act assigned to the accused petitioner. There is no allegation of the allegation of causing injury to the informant is also not proved, as the informant in his statement made before the court has not stated of the petitioner having caused any injury. The presence of the accused petitioner is doubtful, as PW5 has failed to identify the petitioner.
Even PWR did not name me also. PW5 and PW1 also.
PW1 has failed to identify?
नहीं लॉर्ड, उन्होंने तो नाम ही नहीं लिया है उधर।
दिखा रहे जो तो सुनिए
तो सही बीच में काहे बोल रहे हैं?
Sorry.
As PW5 has failed to identify the petitioner in the course of trial. Legal counsel further submits that the petitioner does not belong to the same village, and it is a case of over-implication. Per contra, legal counsel appearing for the informant supports the order and submits that the presence of the accused petitioner at the time of incidence stands fully proved in view of the statement made by PW1, PW2, PW3 as well as PW5.
4, 5, 6.
4, 5, 6.
4,
5 and 6. And in a case where a huge number of assailants have attacked the informant and the other members of the family, resulting in causing death of 3 persons, it may not be possible to identify the concerned overt act of each individual. However, they are all members of unlawful assembly and were members of the assailant party who dragged persons from their house, and 3 of them died while 2 others suffered severe injuries. Legal counsel has also placed reliance on orders passed by coordinated benches refusing bail to other co-accused, namely Lali Yadav and Basmatiya Devi. Learned PP has also opposed the sender suspension application and pointed out that it is a case of committing heinous crime where the members of the accused party have waylaid the persons of a family entered in their house and murdered 3 persons. When we have considered the submissions, taking into consideration the overall circumstances and the orders passed by the coordinate bench, and also I'm officially finding that presence of accused at the time of incident, we are not inclined to grant bail to the petitioner. Application is dismissed.
Any time will. It's any time will be given.
No time. Why?
Item was 6.
Sole appeal trial. Then case number 2 IA is pending. Third IA 3 of 2023 I have filed recently for grant of provisional bail of the appellant on the ground that his mother died and Shraddh was going to be had. But now Shraddh period is over, hence I am withdrawing the IA number 3. Now I am placing IA number 2 before of 2021 before your lordship for grant of bail to the sole appellant who is husband of the deceased. 3 को हम विड्रॉ कर ले, श्राद्ध के ग्राउंड पर था, मदर मर गई थी 18। Earlier, my lord, second attempt, the prayer for bail of this appellant was rejected by this honorable court on 24/9/19 with an observation regarding being had to the above stated facts and circumstances as well as submission of the parties, we are not inclined to release the appellant on bail, and accordingly his prayer for bail stands rejected for the present. In this case, my lord, the appellant convicted under section 304B by 34 of the IPC and also 302 by 34 of the IPC. One of the 7 साल करीब हुजूर होने जा रहा है। 13/4/2023 को 7 साल हो जाएगा कस्टडी, और हुजूर के सामने हम सिर्फ with your lordship's permission, I will try to place the evidence of PW1, who is the brother, 2 is the bhabhi of the deceased, 3 is the nephew of the deceased, 4 is the mother. There is contradiction with regard to marriage of the deceased. PW page 3, मैरिज कहते हैं, पेज 3 ऑफ द जजमेंट में ही आ गया है, पेज 3. आई मे बी अलाउड टू रेफर पेज 3, और उनको 2 बच्चे भी हैं, ये भी आ गए पेज 3. माय लॉर्ड, 3rd लाइन फ्रॉम द टॉप, इज ब्रदर ऑफ द डिसीज्ड, दानापुर इन द ईयर ऑफ 2011, and this witness is the brother. Firstly, he was informed through the counselor that his sister died due to hanging in her matrimonial house. Now, my lord, page 7, मदर कहती है कि 7 साल पहले हम शादी हुई थी. पेज 7, माँ को ही ज्यादा याद रहा होगा. 5, 6 and 7. Paragraph 14. Sita Devi, mother of the deceased, in her cross-examination, chief has stated that her daughter Malti was married with Vicky appellant 7 years ago. After marriage, her daughter went to her sasural, and after information, all witnesses, all 1 to 4 are the family members, went there. The middle portion, there she saw that hands and feet of Malti Devi was wounded and went, and he was hanged in the fan by tying dupatta. Now, my lord, page 5, भाभी है ये, wife of the informant, page 5. having two issues, my lord. Middle, my lord. He and her mother Urmila went to the house of her nanad at Danapur. She saw that her nanad was hanging in fan. And information regarding her death was given by the local councillor to the informant. कि आपकी बहन ये हो गई, ये हुआ गया हो जी पेज 12 में, उसी में सारा डिटेल्स आ गया, इतना तो जाने का भी नहीं. पेज 12 में नीचे एक 13 line from the bottom. It also appears from the evidence of PW 1, 2, 3 and 4 that all are family members, that the dead body of Malki was found in her matrimonial house hanging in ceiling fan.
Yes?
जी?
Which page?
Page paragraph 12. Sorry, my lord. Page 12. Paragraph number हो गया 19. Page 12. सब लोग बोला है girl, mother, bhabi, because I am husband and there is demand of 25,000. Having two issues, there was no demand. Some altercation might have been taken place in between them, as he might have committed suicide. And because I am husband, pitiable husband, I can say, I am in custody for about 7. ये 13/4/2023 को हुजूर 7 साल हो जाएगा. And the earlier objection was rejected for the present by my lord. Now 13/4/23 को hanging का तो clear cut case है, and there was demand of 25,000. Two issues. A mother भी मर गई, one of the convict, Atwari Devi. He died. A father, he is an old person, and he is the husband. And observation is there, my lord, and now, my lord. 7 witnesses examined, 1 to 4 family members, 5 with the doctor who had conducted postmortem, page 8, 6, proof 7 is the IO. IO's contradiction, she had not taken any page 9 and 11. IO का भी कहा जाएगा तो पढ़ देंगे. Young person, 2 issues having, as per a statement of PW2, and father is in custody, now grandmother is dead. And 7, he had himself surrendered on 13/4/16. That's 13/4/23 को हो जाएगा हुजूर 7 साल. And earlier observation, your lordships, was rejected for the present.
Yes.
Well, Lord, the appellant happens to be the husband of the deceased victim, Lord.
You have the record with you?
My Lord, yes, Lord.
एक विटनेस नहीं करेगा उसके पैरों में बढ़ने में पैर से बढ़ने पर उसके बारे में कुछ है नहीं. ये भी नहीं आता कि कोई एडवेंचरी है नहीं.
Yes. My Lord. My Lord, as per the informant, Lordship, the marriage was solemnized 3-4 years ago from the date of occurrence, Lordship. The victim died in unnatural circumstances in her matrimonial home, Lordship. And there is an allegation of demand of dowry. So soon before her death, it is said that the accused persons were demanding dowry, and since he failed to fulfill their demands, my sister was done to death. And the moment, Lordship, the informant reached there, he found her sister hanging with the rope, but her feet were touching earth, Lordship. It shows that she was hanged after killing, Lordship.
What does your medical report say?
Medical report, Lordship, as per doctor, Lordship.
ये आपने हमें तो नहीं दिया अभी मेडिकल रिपोर्ट नहीं दिया आपने.
My lord, page 8 of the judgment, Lordship, kindly have a look.
Postmortem report.
Yes, postmortem report has been dealt in the judgment itself.
आप दिखाइए ना.
My lord, the original record is with him, with my lord.
देखिए, उसमें तो मिली नहीं हमें.
I am placing from the judgment, Lordship, that is.
देख लो postmortem report. ये मिस हो गया. आपके पास बाकी रिकॉर्ड आपके पास?
यस.
दीजिएगा. एक्सपेक्ट उसमें
जिसकी the rest of the records only case diary and the day-to-day appearance slip. Okay.
डॉक्टर्स रिपोर्ट है वो डॉक्टर
मैडम सॉरी हियर.
हाँ वही तो.
Opinion for
I would think.
It has to come also. There have been two. You say about the legs touching the bed.
My lord, it is in the statement of
the IO. Has he said so? He wanted to know because there is one statement of one person saying that her legs were bound.
The informant says that when I reached, I found my sister hanging, touching her feet in the earth.
And her legs were also bound.
Yes.
आया है किसी का स्टेटमेंट? आयु का क्या है?
आयु नहीं.
Women hanging with dupatta in the hook.
That is there. Ayu does not say.
He found a woman hanging by dupatta in the hook ceiling fan.
But someone has said that her legs were touching the palm. Oh, her hands and feet of Mati Devi were wounded. And she was.
But there is no such mention in the postmortem report about her hands and feet. Balki there is no mention about the entire other part of the body. What is the condition? I don't know how your postmortem reports are prepared here. They should express about each and every part of the body what it is, what is the condition. Or they should say that there is no mark in any other part of the body. कुछ कहा ही नहीं है और ये डॉक्टर कैसे कह देगा it is by hanging.
In the opinion, he said like that. The opinion cause of death is asphyxia leading to cardiorespiratory arrest as a result of hanging caused by soft ligature.
Soft ligature से कब से होती है?
And ligature mark was found as injury number 1 mentioned. The ligature mark was found under line tissue, looks white and blistering. Left corn of thyroid bone was found fractured.
PW1 का है.
PW1 केस में है.
PW5 है डॉक्टर.
One का है.
One is the page 3 of the judgment.
Leg was touching palang. And it was a
IO does not say so.
No, Lord.
Has he prepared a site plan or something?
My Lord, inquest prepared, but page 9 of the judgment I have gone through. He says like this, Lord, that then he reached the Regular Road within so at Gajadhar Check in the upper room of double-storied house of Uday Shankar Rai. He found a woman hanging by dupatta in the hook of ceiling fan. But this much is. This information was given to the officer in charge. But
the inquest report, it has come. कमरे में कड़ी से लटका हुआ
जी
पैर करीब पलंग के बेड में सटा एवं रंग गोरा. दोनों पैर करीब पलंग के बेड में सटा हुआ, रंग गोरा और आंख खुला हुआ, काला जीभ बाहर.
सटा हुआ, बेड में सटा हुआ.
रंग गोरा, आंख खुला हुआ,
काला जीभ बाहर.
जीभ निकला हुआ.
Post-mortem says that the mouth is closed. Mouth is closed.
दाहिना मुट्ठी
बंधा हुआ,
बाल काला.
क्या है?
नारंगी सफेद छीटेदार साड़ी, दोनों हाथ में चूड़ी पहने हुए, नाक में सोना जैसा लौंग, पलंग पर बिछावन बिछा हुआ और साड़ी के कलर का ही ब्लाउज पहने हुए. फांसी लगाने के कारण मृत्यु प्रतीत होता है. She seems to have committed suicide. He was not ready. But it is 304B presumption system told that he is. And there is a demand of dowry. Statement dowry की demand है तो How much time you are in jail?
My lord, I am in custody since 13/4/16. On 13/4/23 को 7 साल हो जाएगा. 13/4 after 2 months. दो बच्चे हैं बाहर. नाउ ग्रैंड मदर इज नो मोर. ग्रैंडफादर इज ए नोन पर्सन. Himself surrendered on 13/4/16.
What is your statement under 313? What is your defense?
I had denied and case was of.
What do you say why she died?
She died due to committing suicide, my lord. 313 case.
But why she died? She was under depression. What have you said?
Depression copy. I don't have that copy. 313 वाला मुझे देखे नहीं. I'm sorry, extremely very sorry, my lord.
ये भी दीजिए उधर दीजिए. वो भी उधर ये तो
हाँ बड़ा वही बड़ा. देखिए प्रश्न गवाहन का बयान है कि आप 16 को अन्य भुक्तों के साथ मिलकर एक मत होकर गजाधर चकटोला दानापुर जिला पटना में पंकज कुमार की बहन मालती देवी की दहेज के लिए हत्या कर 100 को पंखा में लटका दिया. ही डिनाइड. जी नहीं, सफाई में कुछ कहना है. आई एम इनोसेंट. दिस द स्टेटमेंट.
चल
And earlier rejected for the present, my lord. Earlier, my lord, saw the was.
This is the second bail application. Earlier bail application was dismissed by this court. By the order dated
24/9/19.
24/9/2019. Learned Counsel has submits that the petitioner is in jail for almost 7 years now, and he has also taken this court to the evidence which has come on record to submit that the deceased has committed suicide, simpliciter, and there is no sufficient proof to allege the petitioner to have committed
murder of his wife or to have initiated in her committing suicide. And therefore, prima facie he has not committed offence under 304B or under 302, 34. We have considered the submission and perused the record and the statements which have come on record. This court finds that apart from there being statement of PW1, a brother of the deceased, who specifically alleges of there being demand of dowry and harassment to his sister before death, it is also noticed that in the post-mortem report, the deceased is shown to have mouth closed and eyes closed. Which suggests of her being killed. Without going further into merits of the case, we are not inclined to release the petitioner on bail.
Next case is not for provisional.
For the present, almost 7 years.
It is for next case is for provisional bail on the ground of marriage of the daughter and sister.
When is she getting married?
On 9th, no, the marriage is on 6th. It is tilak and 9th is the marriage.
क्या सिस्टम है?
Has it been verified? कब है? 9th को है?
शादी 9th को, तिलक 6th को.
तो वेरिफिकेशन के बाद तो कैसे वेरीफाई तो करेंगे आपके जो स्टेटमेंट है उसको.
स्पेशल आइए पिटीशन पेंडिंग रहेगा.
3 केस में वेरीफाई किया. एक में आया कि वाइफ भी बीमार है,
हाँ
रिपोर्ट आया कि शादी नहीं है. दूसरे में आया
9th को है ना शादी, 8 को रखा देते हैं.
6 को तिलक है तो
तिलक तो हो जाएगा. जब आपने इतना करवा लिया बिना आपके तो ये भी हो जाएगा.
नहीं, इसमें दोनों के लिए हमने किया.
PP to verify and submit verification report before the next date. List again on 8th. उससे पहले तो बेंच बनेगी नहीं.
फिर निकलेगा ही नहीं. होगा कहीं भागलपुर जेल में या दूसरे जेल में, तब तक वहां से वहां जाएगा. नहीं, इसमें हमने
यहाँ डायरेक्ट बेल से नहीं जाता है.
नहीं, कोर्ट में जाता है.
तो बेंच कैसे
जेल में जाता है.
स्पेशल बेंच होगा.
स्पेशल बेंच है ना.
तो कोर्ट बिलो ही वेरीफाई करके अपना देखेंगे तो प्रोविजनली रिलीज कर देंगे. नहीं देखेंगे तो फिर कोर्ट बिलो ही वेरीफाई कर लेंगे.
वैसा कोई प्रेसिडेंशियल कोई ऑर्डर है आपके पास? पहले कभी यहाँ कोर्ट ने ऐसा करा हो?
तो वेरिफिकेशन वाला भी जो इधर ही शुरू हुआ, चूंकि कुछ लोग भाग गए.
हाँ, ये
कुछ लोग भाग ही नहीं गए.
The main purpose is to verify कि marriage है कि नहीं by any agency. If the learned court below verifies that कि अगर
we agree with you.
मेरा 3 केस का एक्सपीरियंस है कि तीनों में ये फॉल्स पाया गया. एक में था कि मेरी वाइफ बीमार है, हुआ कि शादी नहीं हुआ.
में तो भाग गया, उसकी शादी ही नहीं हुई थी और कहा कि बेटी की शादी है.
चलिए 8 तारीख को रख ही लीजिए. देखिए अगर करना होगा तो फिर डायरेक्शन देंगे उसी दिन.